Yes.
Application.
My lord, may kindly permit me to mention one matter. My lord, this matter is pending for execution in civil court. My lord,
It's an application.
my lord, if
Hello. Yes.
my lord, may kindly keep it tomorrow. Otherwise, my lord, Saturday is the date fixed for.
If the file comes today, it will appear tomorrow. Yes.
Grateful, my lord.
Order 41.
Both. Yes. Call on the list.
Your Honor, Order 41, Rule 11.
Yes.
Watch it.
It's a longish ordering portion here. Accordingly, FMA number 195 of 2025 is partially allowed, thereby modifying the impugned judgment and order dated such and such to the following effect. We have given parawise. A copy of this order shall be forwarded to the CWC District North 24 Parganas at the earliest by special messenger at the cost of the appellant, to be deposited within a week. The concerned CWC shall thereafter commence an inquiry under Section 36 of the JJ Act at the earliest. While doing so, the CWC shall ascertain prima facie whether the appellant is a fit person within the contemplation of Section 36(1), and if so, she may be permitted to retain the custody of the children during the period of inquiry by the CWC. Upon the conclusion of such inquiry, in the event the CWC is of the opinion that the children can be placed with the appellant by construing the appellant to be a fit person within the contemplation of Section 37(1)(d) of the JJ Act for long-term or temporary care, the children may be so placed under the care and custody of the appellant. If not, the CWC will consider whether the appellant is entitled to foster care orders in her favor vis-a-vis the children as envisaged under Section 37(1)(e) read with Section 44 of the JJ Act. In the event such option is also not considered feasible, the CWC shall consider granting sponsorship orders under Section 37(1)(f) read with Section 45 in favor of the appellant. The above chronology of options shall be explored by the CWC while undertaking such consideration. In the event it is found that any of the above options can be exercised, particularly if the children can be placed with the appellant as a fit person for a long term and or placed under her foster care for a period to be decided by the CWC shall next proceed to consider whether the children concerned are orphans having no one to take care, keeping in view particularly the circumstances under which the children are being taken care of by the appellant. In the event it is found that sufficient care of the two children in question is being taken by the appellant, in the opinion of the CWC, the children shall not be placed for adoption under Section 38 of the JJ Act, and in such event, the CWC may consider continuance of the placement of the child with the appellant as a fit person for a long term, which may extend to the attainment of their majority. It is made clear that while undertaking the above exercise, the CWC shall be guided by the principles as embodied in Section 3 of the JJ Act, and in particular Clause Roman 12 of Section 3, which mandates the placement of the children in institutional care to be the step of last resort after making such reasonable inquiry as required. It is further clarified that in the event the children are placed with the appellant as a fit person, whether for a long-term or temporary care and or under her foster care and or sponsorship, the CWC shall keep a constant monitoring over the children and their welfare under the appellant as mandated by the relevant provisions of the JJ Act. Nothing in this order shall be construed to be a direction on the CWC to mandatorily place the children with the appellant and or not to declare the children free for adoption, and the CWC shall, only upon conduct of a proper inquiry in accordance with law and in the light of the above observations, and upon giving an opportunity of hearing to the appellant, take its own decisions within the contemplation of the JJ Act, taking the above riders merely to be in the nature of guidelines while doing so. There will be no orders to cost. Can such and such are accordingly disposed of as well.
Much obliged.
We could not bend the law further in the children's favor, actually.
Much obliged.
Accordingly, can 1 of 2024 is allowed on contest, thereby directing the respondent wife to pay alimony pendentility to the appellant wife to the directly respondent husband.
I was a little shocked, but
Yes. Respondent husband to pay alimony pendentility to the appellant wife to the tune of rupees 3,60,000 per month till the disposal of the appeal. We have calculated midway between 1/5 and 1/3. per month till the disposal of the appeal, and one-time ad hoc litigation costs of rupees 5 lakh for the present. Such alimony shall be paid from the date of filing of the application, that is from the month of September 2024. Current alimony starting from the month of April 2025 shall be paid by the 15th day of each current month. The arrears of alimony at the rate of 3,60,000 per month calculated from September 2024 till March 2025 shall be paid in 2 equal monthly installments. The first of such installments shall be paid by April 15, 2025 and the next by May 15, 2025. The total amount of alimony paid between September 2024 and March 2025 pursuant to the order under the Domestic Violence Act at the rate of rupees 60,000 per month shall be deducted from such arrears in making such payments. No orders to cost. And in the appeal, you have directed in view of personal appearance services dispensed with. We will put in special messenger cost with the paper books within the usual time and liberty to the parties to mention.
Grateful to it.
Yes. Mr. Bose, we, while signing the order, we found out that you handed over the envelope in the name of that respondent number 1 and all left. Now, from the order sheet, from the records, we found out that he has already died. His heirs have been substituted. So you had to serve on the substituted heirs. It was a gross error on our part also. We should have checked up. We'll have to recall this order and you have to serve again. There was a section 5 also.
Yes.
So we'll recall this order directly to serve copies of both the applications.
My mistake, my lord. The
No,
passage of
mistakes occur. We find that in the order dated April 1, 2025,
In
we-
fact, my lord, I had also served the advocate on record for the heirs of the
no,
substituted
served properly.
because the appeal was made ready as regards service by
He
the previous
refused.
order.
He refused. He
No,
said he had no
He
contact.
took and then he said he had no contact.
No contact, naturally. How could he contact?
No. Advocate on record for the
He was
substituted
never
heirs
served on the substituted heirs. Never served.
on their advocate, but I'll serve again.
We find that by the order dated April 1, 2025, we had condoned the delay in preferring the appeal and passed stay order. Push up next para. The premise of so proceeding was that the envelope carrying the copy of the applications sought to be served on the respondent number 1 had returned with the endorsement left, which we considered to be good service in view of the respondent proceeding with the execution case from the same address. However, while signing the order, we found that there was a gross error in our order inasmuch as the respondent number 1, Srimati Kanchon Chatterjee, has already met her demise and her heirs and legal representatives having been substituted, are already on record in the appeal, and as such, it is not the deceased respondent number 1, but her heirs who were to be served. Full stop. Hence, we recall the order dated April 1, 2025, and direct the appellant to serve copies of Can 1 of 2016, within bracket old Can 3447 of 2016, as well as Can 2 of 2016, old Can 5425 of 2016, on the substituted respondents and file an affidavit of service on the returnable date. Full stop. The applications shall be listed for hearing on April 28, 2025.
I'm so sorry, my lord.
No, it's
We got to, we appear
I'm
embarrassed
embarrassed.
when we
you have to file it in notes.
Yes,
Yes.
2 days extension. Could not utilize the long weekend.
Lord, if we may, with your lordship's kind leave, my lord, on Friday, lordship will be settling singly. If we can hand it up to your lordship's office.
There'll be difficulty.
Can we file it on
Maybe
Monday?
misplaced. Yes.
Monday,
Monday, my lord.
Monday we'll keep them.
Great.
I'm grateful.
On the prayer of learned council, the matter is adjourned till April 7, 2025, when it will be listed under the same heading for filing of written notes of arguments.
Very great.
Lordship appearing at my instance for correction, my lords. My lords, para 8 of my lord's order, my lord.
The order dated
11th of November. Lordship had directed
about
the
10 to 11.
respondents to take care of all the necessities, but the recording.
One minute.
Lordship, may kindly. I have a copy of the order, my lord.
No, we have to see the order itself.
এইখানে দাদা ওই সব রেসপন্ডেন্ট করে আবার অ্যাপেলেন্ট shall put in requisites বলে ডিপার্টমেন্ট শুরু করছে
11th of November, yes.
Lordship kindly sees paragraph 8.
Yes.
Lordship had recorded that the special messenger cost would be deposited by the respondent number 1. The next line is appellant shall put in the due requisite. This confusion the department's not being
No,
able to-
you respondent number 1 has to put in.
Lordship, this confusion.
Who is for the respondent number 1?
No.
So we'll direct you also to put in the special messenger costs. The requisites.
One aspect, my lord had directed that paper books might be filed by us,
Yes.
Lordship, all by them.
my lord. The respondents, my lord, till date, my lord, the problem is that, my lord, the.
No, we cannot recall on merits.
No, not on merits, not on people will give, my
No,
lord,
you'll paper the bill.
I am not being, my lord, my clients are not being able to hand me over all the.
You had sought for expedition of the appeal. That's why we had directed.
Because we got the stay order, my lords had given us the stay.
To grant us stay,
So
then
my
we
lords
can
had given them to.
appeal also.
That's why we directed you so that you want to
You
expedite the
can take
matter.
it up, my lords, if it falls from my lords.
Well, if he, my lord, if my lord pleases, my lord, then he may.
So everything will be done by them.
No, we will pay for the requisite, but if the paper book may be prepared by them. If subject to my lord's convenience and my learned friends' convenience also.
Shouldn't be an impediment, my lords.
Very well.
As my lord says.
Learned counsel for the appellant points out that in the order dated November 11, 2024, comma, in paragraph number 8 of the order, comma, we had erroneously recorded that the appellant shall put in due requisites, whereas it should be read as respondent number 1 shall put in due requisites within a week from that date. For sub next para, let such error, let such correction be deemed to stand incorporated in the said order. Full stop, the respondent number 1 is given a further week's time for putting in the requisites. Full stop, learned counsel for the respondents submits, respondent number 1 submits that the appellant may be directed to prepare and file the requisite number of paper books, to which learned counsel for the appellant has no objection as such. Full stop, accordingly, paragraph number 9 of the said order stands modified to the effect that the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the lower court record of the trial court records on the learned advocate for the appellant. Full stop. Let this order be deemed to be a part of the order dated November 11, 2022.
I'm grateful. Grateful, Lord.
Item number 6, I appear for the appellant, my lord. My lord, kindly peruses the office report once. My lord, what happened is the erstwhile advocate, Miss Monica Sinha, who has, she married and left and settled abroad, my lord. My lord, I had filed a wakalatnama. In fact, we are from the same chamber of Mr. Ramdulal Manna. So, my lord, there was no formal, no objection, my lord. I have filed. I am praying that kindly accepts the wakalatnama, my lord, and regularize the wakalatnama. And the other defects, perhaps, my lord can cure it. I am the plaintiff, my lord.
No, we cannot accept that. That is beyond the law. There has to be a formal no objection.
My lord, it
Or
is
the- it-
impossible for
No,
us.
then a communication has to be given to her that the client has to communicate to her as per the code of
My
civil
lord,
procedure.
she has went abroad, my lord.
Doesn't have an address there. She's
Nothing-
floating around
My lord, nothing has
in the ocean or something.
my lord, nothing has been given to us, my lord. That is the regularity.
No, we cannot accept it. We cannot.
My lord, then, my lord,
Sorry, no. No, we cannot flout the law just like that.
my lord,
You file a proper one-page application then through the client
the client,
that you want no objection under these circumstances. We cannot flout the law like this.
my lord, as my lord directs.
There
my
are
lord,
provisions in the code of civil procedure that you can communicate to that advocate, and even if thereafter she does not give a no objection, then we can treat that. We have the right then to pass an order, but without letting her know, without any communication from her own or to her, we cannot do this. Then you have to file a proper application. We'll keep that on record and pass an order.
my lord.
Just like that, it cannot be done. And what about the originals have been taken also?
My lord, we are the plaintiffs. That has been taken by the defendants, perhaps, my lord.
Plaintiffs are the appellants.
Yes, my lord.
Defendant numbers 2 to 4. Yes, yes.
Yes, my lord.
So we'll direct them to.
Yes, my lord.
From the office report dated March 25, 2025, comma, we find that the original of certain exhibits were taken back by the learned advocate for the defendant numbers 2 to 4 and the remaining exhibits by the defendant numbers 5 to 15. Full stop. The said defendants, comma, who are the respondents herein, comma, are directed to furnish the originals of the said missing exhibits in terms of the office report dated March 25, 2025 in the department at the earliest, comma, positively within 4 weeks from date. Full stop. A copy of this order shall be communicated by the learned advocate for the appellants to somebody is appearing for them,
No, my lord, we do not to the respondents, my
to
lord.
the respondents
Lord.
directly. Full stop. Next para. Insofar as the filing of wakalatnama on behalf of the appellants is concerned, comma, you are Mr. Mukherjee.
Yes, my lord.
Mr. Shayan Mukherjee, comma, who has filed the wakalatnama on behalf of the appellants, along with Can 2 of 2024, submits that since the erstwhile learned advocate on record, Ms. Monica Sinha, has left practice and settled abroad without leaving any address, comma, no within double inverted, no objection could be obtained from her, and that Mr. Mukherjee may be permitted to conduct the appeal on behalf of the appellants. Push sub next para. However, comma, in the absence of any communication to or from the erstwhile learned advocate, comma, who is still holding power to appear for the appellants, comma, we are not inclined on oral submissions to permit the same. Full stop. However, comma, the appellant shall be at liberty to file a short application seeking to confer power on Mr. Mukherjee and state therein the circumstances under which such exceptional prayer was made. Full stop. As and when such application is filed, comma, liberty is given to the appellants to mention the same for inclusion in the list.
Lordship, appearing for the respondent.
7, yesterday we had yeah, no, sorry, 7 is a different one. Yes, 7. Why is it mentioned?
Neither mentioning nor post mentioning, no notice.
Let us see. Yes.
The deposit of messenger cost was belated. It was directed upon both the appellants and the respondent, and for the respondent, I took the pain, but it was a belated deposit. The first one was an error, there was an error. Second one, it
We
became.
don't find any office report that it has duly been communicated.
Lordship, there is one.
Office report ta kothay ekটু হ্যাঁ আপনি বার করে দিন না
5, 6 lines pages.
You are for the appellant.
I'm for the respondent.
You have deposited.
I've
Belated deposit. You're accepting that. For this, no notice. But even then, you should have given a notice.
I had
They won't know why it is appearing. All of a sudden in the morning, they find out.
my fault, but I could not.
Very well. It is submitted by learned counsel for the respondent and is evident from the office report dated January 9, 2025 that although the special messenger costs have been deposited by the respondent, but the same has been put in out of time. First up, we condone the delay in depositing the special messenger costs and accept the same. First up, the office shall take steps accordingly for to call for the records by special messenger accordingly.
Have we been directed?
Yes, Lordship.
Respondent was directed.
16. We
That is the
grant
previous.
liberty to the council representing appellant as well as respondent.
You have put in, so no difficult. Appellant, we directed.
No.
Some-
Justice Prasad. Justice Prasad. Because
Yes.
they say that they will do it. We are cunning.
Lordship, we will take the
They
pain.
say.
We will take the pain.
See if they have done this. Next. We have put it as to be mentioned because although we gave you the impression that we will retain you on record, your client on record, but the other person will also be there, the added person. But while passing the order, we did not specifically indicate that we are going to pass that order. So we have put it to put you on notice that we have passed that order only. We dictated in open court that it was allowed, setting aside the order. But that was an error on our part. So we retain the order. We have signed it correctly. We have stated that the appeal is partially allowed, setting aside the impugned order to the extent that the name of the appellant was also expunged from the array of parties. Appellant shall continue to be a party to the suit along with the added party, stroke alleged transferee. subject to the outcome of the present suit and the other suit filed by the appellant challenging the purported transfer in favor of the added person. So just to put it on record, formally একটা record করে no further order will be passed. But you won't be having notice, subsequently you discover and the judge has duped you. Yes. Next. Yes.
Appellant petition. The section 5 application 368 days delay, my lord.
How many?
360.
What is the explanation given?
The explanation is, my lord, order was suit was dismissed, my lord,
Yes.
on 12th November 2018. But subsequently, as and when I came to know the same,
Illness of clerk's mother, Mr. Rai. Credible. If our clerks are not there, we would be handicapped.
but ultimately I changed the clerk and
Change the clerk for this matter, then we will not allow it.
No, my lord. He did not apply. Ultimately, we came to know that he did not apply for the certified copy.
He did that for other matters also. Why did you change the clerk? Anyway, you are
Ultimately, on 31st, I applied.
appearing for all the respondents, Mr. Rai?
Yes.
Good. Heard learned counsel for the parties, full stop. In view of sufficient explanation for the delay in preferring the appeal having been made out in the application, comma, we allow can 1 of 2020 within bracket old number can 2014 of 2020, comma, thereby condoning the delay in preferring FAT 81 of 2020. Full stop. The appeal be deemed to stand admitted and registered. Is there any other application? No.
No.
So we'll direct paper books and all.
You must kindly kept that.
Yes, in view of appearance of the respondents through their learned advocate, comma, service of notice of the appeal on the respondents is dispensed with. Use of the trial court record shall be called by special messenger at the cost of the appellant to be deposited within a week from date.
Yes.
Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Stop. Liberty to the parties to mention for enlistment as and when the appeal is ready for hearing.
I'm grateful.
Thank you.
Separate. But there are three application matters, one matter for substitution, another is for a stay, and another for condonation of delay, my lord.
Substitution will take up first. Substitution is
Defective, my lord.
that is reject.
Because defective. Because
Oh, that's,
no,
Why?
Alimony Banerjee died,
yes.
leaving behind mother and two brothers, unmarried. Now, Lord, mother, Sabitri, they want to incorporate substitute in place of the deceased. Now, she has also expired. First, secondly, two brothers have not been incorporated.
Let us find out that application.
We have already carried out the amendment in the executing code, so they are aware of the fact.
Oh, you file a supplementary affidavit, right? Mr. Banerjee, please help your learned friend.
They have to ask for setting aside
Condonation.
abatement
Yes,
also.
yes,
Because
yes.
in this also there is no prayer for setting aside abatement.
They have sought for substitution of only the mother who has already died.
Mother has died.
We take up Can 2 of 2022, which is an application for substitution of the alleged heirs and legal representatives of the deceased respondent stroke claimant. Which is next para. However, learned counsel appearing for the respondent points out, you are for the respondents. Respondents points out that the person sought to be substituted has also met her demise in the meantime, and two other heirs of the deceased original respondent have not been sought to be implemented. Which of next para, on the prayer of learned counsel for the appellant, comma, leave is granted to the appellant to file a supplementary affidavit to the substitution application within a fortnight from date, upon giving an advance copy of the same to the learned advocate for the respondents. Which of next para, the applications shall next be listed on April 21, 2025.
Which will intimate the names and particulars so that they can.
I think that we think that will be
So
better.
it is with them in the
No,
executing
yes.
shall be
No. Again, another supplementary affidavit, the matter will be delayed. on.
some more time of the court.
Thank you.
Leaving, my lord, I am holding the brief of Mr. Manish Kumar Das, my lord. This is
You
an
are? Sorry?
I am holding the brief of Mr. Manish Kumar Das.
In this matter, I am for the
My lord,
respondent number 1.
My lord, this is an application for appropriate order, my lord, to withdraw the appeal. My lord,
Withdraw
what's
the-
happened?
Achha.
Yes, my lord. What's happened, my lord? During pendency of this appeal, my lord, compromise petition has been filed before the learned court.
Compromise petition?
Yes.
What is this matter arising out of?
Partition suit in preliminary.
So compromise petition has been, you want to withdraw, we'll record that
Yes, ma'am.
compromise petition has been filed and he wants to withdraw
And
without liberty to file because there is no question. And
compromise petition has been already been filed, my lord. Has already been filed.
in the trial court?
No, yes, my lord, trial court.
Yes, very good.
Actually,
That
my
is-
lord,
that
while
is
the
annexed.
appeal was at,
My learned friend's client signed in the compromise petition also.
my lord, while the, my lord, this appeal was taken up, the honorable court directed, my lord,
Not to proceed.
the commissioner to be upon,
Three is
probably-
pending, my lord.
One has been disposed of.
yes, it is for.
What was one?
They have annexed it. Your lordship kindly come page 10,
Can one?
can one.
No, we have filed a proper application for, oh, this. Can 3 is this application
Yes, my lord.
for withdrawal? Acha, acha.
Present application.
Can 1 was disposed of when? Can 1 is 4373.
My lord, that is probably.
That was an application for necessary order that was.
Can one to yes, my
Changing nature character was the prayer. Was it moved ever? How are you saying it has been disposed of?
no, actually. Your lordship kindly see the order dated 30.
We'll just check up.
13 pending.
No ad interim order was granted. That application is still pending.
Let
Can-
put the
Can
application.
3 of 2024 is an application substantially for withdrawal of the appeal on the ground that the parties have already filed a compromise petition in the court below in connection with the partition suit comma against the preliminary decree passed in which the present appeal has been preferred. Who's up next para? Upon hearing learned counsel, we accordingly allow can 3 of 2024 without any orders to cost, comma, thereby dismissing FA 32 of 2021 along with can 1 of 2018 within bracket old number can 4373 of 2018 as withdrawn without any orders to cost.
And my lord, department be directed to send the.
The department shall send down the records to the trial court at the earliest. Would you like to put in costs for that? At the earliest.
Yes.
Stop. Yes or no? No. Very well. Next.
Tomorrow appellant.
Yes, my lord.
তাড়াতাড়ি যাও।
To pass our order. Department will send down whenever. Yes. Yes.
Develop.
My lord, I appear on behalf of the appellant.
Appellant.
I'm hearing for the respondent.
Respondent. Right.
There was direction for filing the opposition.
Right.
Right.
You have given a copy?
No, no, they are not served.
Pardon?
Yes, sir.
That's not been served.
Opposition, sir, but the reply has been given from their end.
Against the handwriting export.
Yes, madam. That is can report.
Yes,
And this
yes.
is the evidence of service that we have served.
Learned junior says, well, it does not be served. My lord,
This is the evidence of service. The opposition
This is only against can 4.
gets that. And this is our opposition.
I do not know. I don't have a copy.
Reply copy has been given, she's saying.
My lord,
Well,
but handwritten, it's an evidence of service.
No, no, maybe, my lord.
So we are believing you fully.
I don't.
Show him the reply copy.
My
I
lord,
shall.
That
I
will
shall
convince
visit-
Mr. Ghosh's junior.
well, I shall be, ঠিক আছে রে, আমাকে একটা copy দেবেন পরে, হ্যাঁ?
So would you like to use that reply? Or
My lord, it has to be, because, my lord, I tell you, lordship, what is the matter about, my lord? This is a food for
makes a
declaration.
change brief or something? He's laughing, but he doesn't know whether he has served.
My lord, yes, it will not be the change bill, my lord. He is the advocate record from the inception, my lord. Thereafter,
He doesn't know whether a reply has been drafted or served.
at night, my lord, I asked him whether any affidavit has been given, my lord. He told me that no.
Now he recollects.
I do not know. But let me have a copy of this application.
He's like stuck to you with an adhesive. But we have to see his face also.
Well, I tell you, lordship, my lord, what is the matter about, my lord? This is a suit.
Mr. Ghosh, whatever the suit may be for, either you want to use an affidavit in reply
Well,
or not. If you don't, we proceed with the whatever.
I
Is,
want to do the reply.
then you have to use a new reply.
Oh, reply is given.
That is what we are saying from the beginning. That is why we asked her to show that to you so that your learned junior is convinced.
Well, may I check it up and I come back? I check it up.
Affidavits in opposition to Can 4 of 2023 and affidavit of service to that effect, comma, filed in court today, comma, be kept on record. Full stop. Learned counsel for the petitioner submits that there is a communication gap between the learned advocate on record for the appellant and him, and as such wants an adjournment on such count to ascertain whether an affidavit of service affidavit in reply will be used.
Yes, my lord. I got it. I got it, my lord.
You have got the original reply, but you have not read it.
No, no, I was not aware, my lord, this application was given to me.
যা বললাম তাই থাক। Accordingly, let the matter stand adjourned for the day. We are adjourning it till tomorrow. You file it on the next day, since you have recorded that you are not sure.
Yes, my lord, I come back.
My lord, item number 13, my lord.
Yes.
My lord, this is a review application from the order passed by Honorable Justice Jyotirmoy Bhattacharya and Honorable Justice Ishan Chandra Das. Well,
How many
perhaps,
days after their retirement did you file this application?
no, my lord, in 2022, my lord.
Just
So,
after their
my lord,
retirement.
but the order was of 2016, I have found.
Then it's
My
okay.
lord, perhaps, my lord, the
There should be a section
determination.
5. There should be a section 5 then.
Yes, but the determination, I believe, with Honorable the bench presided by Honorable Justice Bharadwaj.
Oh, acha.
My lord,
matter
last
pertains
week
to
the
what?
determination has come out.
Your lordship, on the last occasion,
in-
passed an order.
That is, my lord,
My Lane Junior appeared.
due
Your
to my
lordship,
fault, because at their behest the matter was mentioned, but we didn't
This
appear.
order was passed under what provision? At what stage of the? This is a second appeal. in
Second.
Yes, my lord.
So,
Second appeal, second review from second order passed in second appeal.
second appeal order was passed under order 41 rule 11 or what?
Yes.
Dismissing the appeal.
Yes, my
Yes.
lord. Thereafter, a review has been
Why
filed.
does why do you say Justice Bharadwaj had determination? We don't.
My
have
lord,
to-
last week's the determination has come out. I have
I
seen,
do
my lord.
not know. I am.
Little embarrassed, my lord, but I can
No
ensure.
question of embarrassment. If you don't have determination, why should
My
you
lord,
take it? Would be.
it is from the my mobile phone. It
What
has,
does your mobile phone say? What is the
Well-
determination of Justice Bharadwaj?
my lord, in case of any retirement of transfer of any judge,
Acha.
Justice Bharadwaj and Honorable Justice Ritobrata Kumar Mitra, that bench, my lord.
Let us just check up.
My lord, kindly.
Justice Bharadwaj will be, yes, just after us.
In monthly list, in last week's determination.
This list
month-
also it should be.
আমি ডিটারমিনেশনের কপিটা নাই ভাই এরকম এনে এরপর যদি কোর্ট কিছু বলে বলে কোর্ট
But today's list says
but today's list
partial modification, one to the roster determination, and appeals from order relating to labor under Group 3,
that
public interest, and
but the
admission.
last week the determination has changed, my lord. On that determination, but I have personally seen. If your lordship kindly see it,
Today's determination. The determination is
earlier
regular.
it was with the bench.
Whatever today, we are concerned with today. Earlier, whatever happened.
Well-
You don't have a list, cause list, physically.
আচ্ছা ডিটারমিনেশনটা লাস্ট উইকের ডিটারমিনেশনটা আছে
There was a change in the roster probably. Change took place on 2nd of
but
April.
that remains with a particular judge, that for a consecutive period that remains with a particular judge, irrespective of what determination comes, what determination go.
এটা তো ওনাকে দাও তো চেক আপ জাস্টিস ভরদ্বাজ
Last week.
ওরা আবার ফেরত নিয়ে নিও
But that I had seen, my lord, yesterday, my lord.
and order 41 determination is still with us and connected application.
Yes, my lord, but in respect of
Move the matter.
Acha,
What is
acha,
the
acha.
matter?
yes, my lord, I am
Yes.
grateful to my learned friend, my lord.
We are also grateful if we don't have to hear them. One matter less.
I am not that so.
No, we are so lazy because one matter less then. It's taking more time than a first appeal hearing. He was grateful to you. You gave it. The phone, no, not you.
No.
Somebody else. Yes, please help him out. Please help him with the phone and take care that no unnecessary message comes up because of your age. What does it say? Justice Bharadwaj's determination. You read it out, please, sir.
Yes, my lord. My lord, contempt application and review petitions, including application connected thereto of the division bench of honorable judges whereof are not available due to death, retirement, or transfer or elevation.
And this is a review.
But kindly.
This is today's list.
No, my lord, last week's determination, entire determination was changed.
Please check up and come back tomorrow because there.
I will come with the printout.
List is not reflecting. No. You check up what is the latest. There have been 2 partial modifications to that.
Yes, I will
After
come
that, if there is a modification and we release the matter, then it goes out and you face a suit. No, this was last.
I will, my lord, I will come
Last
back.
week. This is a new week.
I will, yes.
There have been weekly changes in modifications in the list. We are flooded with those, but we have forgotten what is the last determination.
And
Check
my
up,
lord,
come back tomorrow.
Justice Bharadwaj also has the determination.
Since
of the
learned
last
counsel
week.
for the appellant submits that
My lord,
this
day
bench
after,
might not have determination to take up the matter, comma, to ascertain the same, comma, the matter is adjourned till April 7, 2025, Monday.
Monday, as your lordship, please.
এত নতুন আসছে পার্সিয়াল মডিফিকেশন এরপর মডিফিকেশন হয়ে থাকতে পারে কাল পরশু বোধ হয় এসছে তো দেখি না ওগুলো হ্যাঁ ইয়েস 14
Well, this is my application. Mr. Probal.
Why are you so sad?
Mr. Probal Mukherjee is leading me. He's on legs in.
No, yesterday also you asked for time. No further time. Yesterday there was this resolution of yours.
Passover.
No Passover.
Short
Move that.
for the Passover, as my learned senior friend, he's also appearing.
Let your learned senior friends be wherever they are. What is the application for? This can 2.
Can 3. Yeah.
Can 3.
Can 2. Your lordship is their application. Can 3 is my.
What are the cans? Let us just understand first.
Your lordship, an appeal was filed against an order under section 25 of the Gauges and Wards Act.
One second. একটুখানি can 3 টা কোথায়? Can 1 এর এতগুলো ভলিউম রয়েছে.
Can 1 has 3 volumes, your lordship.
Can 1 has 3 volumes. You've got those volumes. তারই সাপ্লিমেন্টারি এফিডেভিট রিপ্লেস Can 1 এর বুঝলেন তো? এবার Can 3 টা কোথায়? পেয়েছেন পাওয়া গেছে? Can 3 আপনি পেয়েছেন? Yes. Can 3, sorry. Can 3 is for?
Your lordship, Can 3, your lordship.
Child independent lawyer.
Yes, your lordship.
What is the concept? We don't know.
Yes, your lordship, we know.
What is the concept? We don't know.
Your lordship, there are several judgments of Kerala High Court where
Child independent lawyer means?
A lawyer.
This application is for what?
For appointment of a lawyer for the child. The minor.
No, this arises out of, you said something? What is the impugned order?
An appeal under section 25 of the Guardians and
Guardians. So what is the concept of a child independent lawyer?
The child independent lawyer will represent only the interest of the child along with other sociologists and psychologists who will ascertain what is the position of the child as to like where she wants to stay.
Is there any change in our law to accommodate that?
Your lordship, the Kerala High Court has already passed judgments.
Kerala High Court is not our law. What is the law of our country?
The law
that a particular court might have passed.
Yes, your lordship.
But there may be circumstances, each judgment is a precedent for its own circumstances. But
I will show you.
Well, let Mr. Mukherjee come. You may be embarrassed. We also may be embarrassed. Ultimately, if we dismiss it and find out that Mr. Mukherjee had something to add,
Yes,
please come back on the next. You are very grateful. Obviously, you are also asking. Let counsel for the parties seek an accommodation for the day. Push up. Let the matter come up for. Let the matter be listed next on April 7, 2025. Today we take up the appeals first. Tomorrow single. So therefore Monday. দাঁড়ান পড়ে যাবে সাবধান তাড়াহুড়ো করতে হবে বাপুর জন্য জেনে নেবো নিশ্চয়ই জাজমেন্টটা দেখা যাবে প্রবল দেখা যায়
So I appear for the appellant.
Yes.
So I have ascertained what are those 5 applications. Can 1 was the first injunction application when the appeal was filed.
Achha.
That matter rendered infructuous.
The appeal has been admitted under order for.
The admitted interim order was passed. The subsequently interim order expired. But
Achha.
thereafter, they file an application for recalling of that interim order. Thereafter, my lord, we file an application for addition of party and also file an application for restoration of the earlier interim order. The earlier interim order was restored. My lord, that was disposed of Can 4, and thereafter, my lord, we filed this application.
If Can 4 was disposed of, it was restored on the basis of Can 1 or reimposed.
Can 4, my lord, for restoration of the interim order earlier passed.
Then Can 1 is still subsisting. Can 1 was passed ad interim.
There is 2 injunction application that are pending as on date. This is
No, we are in the midst of understanding what are the applications for. So your application for recall can too.
No, it is not my application. It is filed by some.
Vacating, for vacating.
For vacating has to be yours.
I have for the respondent number 1 only.
Some other respondent's application.
Yes, Malan, I am for the respondent number 10,
So
11,
can 2 is
21.
your application.
Can 2 is my application.
Can 2 is still pending.
No, my lord,
My
that
lord.
was directed to be treated as affidavit.
Affidavit in opposition, my lord.
Very well. If you have in opposition, 2 can 1. 2 can 1. So these two are taken care of. Can 1, when was can 1 disposed of? It was never disposed of.
Can 1 was not disposed of. Interim order was expired, we filed for restoration.
So
of-
can 4 has been disposed of. Can 4 was for reimposition of the injunction or whatever, restoration. So therefore it has been restored. Now the ad interim is prevailing.
Not prevailing, it has already been expired.
Again
Because-
expired.
Yes, for development, my lord, circumstances. Because, my lord, the interim order was passed against the, my lord, original respondents.
So why have you filed another
My lord,
a fresh
some-
application for injunction?
Some respondents have been added because they have, my lord, claimed that they have purchased a portion of the property. We filed a suit for partition.
No, see, can 1 is still pending. How can you file a new application on the same?
The added respondents have added, my lord. In view of the, my lord, development.
In can 5 you want injunction against the added
against the added
respondent
respondents, my lord.
only.
My lord.
You could have
Because-
amended the original
No,
application.
because, my lord, in the can 4 application, my lord, when it was disposed of, their lordships were, my lord, restricted. That interim order, my lord, only is binding upon the original respondents, not the added respondents.
At that point of a time, can 5 had not been filed.
No,
But those respondents were added in the appeal.
yes, by virtue of lordships order.
Achha.
Your lordship may point out one thing, whether these added respondents were added as defendants in the original suit. Have asked for that instruction, that is not with me at all. For
The
that
appeal is against what?
appeal is against the injunction order.
No, not injunction order. And what happened? Firstly, we filed an application, appeal, my lord, challenging the refusal to add interim order. Pass an interim order. Initially, my lord, the interim order was passed, and their lordships, my lord, directed the learned trial court to consider our prayer for interim or for extension of their lordships order. My lord, that was not considered, and my lord, interim order was not extended. Challenging that order, my lord, we filed this instance.
In the trial court, the temporary injunction application itself has been dismissed.
No, my
No,
lord, it is
ad
fixed for
interim
hearing.
order.
At
When?
the last order.
When?
My lord, it is fixed on 14th of May.
My lord,
The
that is-
711 application under Order 7 Rule 11 has been filed by me. That is also pending.
But 14th of May is far off. In the meantime, if you do anything to the property, then we have to.
They are making construction.
My lord, there is the thing that there was a partition originally between the predecessors of the party.
No, we'll hear on merits later. But then these added, who are these added respondents?
My lord, they have claimed that they have purchased a portion of the joint property.
So you want, what is the injunction you are wanting? From changing nature,
They are making construction because, my lord, my land.
from changing nature character?
Yes.
My lord, they
What-
have also transferred certain
No,
portions.
no, we'll consider that. First, let me hear them, then we'll hear you, both of you. Take your seat. Yes. So move your application. Can 1 and 5 we are taking up together then? What is their contention in the objection?
Their contention is, my lord, that already partition has taken effect, so they are, my lord.
That will be decided in the on the merits.
My lord,
It's a partition suit.
partition.
Why was injunction refused by the trial court?
My lord, there is no urgency.
What do you say? Why shouldn't injunction? First I'll hear you, then we'll hear her.
My lord, for that reason, my lord, I have to ask for certain instruction. I'll require a affidavit, a short
You
affidavit.
file your affidavit by all means, but in the meantime, it's a partition suit. You cannot change the nature and character.
My lord, the property has.
Urgency is obviously proved because these added parties, they have, it has been transferred to, they claim that it has been transferred to them.
My lord,
Fresh allegation that
what
they're
they
making.
claim is that a suit has been filed against them by these added respondents, and they have obtained the order of injunction. Thereafter, they have come in this appeal, not in the suit. They have come up and filed a application for adding them as
Those
respondents.
added respondents filed a suit against them.
Several suits that is disclosed in the application.
You are for the added respondents, no?
No, my lord. I
Added
am-
respondents have been served copies of this application.
No, not application, my lord, the notice has been served.
What notice?
My lord, the appeal, my lord.
The addition of party application, there must have been some addition of party application which was allowed. That application was served on them. How could they be added then by this court?
My lord, by virtue of lordship's order, my lord.
How could I add? I mean, that is what I am asking. What is the premise of our
That
addition?
application
My
was
lord,
unopposed.
after, my lord, because, my lord, I, my lord, made.
Service, if service was not effective, oh, acha, acha.
No, I-
Unopposed by you.
Nobody appeared, my lord.
Acha.
Well,
From
I
the
made a
order
case,
sheet, I
my
could
lord, I
find
made a case, my lord, I came.
No, but if you are seeking injunction against them also, then you have to serve copy of this application now.
I will serve. My lord, what is my case? My lord, now my relief not against my learned friend's client.
Only against the added respondent.
Yes, my lord, because they are making construction. My lord, initially interim order was passed.
Very well. If the main injunction application is pending in the trial court, you have added those parties in the main injunction application or the suit.
That I don't know because.
If you don't know, you haven't.
My lord,
My
If
lord,
you had, then you would have known.
Sir,
If you are not seeking, that would be beyond the scope of the injunction, the main order against which the appeal has been filed. We'll relegate the matter, lock, stock, barrel, file your applications in the trial court.
my lord, since my lord, this appeal is pending.
You have to file this application. For the first time, we cannot grant an injunction against parties who are not parties to the suit.
My lord,
We might have added them as parties.
They have been added to the appeal because, my lord, now the appeal is pending, my lord. I will certainly, my lord, take steps before the learned court below. But since the appeal is pending, my lord, so I have, my lord, added the part. I have made the application for, my lord, for adding them as a party to this appeal. So, my lord, my humble submission to lord, my lord, only, my lord, status quo order be maintained. So, in the meantime, my lord, let the trial court be directed to, my lord, dispose of the injunction application.
You have to get them, those parties added first in the trial court.
Well, I have to. But
Granting
in the-
injunction against this
in
person
the
should be
meantime, my lord,
the appeal.
Lordship, kindly have a look to the photographs. Kindly have a look. My lord,
We are
appreciate.
convinced that photographs are there, but this will be beyond the scope of the appeal.
Substantial construction has taken place because, my lord, interim order was.
Why didn't you implement them in the court below as well?
Since, my lord, appeal is pending, that's why, my
Appeal
lord,
is pending against an ad interim order, means suit is pending.
main suit is pending, my lord. In the meantime, my lord, the appeal is pending. That's why, my lord, I first filed this application before this honorable court. In this appeal, so that, my lord, an injunction order can be, my lord, obtained against them because, my lord, they are rapidly.
Listen. You have not yet filed an application for injunction against these people in the court below.
No.
We cannot use up the jurisdiction of the trial court and grant an injunction for the first time against persons who are not parties to the suit. No injunction has been sought in the court below. In an appeal, if the appeal was against a final decree or a preliminary decree, we could have understood. This is an appeal against a particular order. It's cylindrical in scope. That we cannot exceed the scope of the trial court itself today. If we affirm this order or set it aside, we could at best grant an injunction in respect of the persons who are there in the suit. But as of today, if we dispose of this matter and send it back to the trial court, as of today, the trial court could not grant injunction against those persons. So we cannot go beyond the scope of the appeal. Now, because your contention is that now these people are constructing, we'll dispose of the appeal and we'll relegate the matter to the trial court.
Subject to lawsuit correction, my lord.
There is no scope of this appeal.
No, my lord, let them come, my lord. We will serve the copy upon the opposite.
No, we cannot because they are not parties yet to the suit. We cannot go beyond the scope of the suit. We have added them. You have made out a case that they are seeking for addition of, they are seeking, asserting that they have purchased the property. We appreciate that. But if they are not yet parties to the suit, your learned friend is right on that. We cannot go beyond the scope of this.
My lord, kindly appreciate. My lord, kindly, they have been added. My lord, kindly appreciate.
We cannot go beyond the scope of
My
the.
lord, kindly appreciate. My lord, they have been added in this appeal, my lord. My lord, late, my lord, they come and place their defense before the lordship.
We will give our reasons. We cannot.
My lord, only, my lord, otherwise, my lord, it will take some time, my lord. In the your lordship can have a look. The substantial construction of taking place. My lord, if my lord, third party interest is created, my lord, multiplicity proceeding will take place, my lord. Kindly appreciate.
You don't understand. What you are not understanding is that they are not parties to the suit. We cannot, in a misappeal, go beyond the scope of the suit. We cannot.
That is, my lord, challenging, my lord, the order, my lord, which was directed by this honorable court to consider. That was not considered by the learned court below. Against that order.
Now you are not even pressing your injunction application against them. Your prayer is against someone else who is not a party to the suit. How many times do you repeat?
The injunction is against all the respondents. Against all the respondents.
You are saying yourself that then CAN 5 is not maintainable.
Well, it is not res judicata because of development took place because of the.
CAN 5 is not maintainable not because of res judicata, because an application is already pending in that principle of section 10, not res judicata.
But my lord, my lord, no relief can be, my lord, prayed for in the CAN 1 application against the, my lord, added respondent. Some development took place.
No.
Lordship can appeal some development.
You could have amended CAN 1.
Lord,
anyway, we cannot go beyond the scope of this suit itself.
But injunction, my lord, they are restricting the respondents, including the added respondent.
No.
So lordship can appreciate. Otherwise, my lord, my whole, my lord, suit would be rendered
Counsel
infructuous.
for the appellant submits that CAN 5, no, that Can 5 of 2025 has been filed seeking injunction against the added respondents. Full stop. Next para, it is pointed out by learned counsel appearing for you or for respondent number
1.
And you,
My lord, 10, 11 and 20, my lord.
learned counsel for respondent number 1 and learned counsel for respondent numbers 10, 11 and 21 that
20, my lord.
20,
20, my lord.
21 or 20.
21.
20,
In
I
11,
guess.
21 appeared last.
You are not sure who you are appearing for?
20, my lord.
21.
20, my lord.
1, 21.
Hey, but this is order has been
20.
21. My lord.
Call, yes, thank you. 21 that the added respondents have not yet been impleaded in the partition suit itself, from which the present appeal emanates. Puts up next para. The brief background of the case is that initially a partition suit was filed by the appellant, in connection which an injunction application was also filed by the plaintiff's appellant. Full stop. Plaintiff's appellants. Full stop. In the said matter, the ad interim injunction having been refused, an appeal was preferred, in which there were certain directions on the learned trial judge to reconsider whether to extend the ad interim order granted by this court in the said appeal. Full stop. The grievance of the appellant is that without considering such observations, the learned trial judge again refused ad interim injunction. Full stop. Next para. As it transpires, the main injunction application in the trial court is scheduled to be heard on May 14, 2025. Full stop. Next para. In the meantime, it is alleged by the appellants that certain third parties to the suit claim that they have purchased the property, the suit property. Full stop. On such premise, those parties were added as parties to the present appeal. Full stop. Can 5 of 2025 has been filed for injunction against the said added parties. Full stop. Learned counsel for the appellant alleges that it is the added parties who are now making day-to-day construction, for which learned counsel seeks to rely on certain photographs and the other annexures to the application bearing can 5 of 2025. Full stop. Next para. Upon consideration of upon careful consideration of the materials on record and the submissions of parties, we are of the opinion that an appellate hierarchy is somewhat cylindrical or can be compared to a pyramid. Full stop. Next para. The tip stroke apex of the pyramid cannot go beyond the base. Full stop. Next para. Since the present appeal itself arises out of the refusal to grant ad interim injunction in a partition suit where the added respondents have not been impleaded as yet, in the event we grant an injunction in respect of the added parties to the appeal, it would be entirely beyond the scope, not only of the suit, but also the impugned order. Full stop. The court taking up a miscellaneous appeal against an ad interim order passed in a suit operates in a much limited jurisdiction than a regular first appeal. Full stop. In the event the appeal had been preferred against a decree passed in a suit, the legal fiction of appeal being a continuation of suit could have been applied and this court could have added the parties and granted injunction against them. Full stop. Next para. However, within the limited scope of the appeal, which is in respect of refusal of an ad interim injunction against the original respondents herein, granting an injunction against parties who are not yet impleaded in the suit would be entirely dehorse the jurisdiction of this court in our opinion. Full stop. Accordingly, FMA, line add kodo. Moreover, since the injunction application is already pending in the court below to be taken up on May 14, 2025, and the present appellant is without injunction even before this court for some time now, we deem it fit that liberty should be given to the appellants to make appropriate application for extension of the injunction. Injunction to পাইনি for addition of the alleged purchasers and seeking fresh injunction against them and or seeking an extension of injunction against the said added parties in connection with the main injunction application which is already pending. Full stop, next para. In view of the above, comma, FMA 451 of 2023 is disposed of without interfering with the impugned order, comma, granting liberty to the plaintiff's appellants to file appropriate application for addition of the alleged subsequent purchasers as parties to the partition suit and also to seek injunction stroke extension of injunction against such added parties, comma, also before the learned trial court, full stop. If so approached, comma, the learned trial judge shall dispose of such applications as expeditiously as possible upon giving an opportunity of hearing to the defendants stroke respondents, comma, without being influenced in any manner by any of the observations made above on merits. Full stop. Can 1 of 2023, comma, can 2 of 2023, and can 5 of 2025 are also disposed of in the light of the above observations. There will be no orders to cost.
But only in reasons, my lord, time fixed, my lord, if the exercise is, my lord, completed in the meantime.
We have said as
Because,
expeditious
my lord,
as
your
possible.
lordship knows, my lord, in the my lord, trial court, my lord, it is very difficult to, my lord.
We know, but nothing
But
to say, Chakravarti, we cannot do it.
next, my lord, date or 1 month thereafter. Lordship kindly recorded, my lord. Because, my lord, kindly see that, my lord,
আচ্ছা একটা জায়গায় বলেছে না
substantial.
শঙ্কর expeditiously as expeditious as possible disposition as expeditious as possible comma preferably within 3 weeks from the date of filing of such applications.
Right. Right. I am deeply offended.
Number 16.
16, my lord, it's an application for expeditious hearing of the.
What is the defect?
Defect, my lord.
First check up the defects whenever you move a matter. Remove for this. Remove. Expeditious hearing. This appeal arises out of what?
Lord, a suit for declaration declaring my termination letter to be void. Null and
Dismissed.
void. No,
Dismissed.
my lord, allowed. But my lord, my arrears of salary has been
Not given. So partially. Very good. Can 1 of 2024 is an application for expeditious hearing of the appeal, full stop. In view of the innocuous nature of the prayer, comma, we do not deem it necessary to direct prior service of the application on the respondent. Full stop, next para. Can 1 of 2024 is accordingly disposed of, directing the appellant to put in the due requisites for the service of notice of appeal on the respondent within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. No orders to cost.
Number 33. My lord, I appear for the appellant. I'm led by Mr. Deepthi Banerjee in this matter. My lord, this is an application for leave to prefer the appeal as legal representative of the deceased plaintiff. My lord, the order. My lord,
The plaintiff died during in the interregnum between the decree and this appeal.
yes, ma'am.
Serve a copy on the other side. Then. Serve a copy of this application. There is any other application?
No one.
So serve a copy of this application along with the memorandum
Fine.
so that they can come prepared on. The present application is an application for leave to prefer the appeal, comma, since the original plaintiff in the court below, comma, of whose original plaintiff in the court below died in the interregnum between passing of the impugned judgment and decree and the preferring of this appeal. First up, the appellants claim to be the heirs of the said deceased original plaintiff. First up, next para. Although we find a prima facie case for grant of such leave, comma, for the sake of propriety, comma, the appellant is directed to serve copies of the application and the memorandum of the appeal on the respondents, indicating that the application shall be listed next on April 21, 2025, when an affidavit of service to that effect shall be filed by the petitioners.
Well, I'm appearing on behalf of the appellant wife, my lord.
Apparent wife, right?
This is my affidavit in reply. I have already found it and served up on the other side, my lord.
This is for alimony or
No, my lord. It's for condonation of.
what is the delay? 555. What is the reason for the delay, Ms. Banerjee? You have filed your opposition, Mr.
Yes, Milord, I have last date, Milord, I have handed over.
Sorry. Yes.
The reason for the delay is, my lord, I was not aware of the pending of any suit before 21st September 2024.
Right.
As I have understand, there is a matter, there was a suit.
It's an ex parte degree.
Yes, my lord.
Degree is for
It is for divorce.
divorce degree. Now, when did you come to know?
21st September 2024.
When did you prefer the appeal? From reliable sources. You have not disclosed the source properly. This is not an explanation.
7th October 2024.
That is within reasonable time. But what is the reliable source? How did you come to know?
Common friend, my lord.
Yes, what? How have you? What is the objection?
Your lordship knows that she has chooses to prefer a regular appeal. That instead of order 9 rule 13. That there was a summon served not in the address as mentioned in the cause title of the instant appeal of the wife. Thereafter substituted service made. Not even spelled out what happened. In the meantime, the statutory period over, I remarried. I have mentioned in my.
You remarried.
Yes. So situation becomes irreversible. And what happened? She was heavily contesting one of the criminal proceeding against she was posted as one of the responsible officer in State Bank of India. There's a huge defalcation of money.
So Mukherjee, you know the law that knowledge of the pendency of the suit is not knowledge of the ex parte degree.
Order that is Article 120. The Order 5 Rule 20 substituted service is not, but regarding.
No, she had knowledge of the suit. I may have knowledge of the suit against me, but that does not necessarily presuppose that I have knowledge of the ex parte decree.
But
I was supposed to be diligent.
One is the explanation.
Supplementary affidavit has also been filed. Something must be there also.
Supplementary affidavit filed because the erstwhile lawyer has calculated the delay.
Oh, the number of them.
And my occupation was said I was a service holder, but since then I lost my job, my lord. The thing, my lord,
anticipatory bail.
But what is the use? I mean, there is a Rajasthan High Court and there are other judgments also that this also has to be taken into consideration. What is the purpose of reviving this appeal? They're married after the statutory period. This will ruin, I mean, at least 2 lives. His life, his new wife's life, if not others.
Lordship can come to the page 3 of my affidavit in reply. I have mentioned, I have explained it because the substituted service is the.
Now, this is not an Order 9 Rule 13. Why didn't you prefer an Order 9 Rule 13?
It's an arm twisting litigation.
The address, my office address, etc.
But you have not taken out an Order 9 Rule 13. That is not a consideration in Order 9 Rule 13. In appeal, consideration is whether we can, on merits, we should set aside the decree. But a major consideration in that in matrimonial matters is that they have already remarried. And your appeal, if you allow this appeal, I mean, allow this application, then it will be jeopardizing the rights which have already accrued long back in their favor. And this is not an Order 9 Rule 13 as such.
Just on February 2022, the
equity prevents us from doing it. And your explanation is not clear. Suddenly you learn from this appears to be malafide.
But it's an untwisting.
Appears to be malafide.
Substituted service, they have chosen the paper is HON'BLE, my lord. And I am residing at Delhi. HON'BLE is the not wide publicated newspaper. They have chosen a newspaper which has limited jurisdiction.
That also my learned friend cannot take in
not regular appeal.
The order was passed on 17th February 2022, and they have chose to such publication on 14th on 1st April, my lord. It's a long time back. They have taken a long time gap. When the order passed, I was in Kolkata as my father died at that time. So if they publish at that moment, my lord, I may have the knowledge of the pending suit as well as the decree. My only contention is it's my natural justice has infringed, my lord. This is my only contention. And the respondent was well aware of the other addresses of mine.
কি করা যায় বলুন তো? সেকশন 5 টা কনভেন্ট করলে অ্যাপিলটা রেজিস্টার্ড হবে। দিয়ে ঠাকুরে বসে আছে তো। When did you remarry?
Yes, my lord. The decree was passed, my lord, on February 2023. I remarried on 26th of February 2024. After almost 1 year.
14 months.
জাজমেন্ট আছে অন্যান্য হাইকোর্টের যে
Against me in the suit as well as the judgment and the decree. When it is an ex parte decree, the judgment.
My lord, I can make comments, my lord, regarding that. When she was posted as an employee of SBI.
No. I have not appeared in the suit, my lord. I didn't file any application.
alimony, even today you can file an alimony under section 25.
But the appeal is pending.
No, she does not want an alimony because she's wanting to divorce it.
Afterward, maybe I'll consult with my.
Right now, because if you file a section 25, you are abiding by that final decree. Then we would not advise you, but if you had filed the section 25, then you would have conceded to the final degree having 25 can be filed only if there is a final degree. Since you have challenged, obviously you have not filed section 25.
No, my lord, I have not.
But first of all, this is not bona fide. Para 2, your para 2 says from her reliable sources. We are not very confident on that. And we would not be so technical if there was no remarriage in the meantime. Remarriage after 1 year from the date of decree.
Not in my hand, my lord, but the allegations are false and.
Not in your hand, but.
But the allegations against me are very vicious, my lord. And I have, and the judgment and decree also have the same allegations. If it is an ex parte decree and there is a judgment which is. That is my only contention. That's a natural justice has increased, my lord, and I am before your lordship. And the substituted service was made through Ajkal Potrika.
Mr. Mukherjee, it's not that we cannot, even in an appeal, there are certain judgments which say that we in the appeal also, apart from the merits, that is also, we can also look at whether regarding the Order 9 Rule 13 scenario, whether the decree itself, because that vitiates the root of the decree also. If that ex parte degree was obtained without proper service.
To correction, my lord. If one chooses, my lord, there are two, my lord, parallel remedy available. Order 9 Rule 13 and regular appeal can be filed parallelly.
No,
Lord,
in an appeal,
the scope of my lord, Order 9 Rule 13
there is
regarding
appeal is wider, Mr. Mukherjee.
Yes, my lord.
In appeal also we
wider,
can consider.
In the appeal, the not subject to correction, my lord, my learned friend has to demonstrate before your lordship, even if I was not there, I was not contested. Then also, what is the decree that is wrong on merit, even if I did not consent. But the scope of Order 9 Rule 13 is not that's why not perhaps not certain.
Order 9 Rule 13 is limited,
It's
but
limited,
appeal is not limited only to consider whether on the basis of the, because if you find that the ex parte decree you are obtaining the ex parte decree is vitiated, then that goes to the root of the decree. Now, Ajkal Potrika circulation, when she is a resident of Delhi.
The respondent is well aware of the addresses, my lord.
your lordship.
We have a phone call chat also.
Yes, that's why I did not gone into that arena. Why this is arm twisting? There are Facebook posting, there are the WhatsApp chat from which it can be apparent that the wife, the first wife, do have the knowledge regarding divorce and all that. She continued.
when
You have
she-
not, you haven't annexed anything to your opposition,
No, my lord, I
any
have
chat or
annexed-
anything.
I have no, my lord, that is, my lord, I do not want to even today also, my lord, there are, my lord, WhatsApp chatting, my lord, he used to, my lord, post, my client used to block.
You cannot go
But
in.
that is the other thing.
That's
But
your
today-
submission from the bar. There is nothing on record.
Today, my lord, my learned friend has come up, my lord, after, my lord, waiting, my lord, your lordship knows, my lord, he has to at least reasonable explanation. From what source, when, how she has come to learn. It's only after, my lord, 555 days, she, my lord, thinks that yes, a regular. And, my lord, regarding, my lord, the allegation, my learned friend once, my lord, kindly once looks at.
Now, what about Ajgal circulation? What was the address given? The present address was given.
The present address mentioned in the cause title of his appeal, or her appeal, is being, my lord, the address wherein, my lord, the initial service made, satisfied, thereafter substituted service in Ajkal newspaper, it published.
Satisfied in what manner, my lord? Nobody has
Nobody entered appearance, that's why.
received the summon ever. My father was he was suffering from,
Ms. Banerjee, you are not satisfied with the explanation. Reliable sources.
it's a common friend, my lord.
Common friend. If it was a common friend, he should have informed earlier.
Stop taking calls.
If there was a common friend, then you would not have been informed 555 days after. I mean, it's almost 1.5 years.
Stop taking my calls, then I got.
Why, my lord, stops taking of call, my lord, in the, my lord,
Dismissing.
in the anticipatory bail application, your lordship kindly once looks at paragraph 60. But she
Let us not
herself, my lord,
wash dirty linen in public since
No,
you are
my lord,
dismissing her. The present application has been filed for condonation of delay of about 555 days. 555 or what? What is the number? 555 days in dekhini ekhane koto ache.
563 days.
Acha, about 563 days in preferring the appeal. First of the appeal has been preferred against a decree of divorce obtained by the respondent husband. First of next para, learned counsel for the appellant submits that although the appellant is a resident of Delhi and has been a resident of Delhi during the relevant period, comma, summons were substituted service of summons was effected purportedly by circulation in a Bengali newspaper, comma, which does not have any circulation as such in Delhi. Full stop, next para. Thus, comma, it is submitted that proper service was not effected at all on the appellant and she was left in the lurch, comma, since there was regular communication between the parties even after the decree and there was no occasion for the appellant to suspect that a divorce had been obtained surreptitiously behind her back by the respondent. Full stop, next para. Learned counsel appearing for the respondent husband submits that the appellant wife was well aware of the pendency of the suit and the decree. Full stop. In fact, comma, it is pointed out that the cause title of the appellant given in the present appeal, comma, that is the memorandum of the appeal and the connected application, are also within the jurisdiction of the trial court. Full stop. It is the said address at which summons was sought to be served. Full stop. As such, comma, it is contended that the present application is mala fide. Full stop. Next para. It is further submitted by the respondent that after waiting for a year, about a year from the passing of the divorce decree, comma, only on February 26, 24, comma, the respondent has remarried and as such, comma, the lives of the respondent and his second wife would be jeopardized in the event the appeal is permitted to be registered upon condonation of the delay. So next para, there are several aspects of the matter which we are required to consideration since, comma, at the end of the day, comma, it is an equitable remedy which is sought by the appellant wife in the application for condonation of delay. Full stop. What is to be considered is whether the appellant was reasonably diligent in looking after the appeal. Full stop. Next para. The first aspect of the matter which catches our eye is that the only explanation regarding the appellant wife having coming to know of the ex parte decree is found in paragraph 2 of the application, which is merely that suddenly, on September 21, 2024, she came to know that her husband had obtained the ex parte decree on December 23, 2022. Full stop. The source of such knowledge is, as stated in paragraph 2, merely within double inverted reliable sources, double inverted close, without elaborating as to what is the exact nature of such source, which casts a doubt on the said averment. Full stop. Learned counsel for the appellant, during her arguments, submits that it was common friends from whom the appellant wife came to know of the divorce decree. Full stop. However, if the common friends were if the common friends had informed the appellant wife of the ex parte decree, we do not find any reason as to why the said information was not given within reasonable time from the said decree or at the time of passing of the decree. Full stop. In fact, we find that proper explanation as to the knowledge of the wife is completely missing from the application. Full stop. Furthermore, the address of the wife as disclosed in the present appeal is that at which summons were served in the court below. Full stop. Next para. There is nothing on record to show that the wife had left such permanent address at any point of time. Full stop. Next para. As regards the averment as to the appellant being posted at Delhi South Campus SBI branch at the relevant period, we find lack of sufficient explanation or proof in that regard as well, sufficient to show that the wife had no communication with her permanent address and or never came to her permanent address as disclosed in the cause title of the present appeal during the relevant period. Full stop. Next para. Moreover, an important consideration here is that the respondent husband, after waiting for much beyond the statutory period, that is after 1 year from the ex parte decree, remarried. Full stop. Next para. In the event the delay is condoned at this belated juncture, valuable rights accrued in favor of not only the respondent but his second wife and their lives would be jeopardized. Full stop. Next para. Taking into consideration all the above aspects, we are of the opinion that the present application is not bona fide and we do not find sufficient explanation for the prolonged delay of about 563 days in preferring the appeal. Full stop. Accordingly, Can 1 of 2024 is dismissed on contest without any orders to cost. Full stop. Next para. Consequentially, FAT 339 of 2024 is dismissed as time barred. Any other application pending? No. No orders to cost. Sorry, Ms. Banerjee. It was a dilemma, but yes. Yes, Mr. Banerjee to Bandyopadhyay now. No, sorry. Yes, Mr. Bandyopadhyay. Who are you looking for?
I don't find my advocation record. Or
Oh, then you cannot have.
Because that because
Now Supreme Court is very cautious.
service of notice.
Oh, without that, you are appearing. Why are you silent? You are appearing for whom? Both the respondents.
No, sir, I am appealing for respondent number 1, plaintiff.
Another is the Performa Respondent. In the suit, he was made Performa defendant.
What was the suit for?
Suit for declaration and injunctions, of a right which was not existed. Which didn't exist.
No, decree. Their suit.
Their suit.
Decree.
It's a shop room.
Performa you are a defendant. You are defendants.
I was defendant.
And the other one was Performa defendant.
Yes.
Performa defendant ever contested? Do you have any idea?
My lord, Performa opposite party is also defendant. He is
Regular defendant?
Yes, he is defendant number 2.
But in the
But they are not claiming any relief against the pro forma defendant.
my lord, in the
No, I
suit,
have,
my lord,
I have claimed for an injunction order against the defendants as well as the pro forma defendant.
Right. But regarding the Section 5 application in the appeal,
2 days delay, my lord.
no, not only that, service of the appeal also, notice of appeal on the pro forma defendant is not necessary. The pro forma defendant will benefit only if they win the appeal. So his fate is not decided. Your fate is decided, your client. Very well. Affidavit of service is not there, but we direct.
Not with me, my lord, I don't know.
Should he pass it over or take it up on the name? Mr. Rai is also involved in this. How? Where is the affidavit of service? File it. No, affidavit of service. You cannot be an affidavit of service.
Let it be passed over, my lord.
Very not today then, Mr. Mandal. Say, on the prayer of the appellants, the matter is adjourned for the day. Give your names. Mr. Bandavad, you have to give the name of your advocate and record also. Ask him or her to give the name. Mr. Rai, please write on a piece of paper. His junior's name also, excluding your name. Next matter. Yes. Yes.
Proposing this application.
You are who is proposing? Oh, Mr. Rai, yes. What is the matter?
But before starting, my learned friend, the order passed in the Lalbagh court, whereas the impugned order passed by the Jongipur court. But in the application, there is a wrong aberment, and also pair also been wrongly incorporated.
Misappeal has been admitted.
Yes. Admitted.
So no, what is the application for? The challenge is against what?
Remand.
Remand.
So,
So at the time of order 41 admission, you did not move the stay.
yes, my lord.
Stay has been granted.
Stay granted, my lord. Your lordship, this is my fault, my lord. It appears, my lord. In the prayer portion, I made civil judge additional court.
That will give you leave.
Jongipur, my lord. That is the
Should be additional court at Jongipur.
That would be Jongipur. In the order sheet also there is the.
But extending the stay, we are directing paper books to be filed and all.
And one thing, my lord, subject to question, my lord. This is a remand, my lord. Earlier occasion, this came up.
Oh, single judge. Right.
That has.
Right. Forgetting every time. It has to go before a learned single judge. It is rightly pointed out by learned counsel for the appellant that the matter pertains to the jurisdiction of a learned single judge of the appropriate learned single judge having determination, since the present first miscellaneous appeal arises out of a remand order. Full stop. Accordingly, let the matter go out of a list on due to lack of determination, with liberty to the parties to mention before the appropriate learned single judge having determination. Full stop. On the prayer of the appellant, however, leave is granted to the learned advocate and record for the appellant to carry out the necessary correction in the prayer portion of the application, insofar as the concerned court is concerned. Carry out that correction and go before the next.
I am appearing on behalf of the respondent number 1 and 2.
Yes, please.
Very. You just write it on a ask.
The order also been corrected. Otherwise,
No, order to correct. The order subject to question, my lord. If your lordship, there is the order of stay was granted by directing the.
We had granted.
yes.
That was.
Lalbagh court. That is Jongipur.
আগেটা একবার দিন তো এটা থাক আগেটা আরেকটা লাইন অ্যাড করে আগের order.
Thank you, Lord.
Leave is granted যেখানটা বললাম সেখানে in the light of the above error having been crept out, let our order dated February 18, 2025 be deemed to stand corrected inasmuch as the expression within double inverted additional court at Lalbagh, double inverted close, appearing in paragraph number 2 of the said order, be read as additional court at Jongipur.
But only one pair that directed to my learned friend to serve a memorandum of appeal. Not only application has been served.
Give a copy, Mr. We are not directing it. Yes.
That is
Our thing is
grateful.
Thank
বিশেষ করে
you. আপনি আমি সিন করবো। কল করেন। Yes. You're appealing for the other side?
Yes.
You have to file that receipt also formally. Yes, there was a direction
My lord,
to put in special messenger costs.
my lord, I have already put special messenger cost. Although, my lord, at the time of dictating the order in open court, your lordship directed the appellant to submit.
Oh.
But, my lord, mistakenly, my lord, it was recorded as respondent.
Acha.
Thereof, my lord, I have
Application for
deposited.
modification, my lord. My lord, in terms of your lordship's order.
What is the modification you are seeking?
My lord, what has happened, my lord? My lord, on 11/3/2025.
Modification of that order in which you also directed putting in special messenger
Yes,
costs.
yes, my lord. My lord, what has happened, my lord? My lord, at the time of hearing of the, my lord, said applications, my lord, on that day, my lord.
Yes.
My learned friends, my lord, produce documents as regards to the relaxation of condition of bail, and on the basis of such documents, my lord, which has not been relied in the affidavit in opposition, but at the time of hearing, they have just handed over the documents, my lord. But on that basis, my lord, your lordship made certain observation in the order, my lord. My lord, if your lordship kindly takes pen to the order dated, my lord, 11/3/2025 in the next page, page number 2 of the order sheet, my lord. Lord, an application filed by the appellant for relaxation of condition of bail, a copy of which is handed over in court today. We find that the appellant used the suit premises for running an embroidery business. Learned counsel for the respondent submits the such claim of the appellant of residential use is palpably belied, since the relaxation of bail was obtained on the sole ground that the appellant is running his business and embroidery shop from the said premises, which is the only source of appellant's livelihood. Hence, there is no reason why we should not draw adverse inference against the appellant for such material suppression of the relevant fact, my lord. My lord, although in the affidavit in opposition reply, my lord, we have categorically mentioned that we are not running any business in the property in questions.
Do you deny that you had obtained relaxation of bail on such ground?
No.
An order was produced
No,
to
my lord,
us.
my lord, kindly see the order, my lord. My lord, kindly see the order, my lord. Subsequently, my lord, we have inquired all these things, my lord. Kindly see the order, my lord. I have annexed my modification application also. My lord,
Okay.
kindly see.
Let us see that. Page 9.
My lord. Page, yes, my lord, page 9. My lord,
This is the order you had handed over?
yes, yes.
Yes, my lord, on that.
My lord, page 9 kindly comes to the page 10, my lord. This is the relevant part. Paragraph 4 of the order sheet, my lord. My lord, accordingly, the appellant petitioner are permitted to enter the...
No. Come to para 1 first.
Yes, my lord. The appellant petitioner are granted bail by an order dated such and such.
Come to the next sentence after the italics.
Yes. Shall not enter the jurisdiction of Shampukur.
After the italics, after that. Oh, Shampukur police.
Yes, yes. Jurisdiction of Shampukur police station except for the purpose of attending court proceeding and shall report to the officer in charge Shampukur police station once in a week until further order. They say that they have been scrupulously adhering to the said condition of bail. They now seek relaxation of those to condition of bail.
Next sentence.
They say they operate a very small embroidery shop within the jurisdiction of Shampukur police station. It is not with that property, my lord.
It is not your case that you have any other property.
My lord, yes, my lord. It is the jurisdiction of Shampukur.
You have other property also within Shampukur?
Yes, but I have annexed in my modification application that we are running a business, embroidery business in other property in questions. So that is 12/1, my lord. It is relates to the Shampukur.
Then also it's the same location, same neighborhood.
No, my lord. Shampukur police jurisdiction, that means it is the entire area of Shampukur police stations, my lord. It is admitted
Mr.
position that we are
Bhattacharya,
running a business.
this suit property is also within the Shampukur jurisdiction.
Yes.
Then it's commercially viable.
But not in this property.
Even
this
if in
property we are using exclusively for the purpose of residential.
You understand, then there could not be any adverse inference drawn against you. But that would still be a consideration that that area is commercially viable.
No, my lord, kindly seek your lord's order 1 second, my lord.
That is what we are saying. In para 2, you have stated that you draw an adverse inference because you
have suppressed. Your lordship has...
You have suppressed and running an embroidery from the shop room.
No,
So that premise should go.
in the premises, in that premises. It is not that we are not running the embodied.
Yes, what do you say to this?
In their premises, my lord.
In my
And
opposition also.
one more submission.
Acha.
Well, considering this aspect, since
Right.
your lordship has hold that this is a commercially viable and we are using a commercial portion of that property in questions, your lordship has been pleased to fix 30,000 occupational charges, taking into consideration of that fact.
That was independent. Read paragraph 4.
That's true, but
Read paragraph 4.
is also followed from your
If
lordship.
you are satisfied with your contention, that will expunge that observation that we draw in
It is
advocacy.
also followed from since it's a commercial, we are using this as a commercial purpose. Certainly,
You are using if you have a commercial business in the same residential area,
not say, in other
shampoo same police station area.
not in this property.
Even then, it's the same neighborhood.
Property is under but the occupational charge has been fixed 30,000
Rightly.
considering this aspect only.
What do you say regarding shampoo?
Regarding shampoo, my lord, I
That,
have
that it
stated
is
in my
it not being in the same area because they have given another address.
My lord, I have written in my opposition, paragraph 7C, 4C. page
What did
number
you stand?
7.
Tell us.
The appellant number 2 to 4 are not only staying at the premises but also used to continue embroidery business from the ground floor of the said premises.
No, but that 12 by 2 is a different premises.
Now, my lord, that they have not opposed in the reply itself.
Yes.
In the reply,
Specific.
Acha, we'll come back and do it.
My lord.
Yes.
My lord, paragraph number 7C of my opposition, I have stated.
Opposition to this modification.
Opposition to the, not the modification.
Main.
main.
Acha, yes.
4C of the opposition, I have stated that they are not only staying, but also used to continue embroidery business from the ground floor of the said premises.
4C.
4C, page number 7. 7 of the opposition. Page 7 of the opposition.
Oh, sorry, this is a reply. Yes, continue. How did they deal with this? In the reply, how did they deal with this?
This is page 4 of the reply, paragraph 6.
No, they say they are residing.
They said,
Kindly comes to page 5.
Please wait. Both cannot argue at the same time. They are saying they are residing there. That they are saying.
My contention is that they are residing as well as they are running. Now, my lord, at the time of hearing also.
Yes, not
they have
only staying but also used to continue. That is it. Acha, acha. They say that they are residing as bona fide tenants, right? No specific denial that they are also running.
Yes.
No. Next page they say, page 5. Further, it is to mention herein that since beginning, the appellant defendants have been using the tenant exclusively for residential purpose.
Now, my lord,
They also say that.
They say that exclusively for residential purpose, but they are with regard to their running of the business, they could have, my lord, annexed the document along with the
And
reply.
residential certificate, whatever that means.
And my lord, moreover, my
What is
lord,
a residential certificate? Who gave this? Councillor?
residential certificate.
Under which provision, Mr. Bhattacharya? No, residential certificate is given under which provision of law?
Councillor,
It's in italics, it's written residential certificate.
As a rent control bill also there, I have annexed.
Rent control, you're depositing money.
Yes. So that is in respect.
What is a residential certificate?
That I cannot.
This shows that you had the money and you run an embedded.
I'm running the business.
You know, councillor gave you this certificate. That shows that you have the money to get the certificate.
12 by 1, not by 7 by 1.
Yes. Yes, Mr. Bhattacharya, take your seat. Let us complete hearing. Yes.
My lord, at the time of hearing on the last.
But they have also said that they are exclusive using for residential purpose.
Yes, they have said, but at the time of my lord filing the reply, they could have annexed about the running of the business from another shop. Since I have taken that point.
But now they have, in their present modification application, they have annexed a document to show that they are running from a different premises.
After passing of the, my lord, your lordship.
Yes, because that was handed over at the time of argument.
At the time of argument, they have also stated that they are running 2 swing machines from the ground floor.
Who stated?
They stated.
They have recorded that in our order.
No, that has not been recorded, my lord. They have stated.
Swing machine in somebody's home, there may be also be swing machines.
That
does not necessarily show that they have an embroidery business. Then this adverse inference cannot remain. They have denied categorically. They have said that exclusively for residential means not for other purpose. So the determinant was then only this order which you handed over.
Yes.
And they have explained that order because in their opposition, in their present modification application, they have also annexed at page 11 to show that within this both are Shampookur police station.
Yes. Both are Shampookur police station.
Then they have a separate. It was a different, and that is also non-residential use. Sufficient proof has been given by them in this, at least to dispel our doubt regarding that we could not have drawn that adverse inference then. Because that adverse inference was only, the suppression observation was only on the premise that of this bail order. Yes. And since they have shown that they have a different premises where it's non-residential, so it could very well have been that.
The application.
Adverse inference should not be there. But then it also goes on to show that your client is running within the same police station area, commercial
my lord, if you
endeavor.
Kindly explain to me, Lord, order, my lord, paragraph number 5 of your lordship's order dated 11/3. Kindly come. once, my lord.
That is an additional ground. Come to page paragraph 4.
That's true, my lord.
Come to paragraph 4.
But my lord,
The adjudication is in para 4, keeping in mind the
Yes,
measurements of said room and marketing prevailing at the location. We have, and we also cannot overlook is an additional ground.
But my lord, paragraph 5 also, my lord, we also
5
cannot-
is an additional, an
My
afterthought.
lord, my lord, that is why, my lord.
That is not the determinant.
My lord, my lord, since your lordship has
We'll
already
expunge our, we'll say that we modify the order to the effect that there is no material suppression. At least we cannot find any material suppression of material fact only on the basis of this order. And this adverse inference, that portion we say that is a wrong.
some more relaxation so that, my lord, I can, my lord, kindly consider our situation, my lord. This is a very, it's not that of building, my lord, we are using, my lord.
No, that on merits we cannot. It's not a review.
The occupational charges 30,000 has been, considered on the basis of, since we have
Whatever.
suppressed, it is a commercial portion. That's why, otherwise your lawsuit could not have, passed this order of 30,000,
No. The present application has been filed for modification of an order dated March 11, 2025 by this court, whereby stay of the impugned eviction decree and the connected execution case was granted, subject to payment of occupation charges by the appellants / petitioners at the rate of rupees 30,000 per month. Who sub next parallel counsel for the appellants argues that there was an error apparent on the face of the said order, inasmuch as in paragraph number 2 of the order dated March 11, 2025, this court had observed that during arguments, learned counsel for the respondents had handed over a copy of an order of relaxation of bail, which was obtained by the appellants on the sole ground that the appellants are running an embroidery shop from the premises in question. Pushed up next para, on such basis, the court drew adverse inference against the appellants, treating the same to be a material suppression of relevant facts. Pushed up also, in paragraph number 5 of the order, this court had observed that the court cannot overlook the fact that the suit property is being exploited commercially by the appellants, which fact was deliberately sought to be suppressed by the appellants before this court. So next para, learned counsel places reliance on the said relaxation of bail order dated November 25, 2024, which has been annexed to the modification application, which merely records that the appellants were granted bail on condition that they shall not enter the jurisdiction of the Shampukur police station except for the purpose of attending court proceedings, and shall report to the officer in charge of the Shampukur police station once in a week until further order. The said condition was relaxed by observing that the appellants operate a very small embroidery shop within the jurisdiction of the Shampukur police station, which is their own only source of livelihood. Next para. However, learned counsel places reliance on annexure B at page 11 of the modification application and the documents annexed thereafter, which go on to show that within the same police station area, a different non-residential premises is used as a tailoring shop of the appellants. The address of the same, it is evident from the documents annexed to the modification application, is different than the suit premises. Next para, learned counsel for the respondents submits that in the affidavit in opposition to the original stay application, it was categorically averred in paragraph number 4 within bracket small c that the suit premises is being used by the appellants both for residential and for the residential purpose and for the purpose of running a small embroidery business, which was not denied by the appellants in their reply. Full stop. Next para. However, comma, we find from paragraph number 6 of the reply that apart from asserting that the suit premises are being used for residential purpose, comma, it has also been averred by the appellants in the self-same paragraph, that is paragraph number 6 of the reply to the stay application, that the said premises is being exclusively for the purpose of residence. So thus, comma, there was clear denial of such allegation made by the respondents on the part of the appellants. So next para, this court had relied solely on the relaxation of bail order obtained by the appellants in coming to the conclusion that the appellants are running embroidery business from the suit premises itself, comma, the basis of which was the observation by the court granting relaxation of bail that the appellants operate a very small embroidery shop within the jurisdiction of Shampukur police station. Next para. However, comma, since we are satisfied from the annexures to the present modification application that a different shop room is being run by the appellants from within the Shampukur police station, comma, within which the suit premises is also situated, comma, it becomes doubtful that solely on the basis of such relaxation of bail order, comma, we could have arrived at the conclusion that the appellants are running an embroidery business from the suit premises itself. Thus, comma, the observations made in paragraph number 2 and 5 of the order dated March 11, 2025, to the effect that material facts had been suppressed by the appellants are hereby deemed to stand expunged. As such, comma, the adverse inference drawn against the appellants on such count is also mitigated, and we do not draw such adverse inference against them. The question now crops up as to whether, in view of the above alteration of the said order, comma, the occupation charges of rupees 30,000 could still remain. Next para. Upon a careful perusal of our order dated March 11, 2025, we find that only one of the reasons of ascertaining occupation charges was the observation that the material fact of the appellants running an embroidery shop from the suit premises was suppressed. Both in paragraphs 2 and 5, comma, we had observed that the property is exploited, suit property is being exploited commercially, which does not appear to be clinched beyond reasonable doubt merely from the relaxation of bail order. Next para. However, comma, independently of such observations, comma, in paragraph number 4 of the said order, we had observed that keeping in mind the measurements of the suit room, which is about 650 square feet in area, and the market rent prevailing in the location, we were of the opinion that an amount of rupees 30,000 per month would suffice as occupation charges. Next para. We do not find any reason to deviate from such stand, comma, since the said finding was arrived at only upon consideration of the measurement of the suit room as well as the market rent prevailing in the location. Next para. In fact, comma, such observation is further strengthened by the fact that admittedly the appellants are running a tailoring shop within the same police station area, and as such, comma, the neighborhood is admittedly commercially viable. Next para. Hence, comma, we do not find any reason to alter the occupation charges imposed by the order dated March 11, 2025, although we have expunged the observation that there was suppression of material fact by the appellants and that we drew adverse inference in that regard. Hence, comma, the occupation charges imposed earlier shall remain. What is this? Can 3?
Well, kindly extend the time, your lordship, in the last.
The
order.
Can 3 of 2020, this is, what is the modification? Can 3? Can 3 of 2025. 2025. Can 3 of 2025 is disposed of in the light of the above observations without any knowledge to cost. Yes.
And my lord, there will be a violation in that even, my lord, your lordship directed me to, my lord, pay by 31st of March 2025. Well, kindly extend that part, my lord.
What did we?
My lord, paragraph 7, my lord.
First occupational charge, my lord.
First occupational charge.
Arrears of occupation charge.
Last day of the.
You have been
March-
paying the current
No,
No, my lord.
no,
My lord,
no,
since we have filed a modification application,
just by filing a modification
my
application.
lord, only 2 days, my lord. We have tried this matter to be heard before 31st, my lord, but I failed, my lord.
Then there has been modification of the entire thing.
Like only, my
The
lord,
entire,
time
no,
limit.
no. Then the
Only
current month
extend-
will be April. We directed March to
No,
be the
my lord,
current month.
in that even, my lord, the shall be paid 4 equal instruments, that is February 20, it will be remain same only for the current, my lord, April 25, my lord.
No, you have not paid the first installment also.
No, no.
Not the current
No, no.
occupation charge. After line at in view of the pendency of the modification application, comma, the time for deposit of the first installment of the arrear occupation charges is extended till the last day of April 2025. Full stop. For such purpose, comma, the next installments of the arrear occupation charges shall be paid within the last date of each succeeding month thereafter. Full stop. However, comma, such arrear of occupation charges shall now be treated to be from the date of the impugned judgment and decree till the month of March 2025. Full stop. The current occupation charges for the month of April 2025 shall be deposited by the by April 30, 2025, and thereafter by the last date of each current month.
And my lord, with regard to my lord, special messenger cost, my lord, I have deposited, but my lord, applicant should, my lord, prepare the paper books and all other
That is
things,
there.
my lord.
That is also there.
No, that is with regard to respondent, it is written, recorded.
তো তোদের correction দরকার, হ্যাঁ। কোনটা বলছিস?
No.
For the respondents.
On your pair, we have directed you to put in the special messenger
No,
cost.
no.
No, there is no, there will be no modification of that.
My
You
lord, at
prepare
the time of hearing, my lord, your lordship directed, my lord.
করে না নেবো।
No. You
At the
prepare
time of
the paper.
hearing, my lord, your lordship directed, my lord.
You want to expedite the matter? You
My
prepare
lord,
the paper.
there is, my lord, some, my lord, typographical mistake, my lord. At the time of dictating, my lord, your lordship directed the appellants to do all these things, my lord.
Appellants?
Yes, my lord.
Acha, the article line at the order dated March 11, 2025 further stands modified to the effect that the appellant shall prepare the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Grateful.
Plaintiff,
Yes.
then lordship, money suit, dismiss ex parte, application for expeditious.
Solobana, you did not put it.
Yes, it was deposited 1st April 2025
What is the application for?
for direction for expeditious.
Your money suit was dismissed. Learned counsel for the appellant submits that the appellant has deposited the Tolobana on April 1, 2025. Full stop. The office shall furnish a fresh report in that regard. Next para, furnish a revised report in that regard. Full stop. The present appeal arises out of the dismissal of a money suit filed by the plaintiff appellant. Full stop. Since the present application bearing can 1 of 2025 is one for expeditious hearing of the appeal, comma, prior service of notice of the same on the respondent is deemed unnecessary and dispensed with. Full stop. Can 1 of 2025 is accordingly disposed of by directing the appellant to put in the requisites for service of notice of appeal on the respondent at all the addresses of the respondent as shown in the cause title of the memorandum of appeal and the application. For sub next para, the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the trial court records on the learned advocate for the appellant, who sub liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Yes.
For the appellant wife, who was the respondent in the suit in the trial court below, my lord. Pursuant to lordship's direction of 12th March 2025, my lord, we attempted to serve, my lord, at the two addresses disclosed in the, my lord, plaint.
This is against a divorce decree?
Divorce decree, my lord, at the instance of the husband.
We passed an ad interim order.
Your lordship, my lord, passed an order that he cannot remarry. On 12th of March 2025.
Till disposal of the application.
Of the application.
Could not be served. Why?
Both the addresses disclosed in the plaint, my lord, both have come back, my lord. One has come back, the other says cannot be traced. The track report. One is his residential address, the other is, my lord, the Reserve Bank staff quarter. He's an employee of the Reserve Bank.
What is your instruction? He's still working there?
He's working under Reserve Bank, same staff quarter. That is, my lord, the instruction. I'll be not paying leave, my lord, to take out an application for under Order 5 Rule 20, my lord, for substituted service, my lord, because otherwise.
Affidavits of service filed to be kept on record. So it transpires that. No, but when was the decree passed?
Decree passed, my lord,
this is his address in the decree.
Yes, 6 December 2024, my lord. This is the address in the plaint and the decree. Not traceable. That is why.
No, we'll deem good service and dispose of the injunction, but put in requisites for service of notice of the appeal.
That has been put in, my lord.
Has been put in.
Solovana and written up notice have been, my lord, put in.
Very well. Affidavit of service filed to be kept on record. So it transpires that proper service could not be effected on the respondent husband. What is this able? What is this?
I have never seen this endorsement, my lord.
Sub next para, the endorsement on the postal endorsement on the envelope sought to be sent to the husband is not decipherable. Not decipherable. Full stop. The track report indicates that the item has been kept on hold since the addressee could not be located.
That is regarding not the residential address. The
Full stop. Next para. However, comma, as rightly submitted by learned counsel for the appellant, comma, the service was sought to be effected at the addresses of the husband as disclosed in the respondent husband's plaint in the court below and also finds place in the impugned decree. Full stop. Next para. In the absence of any intimation by the husband of any change of such address throughout the suit, comma, we deem that proper service of the application has been effected on the husband and the respondent husband is deliberately avoiding service. Full stop. Accordingly, we take up the application for disposal. Full stop. In view of sufficient prima facie case having been made out for hearing of the appeal, comma, which is against this decree of divorce, comma, can 1 of 2025 is allowed, comma, thereby granting injunction restraining the respondent husband from what was the language is contracting remarriage or remarrying, from contracting any remarriage, comma, if not already contracted during pendency of the appeal. There will be no arrest to cost. The appellant shall put in due requisites for service of notice of appeal on the respondent within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
I am for the appellant.
Yes.
May I file the affidavit of service?
That it? Or that appeal was, in appeal it was reversed.
Yes.
The injunction, and that was the
The
payment.
injunction your lordship had disposed of by allowing the appeal. This is from the order 40 refusal. Lord, your lordship will see there are 10 defendants.
You had filed an injunction application also in connection with this.
Yes.
So that you have disposed of.
No, no.
Your
Your
In connection with this appeal, there was no injunction.
No, no.
But appointing a receiver would be tantamount to allowing the appeal.
Lord, your lordship had on the earlier occasion of 11th March had directed for a fresh service. We had served. We were only able to successfully serve respond numbers 1, 2, and 8. The others are unclaimed, refused, addressee moved in some.
Addressee moved is not good service. Unclaimed is good service.
Yes. Lord, addressee moved are respond number 5, 7, and 10. Lord, 5, 7, and 10 were never appearing in the trial court till date. And we had taken out a application for paper publication, which was
The
allowed.
suit is for what? Partition?
Suit is for injunction, only injunction.
Suit for permanent injunction.
Permanent.
But the relief sought in the suit is the receiver relief is more than the main relief.
Yes, because your lordship will recall, your lordship by an order date of February had disposed of a similar matter refusal from order 39-1-2. Your lordship had allowed that. What is the nature of injunction that we had sought was the defendants not to interfere with our construction of boundary wall in the suit property. This application of receiver's application, this order 40 is only in aid of that. We'll kindly take.
Receiver appointment, what will the receiver do? What is the scope
That
of?
is what, that is
Yes.
what. Lord, we'll kindly take. The straight away the receiver's application, 382 page number. At page 409. Is it your lordship's pleasure? May
Yes.
I take your lordship to the allowing of the injunction application by your lordship?
Receiver will construct a boundary wall.
Yes.
Receiver will be a mason.
Lord, this is because
Then we have to appoint a good mason as receiver.
Lord, this
You
is
have asked the receiver to construct a boundary
Yes.
wall, not to supervise. The receiver, if the receiver has to construct a boundary wall, one
It is an
receiver
error
won't
on
do.
our part, my lord.
And we'll direct you to pay commensurate with an advocate of this court. The masons will have to be paid.
Lord, that
They'll
is
get
a-
some income, good
That
income.
is
at
an
least.
error on
Once
our
in a-
part, my lord. My lord,
For this, receiver is not required. Police
Lord, it is.
take out a police help application in the court below.
I'll
Receiver will do what? Stand there
lordship
throughout
will
the day and
kindly
see.
take your lordship's order of 3 at page 352, my lord.
352.
Yes.
We'll modify that order also then.
No, no.
We have said that. But receiver cannot stand there throughout the day and you
Since
construct the wall and
I
he'll
will
see.
show documents since 2022 repeated
You
police
you have any vengeance against any of your members of the bar, then just point him out and I will appoint him a receiver.
complaints.
We'll compensate by money, but he'll have to stand
this
throughout the
is
day and
because-
watch the masons construct the wall.
This is because
What
I'll
sort of
tell
an
your
app-
lordship.
Yes.
This order of your lordship at 352
Hmm.
was allowing the petitioner, the appellant, to construct a boundary wall. Lord, there has been several interim reliefs beforehand also. We have tried several times and I have annexed documents. Several instances we had tried to appoint a surveyor, we had tried to appoint the measure the physically the suit property. We had tremendous resistance and we were in any event we were unable. We had filed several police complaints since 2021 onwards. But it is physically impossible for me or a contractor appointed by the appellant to physically go to the site, measure and construct a boundary wall.
You
Let
will
alone
give you liberty to seek police help in the court. Receiver cannot. What will a receiver do? The receiver will stand there throughout the day and watch you make the construct the boundary wall.
Receiver is an officer of court. Let him be appointed.
That is why you are more sensitive
Let
on
him
that.
be appointed and the
What will be
entire-
the exact job of the receiver? He'll stand there throughout the day.
He will supervise the measurement and construction of the boundary wall. And if your lordship
Not a job
permits,
of a
your
receiver.
lordship has enough discretion to direct the police for assistance, my lord, of the receiver.
Make
not
that
for-
application in the code below. Why a receiver? We are putting in a receiver in the middle of it.
my lord, in that case,
You will
my lord,
construct and we'll give you liberty. We'll dispose of the appeal.
my lord, in that
We'll
case,
say
my
that
lord,
we are giving you liberty to
my lord,
perform.
only in that case, if it is commencing your lordship, may I come back another day because I'm led by Mr. Gupta.
Which
Mr.
Mr.
Chavan
Gupta?
But will kindly give me 1 day's time. He's on legs in courtroom number 26, I'm informed.
See, but we cannot take up the appeal for final hearing. If you agree only, then we'll dispose of the appeal. But then we'll have to dismiss the appeal, and we can dismiss the appeal and say that we are giving you liberty. Express this to Mr. Gupta. Or we can just dispose of this application saying that there is no scope of appointment of a receiver. If you dispose of this application, because as yet all the respondents have not been served,
Yes.
and regarding the appeal, they have not been served at all. So you take instructions also from your client what you will do, because we shall reject this application saying that no case for receiver has been made out, but you can seek police help in the court bill. If you do that, that will be tantamount. You can then withdraw the appeal also probably on that premise.
Gives
Take
me 1
instruction and
day's-
come back. We'll keep it on Monday.
Very well. I'm so good.
Affidavit of service filed today be kept on record. Full-stop. It transpires that insofar as respondent numbers 5, 7, and 10, 5, 7, and 10, that
They had never appeared in the trial.
5,
court.
7, and 10 is concerned, proper service has not been effected on them. Full-stop. But no, they have not appeared. This will be premature to say that. We'll have to serve them again.
Well, we had made a paper publication
In the trial
application.
court?
Yes, which
Very
was
well.
allowed.
It is
but thereafter-
submitted that despite substituted service being effected in the trial court, the said respondents did not appear in the court below as well. Hence, we dispense with service of further notice on the said respondents. Next para. At this juncture, on the prayer of learned counsel for the appellant, the matter is adjourned till April 7, 2025. We are not giving the reasons. Take instructions, come back.
I'm so grateful.
We can dismiss the appeal at this stage without hearing the respondent. But we cannot, pass any other order in the appeal. If you agree to that, we can take up the appeal and dismiss it, but granting you that liberty. We'll give our reasons also. Mr. Gupta is there. Tell him. Mr. Gupta, we were thinking this, that receiver we are not inclined to, because receiver, an officer of the court, cannot stand there the whole day and watch you make your walls. We'll dismiss this application. We'll say receiver is disproportionate relief vis-a-vis whatever cause of action you have made, and we'll give you liberty to seek police help in the court below for implementing this our order of injunction. That you can make construction, police will be there. You can want a police picket also, you have to pay for that.
Instead of indicating that we can file an application for police help, in this application, there
No.
in this application there is police. So if your lordship deems it so fit, to confine your lordship's order to that.
No, for that you have to approach the trial court. It's
Because the whole application was
just merged in the trial court.
Yes,
Yes, the appeal will dismiss the appeal itself.
because the whole application
The appeal is against receiver.
press in the receiver's application, then
That prayer was already.
No, if you allow the appeal, we cannot dispose it of. You have to wait for the.
no, if your lordship kindly sees the prayers once in the order 40 application, there I have specifically claimed for the police help. So if your lordship restricts your lordship's order, then we do
In
not.
the trial court, in your receiver application, you have asked the receiver to construct the wall.
No,
Look,
but I have,
page 409. Look at page 409.
but I am not on that.
You are on
prayer.
that only.
I'm
We
not
can.
on that prayer. I'm on the other prayer where I have prayed for a
What is
police
that? Read out that prayer.
Page 410. In the event the learned receiver finds that the assistance of the Uluberia police station inadequate and ineffective, the learned receiver.
That is for assisting the receiver. That is a different prayer.
Problem is the practical difficulty which we are facing is we are unable to do anything.
Take police help before the court below. We'll dispose of the appeal itself here.
Could I come back on Tuesday instead of Monday?
No, Monday.
Monday there's a Tuesday, my lord, instead of Monday.
Monday what? Another holiday?
No, no, not a holiday.
He's joining on Monday.
No, no, no.
What will happen on Monday?
There's a fixed matter which is there, my lord, might get stuck. That is why my
তাহলে
lord, I
ওটা
was humbly
রিটার্নেবল
beseeching.
ডেট যেটা বললাম ওটা
Instead of
7
Monday.
না করে 8 করে দিন।
I'm so
এপ্রিল 8। Yes.
That my appeal, my lord. Injunction granted in a suit which I say, my lord, is infructuous, and where, my lord, no decree could ever be made.
Appeal along with the application.
Yes, yes.
Mr. Doctor is for the other side.
Yes.
Yes, you have heavyweights against you.
Very heavy.
But then, my lord, his one thing is heavier than ours. But that's it. That's all.
Yes, Mr. Chaudhary.
Yes, my lord. The suit for diverse reliefs in respect of a property which had been given, my lord, on lease. And I'll just indicate, my lord, the way, my lord, the leases happened and then come to the
That
plain.
matter, that hold.
No, I read up more, my lord, and I read your lordship's judgment, and I think what I said was not correct. Concurrent leases are impermissible. However, this is, my lord, not a concurrent lease, and your lordship has said what would be a concurrent
Starts
lease
from a
also.
subsequent date. So in your case,
It starts, my lord, from a subsequent date, and, my lord, possession is not, my lord, interfered with the lease without possession by a registered instrument. So, my lord, it will not be.
there are judgments probably which say that without handing over possession, there cannot
That
be
your
creation of.
lordship has, those are unregistered documents. That's the distinction your lordship, my lord, made.
That was made in some other matter or this matter.
Other matter. Other matter.
So the facts are exactly the same.
No, no, my lord. This has an additional interesting question. That is, my lord, what had happened was, my lord, trust, my lord, is the owner of the property.
Let us start with the first things first. I mean, they have filed this suit for what? What is the primary relief?
Recovery of possession from somebody else.
So you got yourself added in the suit?
No, no. I am also made a defendant. My lord, my first argument would be, my lord, let me explain, my lord, who the parties are. Kindly, my lord, take the plaint at page 46.
Yes.
My lord, Webel.
You are Charu Diesels.
I am Charu Diesel.
Yes.
I am, my lord, 226. 225.
225. Yes.
225. I'm sorry, my lord.
Right.
225. My lord, plaintiff is, my lord, a sublessee in respect of a property. Plaintiff, my lord, had, after, my lord, sublease in its favor, granted further sublease, my lord, or tenancy.
Who
to,
are
my
you?
lord, the
You are the
defendant
lessor.
number 6.
You are the superior landlord.
I have now got a fresh lease from the owner.
Who was the original owner?
The owner, my lord.
Oh, the owner is not a party yet.
Who has not been, the trust has not been made a party.
That's right.
My lord, lease granted in my favor. My lord, may I just explain?
Yes.
6, my lord. So, my lord, the trust, under the trust, my lord, on 7th of January 1961. The trust, my lord, I have not examined. Jagannath Ju.
Trust is a party.
No, trust is not a party to the suit.
Devotist.
Devotist estate. So, my lord, trust on 7th of January 1961 creates a lease in favor of, my lord, Orient Properties Private Limited for 58 years. This is in respect of 225 B and C AJC Bose Road, which is subsequently, my lord, renumbered as 225 C, D, E, and F. Orient Properties, my lord, and lease is with effect from 12th of May 1961. Registered instrument, page 145 of the compilation.
There's a separate compilation also.
Yes, yes. May not be prepared for both appeals. For this appeal.
What is the other appeal?
The next matter, Milord.
What is that against?
Similar, Milord matter. Similar matter.
Extension?
Different floors of the same property. Now what happens, Milord, is
No, that's in respect of a different suit.
different
Heard analogously.
different suit. Different suit, I am told, Milord, same questions are involved. And Milord, prima facie proof, Milord, is that neither am I briefed nor I believe is Mr. Dotto briefed.
That's what I was inquiring about.
So, Milord, this is prima facie proof that everything is similar.
I have made myself available for that matter. So he is only entitled to charge 2 fees. All of us want.
Yes.
Now, Milord, 7th January 1961
Hmm.
is Milord the lease by the trust to Milord Orient Properties.
58 years, yes.
Yes.
With effect
Then
from 12th of May.
12th of May 1961.
Hmm.
Then 14th September 1970, Orient Properties gives a sublease to Gauri Saria for 47 years. This is not page 163 of the compilation. I don't think, Milord, I should place these documents before your lordship. It will not be necessary. Then 25th of May 1972, Gauri Saria grants a sublease to the plaintiff for 45 years with effect from 10th of February 1972. This is, Milord, in respect of 225F, AJC Bose Road, and page 184 of the compilation. Plaintiff on 1st December 1981 inducts Sun Enterprises as a monthly tenant. On 1st December 1996, I'm sorry, Milord, I missed something. Sun Enterprises subsequently inducts Milord WHON'BLE, the defendant number 6. No, this is 6 is, I believe it's same thing. Defendant number 6. 1st December 1996, WHON'BLE becomes a direct tenant under, Milord, the plaintiff.
WHON'BLE is, I mean, how does WHON'BLE come in?
Milord, WHON'BLE has been, Milord, inducted by Sun Enterprises.
Defendant number 6 is WHON'BLE.
6 is, Milord, WHON'BLE.
Yes. How does it become a direct tenant?
Milord, the document, Milord.
Direct tenant under whom? The trust?
Under, Milord, the plaintiff.
Achha.
The document, Milord, is at page 204 of the compilation. And it's a document, Milord, issued by WHON'BLE to Milord Sun Enterprises, etc. Then, Milord, 9th of February 2019, the plaintiff's lease, Milord, lease in favor of the plaintiff expires. This is a lease which had been granted on 25th May 1972 by Gauri Saria for 45 years with effect from 10th February 1972 at page 225. This, Milord, expires on
Page 225, not 184.
Milord, 184
was Gauri
is,
Saria
Milord,
to plaintiff lease.
Yes, yes, yes. I'm sorry, Milord, 184. I was wrong. 225F is the address which I, Milord, misread. Milord, this expires.
Yes.
On, Milord, 9th February 19. On 11th of May 19, the head lease, Milord, expires from the trust to Orient Properties for 58 years. So, Milord, all leases, Milord, expire. Situation, Milord, is whoever is in possession is a trespasser. Milord, trust is the owner of the property. There's no, my lord, proof, no case of, my lord, any rent being accepted thereafter. After this, my lord, so this is 9th February, plaintiff's lease expires, 11th May, trust's lease expires. After this, on 6th February 2020, by a registered instrument.
Sorry, please, 5th?
6th of February 2020,
Yes.
by a registered instrument, trust creates lease for 29 years in favor of the appellant. Before your lordship, my lord.
Appellant
That's
was
different numbers 2 to 5. My lord, this is at page 101 of the stay petition, first volume. I want your lordship to see one clause, my lord. 101 at 106, my lord, clause 8.
Yes, clause 8.
The said Orient Beverages, in terms of the indenture of lease dated 7th January 61, inducted several sublessees to occupy various portions of the premises. The said lease expired on 11th May 2019, and the rights of Orient Beverages Limited and all the sublessees under Orient Beverages Limited stood determined with effect from 11th May 2009. However, premises number 225F AJC Bose Road is still under possession and occupation of unauthorized persons claiming to be subtenants or under Orient Beverages Limited. In the aforesaid premises, the trust estate of Sri Sri Jagannath Jew, the lessors, became the owner of all that piece and parcel such and such. Then, pursuant to negotiations, lessors and lessees have agreed to grant, and the lessee has agreed to take on lease for a period of 29 years, etc.
The rents were all above this 97 at ceiling.
Yes.
Where?
Lord, this rent under this, my lord. Not, my lord,
Not the
rent
previous ones.
Not the previous one.
But
But I'll still
in
get
some
out.
cases, monthly tenancies were created and all. Although, yes, definitely you can say, but that they cannot get better right than their.
Once the lease expires, everybody becomes a
There's some
12%.
complication will be created.
No, my lord, I'll show you. Your lordship, my lord, has considered this also previously. Then, my lord, paragraph 6. It will not be.
Paragraph
not
6.
Clause 6. Clause 6 at, my lord, page 8. Internal page 8, page 109 of the stay petition. It will not be the responsibility of the lessors to deliver vacant possession of the demised premises to the lessee. The lessors on this day have delivered symbolic possession of the demised premises to the lessee, and lessors shall not have any obligation to hand over actual and physical physical possession of the demised premises.
And
to
this
the
was a
lessee.
registered deed.
Registered lease.
That was the point of distinction of 107, delivery of possession. All right.
So, my lord, registered lease.
Yes.
Now, my lord, the important thing is after this, if WebL has handed over physical possession on 13th May 2021 at page 13th April 2021 at page 148
of the stay.
Yes. Lord, please see the document once. It's very clear. The name of WebL has changed. We keep saying WebL, Lord, it's West Bengal Industry Development Corporation now. So
the defendant 6.
Defendant number 6. My lord, we, WebL, or in its new name, have delivered quiet, peaceful, and vacant possession of the suit premises on this day of such and such. It is confirmed by Charu Diesel LLP that there is no outstanding rent, etc., etc. in future. signed by my lord Webel, signed by my lord Charu Diesel, the appellant before your lordship. This is not 13th April 2021. So, my lord, if I look up, my lord, who's giving me, I've got a lease from, my lord, the trust, the admitted owner of the property. Admitted position is all leases have expired. Admitted position is trespassers in possession. I shouldn't say admitted position. That will be the contested issue. Other persons in occupation, but I get a lease from the owner of the property, and then, my lord, I get possession from, my lord, the person in occupation. This is, my lord, in 2021.
So here there is the question of concurrent lease as such. No question of concurrent lease, and even if they would be perhaps we don't know claiming, if they claim monthly tenancy under the
Yes, they are
Rent
claiming
Control
monthly
Act,
tenancy.
Rent Control Act, then also there cannot be any concurrence in that because that's a statutory tenancy, which they'll have to answer.
Yes, they'll have to answer, and I would submit, my lord, I'm going to hit at my lord, the root of the matter. My lord, they cannot claim to be monthly tenants in a situation like this, and that's decided by this honorable court. After the 1997 Premises Tenancy Act came into force, my lord, lease expires, registered lease over 20 years expires. You can't claim to be, my lord, a monthly tenancy after expiry of lease. If, my lord, I had accepted, or my lord, anybody had accepted rent, owner had accepted or I had accepted, possible. Otherwise, no.
Who claims monthly tenancy? Plaintiff.
Plaintiff claims. After the expiry of lease, he says, I'm a monthly tenant.
Achha.
And I'll, my lord, show your lordship, my lord.
But there was acceptance of rent by Orient after that. Gaurisaria, sorry, Gaurisaria.
There's no such case made out.
All right.
And so that would also be an ineffective case because Gaurisaria himself has no right in the property. Net rent paid, my lord, to a trespasser cannot give you any right. You are also a trespasser.
No, once a transfer property act lease is created, then probably you have a good case that it cannot automatically get converted to a monthly tenancy by after expiry. Then in every case there would be no case of expiry of lease.
My lord, we found the judgment. Last night I tried to read and understand why. Couldn't. Became fuzzy. Now, this morning both of us.
Fuzzy because you're sleepy or due to the judgment?
That's it.
Both reasons. I always get sleepy, particularly when I correct and sign my orders, say around 5:30, 6 in the evening. I mean,
that is
everything becomes
time.
fuzzy.
That is a very bad time.
My logic becomes fuzzy, and there are certain products of that which come up as to be mentioned for correction.
Just couldn't understand that yesterday night. So this morning, my lord, we sat and analyzed it, and I think, my lord, we have the logic behind the division bench judgment.
Fuzzy logic is scientific. I mean, it's a scientific theory.
So, my lord, therefore, three things, my lord.
Yes.
And, my lord, just one more fact before any of this, my lord, begins. 9th of November, and this is very important, 9th of November 2021, the plaintiff is aware that Charu Diesels has obtained possession from Webel. So the fact that I have entered possession, plaintiff is
Charu means defendants 2 to 6.
Yes, defendant numbers 2 to 6 have obtained possession from defendant number 1. Plaintiff is aware from 9th November 2021. This is because in another suit in respect of the same property, another floor, matter had come up in appeal. In my lord, written objection to the appeal, I had disclosed this document and served the written objection upon them on 9th of November 2021.
These same set of facts apply to all these flats, all these
apart from the last bit of taking possession, etc. Same set of facts.
So same parties obtained possession of all these flats.
But I have got the lease in respect of the whole building.
Oh, right. So you cover everything.
Yes. So, my lord, I obtained, so I did, so they are aware of the fact that I am in possession. Then, my lord, they come and file this suit. Now, my first argument is that this suit, my lord, is ineffective and no interim order can be granted in this suit because it's really infructuous. My lord, please have a look at the prayers. In the plain starts at 46,
Page 60.
prayers at page 60.
Yes. We are there only. So deliver a first person.
Yes. Against whom? Okay, defendant number 1. I'll read it out. Prayer B.
One has already handed over to you.
Yes, and to their knowledge. Number 1. Number 2. Decree for mean profit against defendant number 1.
Yes.
Then C, my lord. I'm sorry, C is mean profit. D, decree for recovery of arrear monthly rental. Then money decree. The D and E are essentially against 1. Now F and G, my lord, cover me. Decree for perpetual injunction restraining the defendants from dealing with and disposing of or creating any third party interest in respect of the suit property detailed in the schedule of the plain and or parting with possession is prayer G. So, my lord, the only relief against me is, my lord, parting with possession and not alienation. There is no relief in respect of, my lord, recovery of possession from me.
In the plaint, how do you come in? Do they treat you as licensees of?
Yes. Paragraph 22 to 21 to 25, I want to show your lordship. Correct. By 21 is?
Yes.
Surprisingly, by letter dated such and such, subsidiary company of the defendant number 1 called upon the plaintiff asking for refund as security deposit in respect of the separate tenancy on the 4th floor of the property by referring to a letter issued by defendant number 2 on 22nd June. Upon perusal of the said letter issued by Charu Diesels, defendant number 2, and after obtaining certified copy of the deed of lease dated 6 February 2020, it transpires that purportedly a deed of lease has been executed by the trust of such and such in its favor on 6 February 2020 for a period of 29 years, 29 years in respect of the self-same property on as is where is basis, and the defendant number 2, Charu Diesel, is claiming purported rights in respect of the said property and has offered the defendant number 1 to enter into an arrangement in respect of this portion of the properties under occupation, including the suit property. So he knows of, my lord, the lease. Then the plaintiff was shocked to know about the same. Said lease is a collusive document and is otherwise void, illegal, bad in law, and not binding on the plaintiff. No relief paid for in the suit. The plaintiff has subsequently challenged the said lease of such and such in 2 separate proceedings when defendant number 2, Charu Diesel, attempted to take over possession from other tenants under the plaintiff on the dint of the said purported lease. Presently, there are subsisting orders of injunction in respect of suit properties mentioned therein, such and such. Then, paragraph 24. During the course of hearing of the injunction application filed in title suit number 962 and 963, the plaintiff was served with copies of purported written objection by the defendant numbers 2 to 5, said Charu Diesel and others. Upon perusal of a document annexed to the said objection, being a document purportedly executed on 13th April 2021, it transpired that the defendant number 1 claimed to have allegedly surrendered the suit property to the defendant number 2, said Charu Diesel. There being no privity of contract between defendant number 1 and the defendant number 2, said Charu Diesel, the property could not have been handed over to Charu Diesel, defendant number 2, and is of no significance.
Yes. How does the defendant number 1 come in? You all along your case was defendant number 6 as you submitted.
1 and 6 are, my lord,
6 is subsidiary of 1.
Yes.
That
1
they have
and 6
stated.
are the same. Yes. So, my lord, 1 and 6
But six is a different entity, separate juristic entity.
Yes. Yes.
And this lease deed was executed in favor of six.
Lease deed.
I mean, rather six executed in favor of you.
No, in favor of me, Milord, trust has executed. The owner.
Sorry, six has handed over possession to you.
Six has handed over possession.
So they treat one and six on a similar
is one
footing.
entity. One entity. Now the fact of the matter is that possession has been handed over to me. And there is no prayer, my lord, for eviction against me. There is no relief of declaration that handing over of possession in my favor is void or ineffective or of no significance, as he calls it. In the absence of this,
So the lease deed, no declaration has been claimed that your lease deed
in
is.
this plaint, in other plaint, he has challenged the lease. Not here. In other suits, he has challenged 962, 963. That's what he is mentioned in 23, 22. But what is material is, let us look at this suit. If he succeeds in this suit, he will never get possession from me. Because his relief of possession is against Milord defend number 1 and 6. He's pleaded 1, 6 is Milord bound, pro forma. So this is Milord an improperly formed suit where
And nowhere in the plaint they claim that you are a licensee under 6 or something like that.
No.
Because
in fact, my lord,
they
in the
could not be
plaint,
constructive possession of 6 through you.
no, my lord.
On one
on
through
the
you.
other hand, they plead my lease.
Yes,
And they
they
say
plead your
it's
lease.
bad. So they admit I am, my lord, from the owner.
So you are independently, as per the plaint also, your plaint also, your status has not been described. Independently a trespasser, illegal
No, they
occupant.
say, my lord,
Why do they say that?
in the plaint, my status, qua title,
Yes.
they say is bad because I have obtained title from the owner by an ineffective document which is under challenge in other suits. This is their pleading in paragraph 21, 23.
Mm.
22.
Yes. But your possession has not
As
been
regards possession, is paragraph 24. They say that I have received possession,
Yes.
but that is of no significance. My lord, this handing over of possession in my favor, which allegedly is of no significance, is not under challenge because there is no declaration also sought for, despite the fact that the document is in their possession, which they admit. Plus, there is no decree for eviction sought against me. So, in this suit, if I, my lord, when I am in actual physical possession, and despite knowing that when you don't claim eviction against me, you can't claim any other relief. No relief of injunction would be possible. That's my first point. I'll come back at 2 p.m. Thanks for the
Yes.
My lord, to recapitulate, I had said, my lord, that the suit is really infructuous because I am in physical possession under and pursuant to a handing over from the defend numbers 1 and 6.
Yes.
Neither is the handing over under challenge because there is no relief prayed for in respect of the same, nor is, my lord, a suit for a relief of eviction sought against me. So, my lord, it's an ineffective suit, and plaintiff, my lord, does not disclose any cause of action, and no relief can be, my lord, claimed against me. That's, my lord, my first point. My second point, my lord, is in a situation like this, when there are complicated issues involved, no suit for injunction, my lord, lies. You have to have the status declared by declaratory relief. Not just one judgment, not more technical than anything else, but there is some logic, my lord, involved. When there are issues of complicated questions of fact and law relating to title, court, my lord, does not entertain a suit simpliciter for injunction, but rather relegates parties to remedy by way of a comprehensive suit for declaration of title instead of deciding the matter on a suit for mere injunction. Just, my lord, one judgment, my lord, if I may cite, 2021 SCC Online Supreme Court, page 675. 20 copy দাও, other side copy দাও। আচ্ছা তো Milord, the question, Milord, I'll just, Milord, restrict myself to the question of law. This was not identification of the property was in doubt, etc. Title was in doubt. Milord, please see paragraph 10 of this judgment.
Yes.
The short question which falls for consideration before us is whether the learned single judge of the High Court was right in holding that the suit simpliciter for permanent injunction without claiming declaration of title as filed by the plaintiff was not maintainable. Issue is no more res integra. The position has been crystallized by this court in the case of Anathula Sudhakar in paragraph 21, which reads thus: to summarize the position in regard to suits for prohibitory injunction relating to immovable properties as under, where a cloud is raised over the plaintiff's title and he does not have possession, a suit for declaration and possession with or without consequential injunction is the remedy. Where the plaintiff's title is not in, I'm on that first part. Where plaintiff's title is not in dispute or under a cloud and he is out of possession, he has to sue for possession with a consequential injunction. Where there is merely an interference with the plaintiff's lawful possession or threat of dispossession, it is sufficient to sue for an injunction simpliciter. So, my lord, here against me is injunction simpliciter. His title is in issue. He is not in possession. He has to ask for possession. He has to ask for a declaration of his title. Now, this is, and paragraph 12, my lord. This actually, my lord, goes on to support.
Up to para 13,
yes,
whatever you are saying.
yes. Now, my lord, next is plaintiff is a trespasser, according to me.
Trespasser after expiry of the lease.
After expiry of the lease, my lord, everybody, my lord, who was in possession was a trespasser. Plaintiff is not even in possession. So, my lord, I really shouldn't be calling him a trespasser. He's no one. his possessory right, my lord, which he claims
You said the plaintiff has the locus standi in view of his lease having been expired.
having
The
expired.
mother did also.
Yes. And my lord, the pleading is, my lord, kindly see the pleading once in the plaint. That paragraph 9 of the plaint at page 50.
Paragraph?
9 of the plaint, my lord. 8 and 9 of the plaint at page 50.
Yes.
The plaintiff has been all along paying the monthly rental to the said Ram Narayan Gauri Saria and or his legal heirs. 8, my lord. Paragraph 9 is,
yes, right.
Plaintiff continued to remain a tenant in respect of the said premises. Plaintiff's right of protection against eviction was now being governed and continues to be governed by the Premises Tenancy Act 1997. The plaintiff has paid and is continuing to pay rent to the successor in interest of R.N. Gauri Saria, and rent is being accepted without demand. That's of no avail. My lord, plaintiff, my lord, let's look at the situation. 1972 lease deed of the plaintiff has expired. This is from Gauri Saria. It has expired. Now, Gauri Saria, an important matter is, my lord, his lease expired on 9th February 2019. Now, upon expiry of his lease, what is the position? Plaintiff is not governed by West Bengal Premises Tenancy Act. Upon expiry of lease, Lord, may I just cite one judgment, if your lordship permits? Yes. Correct. They amake judgment আছে Oh, Shivaji Mitra. Lordship does not really need to go into this question perhaps, because Gauri Saria's lease has also expired. So everybody is a, if he is a trespasser, he is accepting rent, my lord, will be of no avail. This discusses in detail after submissions are considered, my lord, from paragraph 22. Judgment is difficult to understand. And after this situation, has it been satisfied? Lordship has differed from Shivaji Mitra.
I don't know.
I am not aware. You follow I am not aware.
No, I'm very prone to differing from myself also. No difficult.
Yes, it is possible.
If you can convince me, definitely I'll
That is
differ.
quite
I'll
possible.
say that is not good law in view of Shivaji.
It is possible.
Yes. I've held my own judgment to be par incurium also. One component of my judgment. So no
It is
difficult.
also possible. And there is no.
Convince me on that and we'll do that.
Yes. No, I was yesterday. This is the one which I was reading yesterday.
This is a difficult
night.
judgment.
Yes, I
Fuzzy logic.
wasn't very clear on the reason. Judgment is on the point, and I didn't know your lordship had referred it. But
sometimes, if the appearances were given, the reasons would become more clear.
No, this is Mr. Anindya Mitra.
Oh. No, we don't know. I mean, the appearances.
Mitra, I know this, my lord.
What is the law? I mean, fuzzy.
Lord,
Where is
so fuzzy affair, my lord, is
which paragraph?
My lord, if your lordship sees the conclusion.
Yes.
Paragraph 25. And then, my lord, consideration and opinion is in paragraph 29. We are of the opinion, if I'm reading paragraph 29, in those cases where the lease expired by efflux of time, but the lease is continuing, but the lessee is continuing in possession, he or she would not come within the purview of the definition of a tenant under section 2G of the Act of 1997. The first point is answered in the negative. I tried to, my lord, in fact, tried to analyze the findings paragraph by paragraph to see where it
So what
was
is the
going.
ratio of this opinion?
Issue of the opinion is that if a lease expires, say for example, my lord, my lease has expired today. Registered lease executed before, maybe a 99 years lease or a 50-year lease. Before the 96 Act came into operation, my lease rent was 500 rupees or 1000 rupees. Or
One logic the obvious logic is that if it's initially a tenancy under the Transfer Property Act, it does not automatically get converted into a premises tenancy act.
And, my lord, apropos to develop that further, my lord, if your lordship permits me to say a proposition, a contractual right can be abrogated or altered by a statute, but only expressly.
Yes.
Here, my lord, if your lordship sees the 97 Act, nothing, my lord, really abrogates the contractual right, my lord, which a lessee
97 Act confers certain additional cloaks of protection to a person who is in possession in the capacity of a tenant by making him or her a statutory tenant.
Yes.
So the expression is statutory tenant.
Yes.
Now, the statutory tenancy has to be from the inception.
Yes.
That can be
here, my lord, lease.
It was a lease.
It was a
under
lease
Transfer
from the
Property Act all
inception.
along.
It was a lease from the inception. So
But
that's one reason.
They
but
may claim that it was a monthly tenancy from the inception.
no, the lease deed is on record, my lord. Lease I've shown your lordship, page
No,
184.
on a construction of section 107 of the Transfer Property Act, it has been held by courts that if it's not a registered lease deed, it can be considered as a monthly tenancy.
Yes.
If it's considered as a monthly tenancy, why shouldn't the Rent Control Act apply?
No, my lord, this is a lease. Gauri Saria to plaintiff is a lease.
Registered lease.
Yes. 25th of May, 1972, page 184 of the compilation.
That legal fiction cannot be accommodated here.
Yes.
So this
And, my lord,
Gauri Saria's lease was 25th of
5th
May.
of May 1972.
So that was also
45 years.
registered.
Registered lease.
All right.
And, my lord, strangely enough, it's legible also. All the other registered.
The deed.
The
Lease
deed.
deed.
The other ones, my lord, are not legible.
The important ones are legible. The important portion.
This one is legible. So, my lord, that's my argument that it could never really be, because it started off under the Transfer of Property Act. So, therefore, upon its expiry, suddenly, my lord, character cannot change.
So that appears to be logical. I mean,
And 108Q of the Transfer of Property Act.
what is that?
The obligation on the part of the
No, 108, those follow only if it's a lease under the
Yes.
Transfer Property Act.
Yes. But same principle, my lord, would apply here. Because this is a registered lease.
There could be different possible statuses of a person who is in possession after the efflux of expiry of lease by
Yes. If, my lord, for example, if it
maybe a
tenders rent,
trespasser or holding over, if there is a positive case made out and proved, it can be holding over also. But otherwise, it's, I mean, if it was at the inception not a statutory tenancy, then all on a sudden after the efflux of time expiry of lease, it may not be converted automatically to a statutory tenancy. You have a point there.
yes, and I don't want to, my lord,
But,
expand on that point
But
much.
if we have to consider this as a precedent, Mr. Chaudhary, you have to know the
No,
logic.
no, I am just
because this was the opinion expressed on what premise? I mean,
No, I am,
because a judgment, the ratio of a judgment is the logic of
but
it.
my lord, I couldn't understand
That
the
is-
issue.
Then I mean,
Lord, but
opinion
to be
it has
very
opinion value.
His single bench decision, paragraph 64.
copy I know. But I'll tell your lordship, I'll show your lordship's judgment. Your lordship has explained it. I'm told, my lord, I haven't read the judgment. I should have. But all that I want to say is, my lord, this is a position for less than 3 months. 9th of February 2019 is when his sublease expires. Plaintiff sublease expires. 11th of May 2019, the head lease expires. Thereafter, my lord, what he pays to Gauri Saria, if at all he pays anything, it becomes immaterial. Everybody becomes a trespasser.
That is also on the principle that one cannot transfer what more than one
You
better
have.
title than one has.
Yes.
That
So
also
when
proceed.
head lease expires on 11th May 19, what happens on 9th February 19, my lord, is irrelevant. But still, my lord, may I show your lordship a few paragraphs of this judgment? This is really, my lord, more academic than anything else, because after 11th May 19, whatever you have done, you're a trespasser. Even if Gauri Saria gives it to you in a certificate, my lord, drawn in blood, you'll still remain, my lord, a trespasser. But, my lord, on the judgment, may I, my lord, section, my lord, paragraph 24, 23, my lord, 22 at page 5, we have considered the submissions made by learned counsel appearing for the parties. We are of the view that the questions which fall for consideration are A, whether defendant is a tenant within the meaning of the provisions of section 2G of the West Bengal Premises Tenancy Act, then whether application for summary judgment was entertainable, and the other ones are not relevant. Paragraph 23, we have set out the provision of the Act in extenso herein above. Before we proceed to answer the first question, advisable to notice provisions of repeal law and the object. Section 3 of the 56 Act is, Lord, it's quoted. Lord, Section 3, subsection 1A. Such lease has been entered into.
Those things are now gone.
Those things are now
Those
gone.
things are now gone. Only
So,
the rent ceiling is important.
Yes.
And government property and all
Yes,
those.
so that's what, my lord, is the finding, that earlier what was relevant is the expiry, I'm sorry, my lord, the determination, etc., etc. Now all that is irrelevant in view of the new section 3. That's what is said by paragraph 29. We are therefore of the opinion in those cases where the lease expired by efflux of time, but the lessee is continuing in possession, he or she would not come within the purview of the definition of a tenant under section 2G of the Act of 1997. The judgment in the case of Sham Charan does not really lend any assistance.
But Mr. Chaudhary, it could be equally, the opposite could equally be argued on this logic. Because para 25 says mere terminability of the lease is no longer the criteria.
Correct.
Criterion or whatever.
Correct.
So if that is not a criterion, then I mean,
Yeah,
converse could also be held. That's not a criterion now at all.
Milord, after
Previously that was important.
Shorn of, Milord, the judgment.
Milord,
let's look at the provision.
Yes.
Once 1997 Act comes in, what the situation is that if there is a long lease, registered long lease, it would continue to run its course, and upon its expiry, no matter what is, my lord, the rent in the registered lease, upon expiry of the lease, you immediately become a trespasser, because under section 108Q of the Transfer of Property Act, you are obliged to hand back possession to the landlord. This is position 1. And you continue as a tenant at sufferance or trespasser. Position 2 is, thereafter, if you pay rent to your landlord and that's accepted by the landlord, you become a monthly tenant by tender and acceptance of rent. If the rent is above 10,000 rupees, section 3 parameters of the Premises Tenancy Act would then apply. And that would determine whether you're tenant or whether you're not tenant. If your landlord never accepts rent from you, you can never be under the Premises Tenancy Act. That's my simple logic.
Tenancy Act 1997 West Bengal
Premises Tenancy Act with it.
we have got a copy ওনাকে একটা দিতে হবে এরকমই বই থাকবে এটা না একটা কারেন্ট বই আনিয়ে নেবেন হ্যাঁ 2018 এখন অনেক
That I have a copy.
So we have a copy, we'll just check for that. We hope there is no change after this.
একদম
Exactly.
Yes.
Kindly see section. I really couldn't, that's why I started with the caveat, my lord, that I couldn't understand.
By
Contra.
default, this act should apply. Section 3 carries the exemption.
Yes. So, my lord, after section 3, my lord, is what we see, my lord, on the basis of the quantum of
That is
rent.
why the logic appears to be contrary to the conclusion. Because if it is irrespective of tenure of tenancy now,
Yes.
tenure of lease,
Now,
then I mean,
yes, I agree with your lord completely, and your lordship has, my lord, considered this judgment, and your lordship has also held, if I may read, I've sent for the, I've sent for copies, my lord, I'll submit them. Paragraph 64 of that judgment.
Sitting singly?
Sitting singly.
What did I hold?
Thus, it is absolutely clear in the light of the judgment in Prakashvati Chopra Supra that the said judgment shed light on the grey area left open by the silence of the exemption clause in section 3C of the 1997 Act as to post 1997 Act lease deeds not containing any provision as to due consent of the tenant in that regard, and in respect of pre-1997 Act lease deed in general. The ratio clearly laid down in Prakashvati Chopra Supra was that only in cases where the lease was permitted to run its full life, the same would be governed by the 1882 Act. Otherwise, if an option was exercised for sooner determination of the lease than its normal tenure, the protection of the 1997 Act would be attracted. Only to those cases, my lord, the necessary rider is where, my lord, the 56
Here it
Act
ran its course in your case.
ran its course. Then I'll submit this.
Always.
And in any event,
probably in a somewhat different context. Sooner
Yes.
determination clause was, it fell for consideration there. Probably, what will be the effect if there is a sooner determination clause? Probably, I don't remember. I'll look into that. But that's a single bench judgment is not binding on us.
No.
But even then, we'll have to look into that if it deals with this particular context.
And again, my lord, I repeat that this is really an academic discussion, because whatever happened on 10th of February 2019, my lord, my lord, lost its force on 11th of May 2019, when the head lease, my lord, given by the
So,
trust.
Chaudhary, the difficulty for you will be if it's once it's decided to be a premises tenancy under the 97 Act or 56 Act, whatever, under the Rent Control Act, then this expiry of lease, this notion does not apply because they get the statutory protection of this statute. They become a statutory tenant.
Statutory tenant, question
But they
is-
have to be from the inception a statutory tenant. That's a good argument. You get liable to be evicted under a different statute.
No, my lord, I'll just.
And then you become a statutory tenant. That may be.
My lord, here, my lord, may I say this?
They have
My lord-
had to be monthly tenants from the beginning then.
My lord, my lord, subtenant, or in this place, my lord, the plaintiff, even let me assume him to be a statutory tenant.
Yes.
Under, my lord, his superior landlord.
Transfer property act din.
Yes.
Please carry on.
Under his superior landlord, he is a statutory tenant.
Yes.
Now, my lord, if his superior landlord goes to evict him, then, my lord, Premises Tenancy Act would apply. But if his superior landlord, my lord, has himself loses right in respect of the property, then, my lord, the owner of the property, when he goes to evict, my lord, he need not, my lord, treat the defendant really as a statutory tenant.
No, here there has been no eviction. He has not been evicted.
No.
According to him.
No.
If his statutory tenancy remained all along, there is no eviction scenario for him.
No.
Here.
Here, the question is, my lord, whether
if he remains a statutory tenant and if he is a statutory tenant and remains so, he remains so unless evicted under this Act, 97 Act. Then the concept of expiry of lease by efflux of time is not applicable to a statutory tenant.
Yes, but it can, cannot
For a
be.
statutory tenant, suppose there is a monthly tenancy created which comes within the purview of this Act.
Yes.
Then he gets the protection of this Act.
Yes.
Even if the tenancy is expired, then also he remains a tenant, statutory tenant, unless evicted.
Your Lordship is right, my lord, because there cannot be a statutory subtenant without the consent of the head, my lord, the owner,
Yes.
in view of section 26 of the Act.
Yes.
Everything has to be with, my lord, consent. Here, my lord, all that doesn't really apply. It's a registered lease. Otherwise, it will create a peculiar situation where under a registered lease, a
Yes.
sublessee creates, my lord, a monthly tenant. Actually never come across a situation, can't happen. A gives B under a long lease governed by Transfer of Property Act. B is authorized to sublet the property. B gives it to C for 500 rupees a month. So between B and C, it's under Premises Tenancy Act, A and B under Transfer of Property Act. Not possible. Because when C is, my lord, demise possession, it is on the strength of B's right to demise possession on the basis of the head lease, which permits him to do so. So therefore, he is a sublessee under the Transfer of Property Act when the head lease is governed by the Transfer of Property Act. And therefore, this anomalous situation, my lord, will never apply. This came to my mind, my lord, because it creates, my lord, a peculiar situation which I've never encountered before.
Anomaly, right.
I've actually never thought of this before, that between A and B is a registered lease under transfer of property, B and C premises tenancy. Is it possible? And if it's not possible, why not? The answer, my lord, would be that B gives it to C on the strength of right derived under as lessee with the right to sublet under Transfer of Property Act. So therefore, C gets it that way. C can never say I'm a monthly tenant. In fact, this is the argument, not any of what I was submitting before your lordship. Because if your lordship now sees up to, my lord, Trust to Orient, Transfer of Property Act, Orient to Ramnarayan Gaurisaria, Transfer of Property Act, Gaurisaria to Plaintiff, Transfer of Property Act. 3 registered leases and subleases. When, my lord, Gaurisaria to Plaintiff comes to an end, Transfer of Property Act will govern. Suddenly, my lord, can't become a tenant under Premises Tenancy Act. Because Gaurisaria's rights, my lord, emanate under Transfer of Property Act. It is on that strength that he gives, my lord, the demise to the plaintiff.
All right.
Now, my lord, really speaking, my lord, this doesn't come up for consideration except, my lord, to show that the plaintiff, my lord, at best is a trespasser and the plaint case in paragraphs 8 and 9 of the plaint are wrong. He is not under Premises Tenancy Act and he's a trespasser. If he's a trespasser, he can't get an injunction against the owner of the property.
Even a trespasser because he's not in possession.
Yes. Not even a trespasser because he can't, my lord, exercise any rights. And there was nothing wrong in, my lord, the person in occupation to hand back possession to me. Because under threat of eviction, always subtenant can give possession to the owner of the property. No law, my lord, can exist which will say that trespasser has a right to recover possession of property. Trespasser is in settled possession, and if he is dispossessed other than by due process of law, then my lord, he can possibly come, but otherwise not so. He has given possession to somebody else, he is a trespasser, other person's a trespasser, so my lord, no case, my lord, really made out by the plaintiff. And this is, my lord, your lordship's judgment.
But if you cite this, you'll have to distinguish this also.
Yes, my lord, since I've referred to it, I've read it out, I handed up a copy.
Or let them cite it, you'll get time to distinguish.
I'll read it up.
I have ফেরত দিয়ে দিই এখন দেখবো না প্রেজুডিসড হয়ে যাবে ওরা দেখাক তারপর
It's in my favor.
If it's in your favor, you can cite.
No,
Otherwise, don't take the risk.
I don't want to. I don't want to enter into this issue because of two risks.
There may be certain Easter eggs in my judgments.
Yes. And your lordship can change your lordship's mind also.
No, definitely.
There's no difficulty there.
And there is no question of changing mind because that was delivered singly.
Yes.
So we need not change our mind.
It's without a
It's not
division
binding,
bench mind.
persuasive. Persuasive.
Yes.
Not junior, senior, single.
Correct,
judge.
my lord.
So let them cite it, you distinguish it.
Yes, yes, if they cite it.
If they don't
again,
cite,
my
you are
lord,
saved.
all of it is academic because 3 months later it's over. May I now, my lord, show your lordship the impugned judgment, my lord, once and end. My lord, just one paragraph. Lord, internal page 7 of the judgment.
Yes. What injunction was granted? You are
Yes, upon cumulative, my lord, internal page 7.
dealing with or disposing of or creating third party interest.
Yes. My lord, not even a
So
trespass.
this is a triable issue, Mr. Chaudhary. If you transfer or create third party rights in the meantime,
Who is he to come and...
you say, but you hit at the maintainability of the suit also.
But you have to make out a prima facie.
That includes
Yes.
maintainability of the suit.
Yes.
Prima facie case, it's settled. Very good.
My lord, upon cumulative consideration of the submissions made by the parties, I'm reading, my lord, last
Yes,
paragraph
yes,
of page 7.
Yes.
It is clear. One thing is clear that suit property is required to be preserved in its present condition with regard to its possession. Whether plaintiff is in possession of the said property through defendant number 1 or defendant number 2 is in possession of suit property after having surrendered by defendant number 1 has to be decided in trial. Not correct, my lord. It's an admitted position from the plaintiff. But whoever be with the immediate possession of the suit property, that possession is required to be preserved for the sake of interest of the suit. When defendant numbers 2 to 5 are showing documents by virtue of which allegedly defendant number 1 surrendered physical possession of the suit property in favor of the defendant number 2, the plaintiff is referring TS number such and such to show that defendant number 2 to 5 along with other lessee of the lease deed have filed a suit seeking eviction of the plaintiff from the suit property, thereby admitting the plaintiff is still in possession of the suit property. This is not correct. This is factually totally incorrect. Yes, yes. TS number 616 is in, I'm told, not in respect of a different property, and that is evident from page 128.
TS 616, page 117.
Yes. 117
You have filed suit for eviction against them.
in respect of different property.
Different property.
Minute 116 at page 128. দেখা না।
117 the plaintiff starts.
দেখা না কাগজটা।
Is it annexed somewhere in your?
Yes, it's not 116 petition.
Page 117. Page 117.
117 at page 128.
Page 60.
Huh.
28.
Milord, this is by us, Milord. 117 would show your lordship it's by us. and the defendant, my lord, is EL Properties Private Limited, who's, my lord, the plaintiff. There's no difficulty there. Now, my lord, kindly see the schedule at page 128. This is all that flat on the 6th floor, measuring 2,500 square feet, more or less on the northeastern side, and flat on the first floor, measuring 2,200 square feet on the northwestern side, and number of quarters on the ground floor.
That portion was not left by them, not surrendered.
My lord,
That
please
was in their direct possession.
Yes, yes. Please compare with page 63. This is an office space on the western portion on the 6th floor. This is not 128 is northeastern side. 6th floor. And 2,500 square feet. And this is 2,400 square feet.
Plus another, and this property plus another first floor.
And that's another, the other suit is also for a first floor property.
No, page 63 is ground floor.
No, but 63 is office space
No, no,
on
no, office-
western portion of on 6th floor.
Sorry,
2,400 square feet with 2 car parking spaces on ground floor. This is not this suit. And the other suit which is referred to is 128, that is flat on 6th floor on northeastern side.
And this is western. The
This
present
is
one.
western.
Area also is different.
Area is different.
2,400 square feet.
And page 128, my lord, is also a flat on the first floor.
Yes.
A composite suit, and that's a different matter. So, my lord, hence, considering the entire circumstances, I find order of ad interim injunction is made absolute in view of parameters of granting injunction for sake of preserving the suit property and preserving the rights of the respective parties. And my lord, I should have shown, my lord, in the previous page, the second paragraph, that all issues raised by parties are matter of trial, which would require extensive discussion of evidence and law. Prima facie, it cannot be said that the plaintiff has not been able to make out a case against the defendants to go to trial. It's not always necessary for the plaintiff to prove absolute title. It is sufficient if plaintiff can raise a legitimate question regarding the existence of the right he claims. Furthermore, if plaintiff can convince the court the property in question should be preserved in its current condition until the legal question is resolved, that may justify the grant of an injunction in his favor. Then principles. May I just say this, my lord, with utmost humility and not meaning to, my lord, disrespect the learned judge. These are all tests, my lord, for grant of an order of injunction. How these tests, my lord, or law laid down by his the learned judge, how they are connected to facts of the case. What is the question to be decided? How the facts apply? Nothing is, my lord, really decided. No facts have been noted. That we appreciate that, my lord, but the principles are also laid down, maybe correctly or incorrectly, but there is no connection between the two indicated. The last paragraph, my lord, upon cumulative consideration. So, my lord, this is a classic case of, my lord, perhaps a order without reasons. Because how facts are facts stated, principles stated, but no connection or cohesion between the two. So, my lord, these are my humble submissions. Yes, and also ultimately what weighed with the learned judge, my lord, is that our suit, which is an incorrect consideration. Look, these are my submissions. Now I'm praying for vacating of this order. No order may be passed in this suit.
Thank you, sir. Yes. Mr. Vats. You and Mr. Chatterjee are for the same set of respondents. Who are you appearing with? Respondent one only. One. Plaintiff.
Factually, Millard, I'm not going to refer, Millard, what my learned
Yes.
friend has said. The questions of law. Millard, my suit proceeds against a person whom in the plaint I have said is in possession as my tenant. My cause of action in the suit is from 2019, he started bargaining with me as to the quantum of rent.
So, can you just take the microphone a bit closer, please? Yes, thank you.
My cause of action in the suit against my tenant is that he started questioning my right to get rent from him. There are certain correspondences which transpired thereafter, which will show that he was bargaining on the position that my lease, the parent lease, he has come to know has expired. So he says that you have no right to ask for any rent. At that juncture, my learned friend client comes in. And the first letter he writes is at page 136A. He writes it to me, saying that give me rent. That's to me. He asking rent from me on the premise that I have now a lease, and henceforth we request you to set the occupier's occupation charges collected by you after expiry of your lease along with occupier's depository. You are sending in letter for non-all occupiers. So he wants rent from me. Thereafter, Millard, somehow he got hand in glove with my tenant. And he wanted to take this surrender. The surrender letter which he shows, it says that I am surrendering the property to you. At this juncture, when we file the suit, the court holds that we've been able to show that although there is this letter of surrender, the actual physical possession is with my tenant till date. At that juncture, Millard, we got an ad interim injunction. The basis of that ad interim injunction is that yes, the plaintiff's lease might have expired. But so far as the parent mother landlord is concerned, the
Parent deed.
parent
lease.
title parent lease is concerned, there is no step taken against him. He has not initiated any proceedings. Plaintiff can run a case of holding over. Plaintiff can run a case of sufferance. Many things can happen. Protect the property. That was the ad interim order. When we go back, we show to the learned trial court further documents where my tenant still claims and continues publicly that he is still in possession of that property. Those documents are here, I'll show. So now, in fact, Millard, his registered office, everywhere, Millard, he still goes on to say that his registered office is still there. So therefore, this one letter, that's why, Millard, that paragraph in that impugned judgment, who is in possession is a question of trial. Millard, this is one aspect of the matter. I'll come to that. This is, Millard, my first point. So today at an ad interim stage, on the basis of whatever I'm able to show, prima facie, that my tenant is in possession. Question is, my learned friend, whether he has a right without disturbing, without, Millard, getting me evicted, to approach and directly get, Millard, a contract, whether a contract can come into existence that way. To address that, Millard, I'll first start with his lease. Millard, your lordship knows that under 108, a lessor is obliged to put the lessee in possession, actual physical possession. But parties can contract out of that also. subject to the contract, because the language of 108 is subject to the contract.
Yes.
Absence of contract.
Yes.
When he takes the lease from the mother, that is the trust, he takes it on as is where is basis.
Defendant numbers 2 to 6. This. It's mentioned in the.
Absolutely. Tara, boss, Tara. A.
Yes.
So whosoever is there claiming through the mother, my lord, their possession is accepted. Maybe of holding over, maybe of sufferance. I will try and take it a little further, but that is something I'm not very sure of whether I can argue it at this stage. And there is another clause in the deed which says.
What is that as is where is basis clause? The number?
I'll tell you, Lordship Miller. That clause is the first clause at page 106, just after the Havendum clause, at page 106.
Page 106, yes.
At 107. Here too on as is where is basis, without any obligation to deliver vacant possession of the said property.
Yes, the one he takes.
Yes. There is another portion, my lord, at page 109. At top, my lord, clause 6.
Yes.
It will not be the responsibility of the lessors to deliver vacant possession of the demised premises to the lessee. The lessors on this day have delivered symbolic possession of the demised premises to the lessee, and the lessors have not have any obligation to hand over actual physical possession of the demised premises to the lessee. And my lord, generally in these clauses, one clause often finds that he has a right to evict persons who are in possession. That right is not. That is, of course, my lord, another argument whether the right to sue survive, whether it cannot be transferred or not. But that's the right is not here. So the position today is I have taken on lease a property, consciously waiving my right to possession, and I'm acquiescing into the persons who are continuing in possession. And what is this, my lord? So therefore, my lord, the question has fallen from your lordship, my lord, then what did he understood the lease to be? Did he understand that he had a right to take possession, or did he understand that it was only a lease to assignment of rent? And that is where, my lord, this is what he understood, which is at page 136A.
Yes.
You know, just after the lease, Charu writes to the plaintiff. And property plaintiff. Plaintiff. The premises number such and such is leased out to us on 6th February, a photocopy of which is attached with it. We request you to send us the occupier's rent occupation charges collected by you after expiry of your lease along with occupier's deposit. You are sending a copy loan to you without prejudice to the rights and complaints. This is what he understood, and this is what was actually been given to him by way of a registered document.
Negotiating with the
He writes for you.
Yes.
So,
my lord, Charu, I mean, my learned friend's clients, best rights are governed by his own document. His right is only symbolic. And if I may say so, my lord, maybe maybe to collect rent or sue for arrears of rent or whatever it is, whatever right he has. Now, if he is unable to get possession, and there was no clause in the contract to the contrary, his remedy would have been to sue the head lessor. That you have not put me into possession, put me into possession or damages. That cannot be the case over here. Now, my lord, that portion of the argument which I was trying to, my lord, think, but I couldn't get, my lord, any assistance, is if after expiry of a lease, the head lessor transfers his interest to collect rent to a third party, with the added clause that these persons are in possession and doesn't give him a right to evict. Can it be construed under
Landlord having right to collect on behalf of?
the other way of looking at it is, can it be also construed is that he has otherwise accented to my continuing in possession upon payment of rent to my clients?
No, obviously, if he writes to you for either rent stroke occupation charges, so they admit your occupation at least on that day.
Now, my lord, kindly come to one portion. I am obliged to my 142. Hmm. 142. My lord, he writes to me in 2021.
By now, they have developed the habit of writing to you.
Last paragraph.
Yes.
It is denied that you are in lawful occupation of the premises alleged, and state that in view of the expiry of previously granted the original lessee and all other lease that have been inducted as such expired, you are liable to hand over peaceful and vacant possession of the premises along with mean profits and other charges during the period of a wrongful occupation of the premises. However, without prejudice to our rights and contentions, we are open for discussions with your offer in case you intend to obtain sublease from us for a portion of the said premises occupied by you as stated above on mutually convenient date and time at your office upon prior appointment. When this does not materialize, he starts writing at page 145. To my tenants.
No, 142 was subsequent to 145.
Yes, yes. And my lord, 145, we write, kindly see the last line of that letter at 146. We request you to accept us as your landlord. Premises include the acceptance of your levy for ready reference. So that is where, Miller, I come in and say that there is, if you want to reach that subtenant, you have to get me evicted. You don't have a right of possession. Number one, even if he files a suit, I think, Miller, privity would be a question which will fall for consideration in the suit which he has filed, although in respect of his correct, where there is already an injunction subsisting in others. So far, as Miller, the relationship between me and my tenant, Miller, that will cannot come to an end on the basis of what has happened to the head lease. So, my lord, my possession, whether it is of holding over, whether it is of a person continuing with the assent of the landlord, whether a person continues only with the right to rent being transferred, all these three issues are to be decided in the suit. So, my lord, this entire argument, whether I had a right, my lord, as of now, my lord, with brief respect to my learned friend, my lord, probably will not fall for consideration here.
And your tenant could validly hand over possession either to you or to superior landlord, not to a third party who got a lease under.
If I can stop him from doing so. On determination of the lease, lessee is bound to put the lesser into possession of.
This is
108Q.
obvious. To you under the Transfer Property Act, and maybe under particular scenarios to the superior landlord under the 97 Act or the 56 Act. If you are treated to a direct tenant.
Now, my lord, possession attack. Now, my lord, the question of possession, which my lord actually, my lord, is judgment. Compilation interim order ও তো রেকর্ড করেছে, দেখাও না। আমি কিন্তু এটা আজকে সব পাতা তুমি বার করবে।
Another compilation. Both the comparisons contain the same things.
I don't know, Miller. I'm seeing it for the first time today at court when the matter was called on. দেখাবো বলো। কোন জায়গাটা দেখাবো তোমাকে? Oh, the first, my lord, is at page 224. 224. This is 9th of March 2023. Okay, copy down.
These were part of the records in the court below.
This one, yes. The other one, yes. There is only one which probably it was a public document which was handed over to court and copy handed over. That is, my lord, a printout from the Ministry of Corporate Affairs showing that even today my tenant is showing his registered office at that same address.
That we may not look into, Mr. Apart from that, the rest.
That's a public document, my lord. That's available in the website. Even today, my lord, even lordship now opens it, your lordship will find that.
That I don't mind if it's considered, and if today's version, which I will produce, is also considered.
Of the same web page.
Now it has, so post suit it has changed. Post injunction it has changed.
So if those cancel out each other, then let us not look.
Very well.
2 documents less.
Actually,
my lord, page 224.
Yes.
My lord, is the eviction notice given to my tenant. Your lordship has got it.
What is their alleged date of surrender by your tenant to him?
That's my lord. Third April 2021.
13th April.
13 na third. Kide?
I mean,
13th April. Which page?
Page
Well, it is
of the stay.
13 is correct. 140.
148.
48.
So this might have been created to manufacture evidence, I mean, to show, because after the surrender.
Could be, that is,
This eviction notice does not matter much, I mean.
No, what I want is this has been addressed and received at the address by my tenant.
Oh, acha. But this was pleaded and produced with a written objection in the court below. We are at the administrative stage, not the we are. He is coming up against a temporary injunction. Final. So then this must be. This was received.
This was received, my lord, your lordship.
Where is the receipt?
At page 231. Ninth of March 28 at the top, my lord.
Anybody might have received, Mr. Dattur.
Oh, my lord, I don't know.
Item delivery confirmed.
Item delivery confirmed at that office.
That is the suit premises.
That's a suit.
Anybody might have received, not clinching proof.
My lord,
Addressed to them, right?
If it is received, if my lord, I am not there, why will I receive it? I send it back. I said I am not there. Somebody else is it. That would be any to his benefit. That would have been an evidence that he was not in possession.
All right.
Second. আরেকটা দিয়েছিলাম 240 বলো 242 and Miller, the other email is at page 240, 243. Achha, sorry. Which shows that the registered office is still at page 243.
This is the other document to which he has answered probably by the recent.
I really don't know. I'm awaiting his answer because my junior shows as of now. I thought ki dekhachhe. As of now, it shows the same.
Same.
But my learned friend.
This probably was not before the court below.
No, this was I handed over personally to the court. I remember. But yes.
Oh, it was handed over to the court.
Yes, it was handed over to the court. They had objected that that was not part of the pleadings. I had said that it is a public document. If you want, I can put it by way of a fidelity. Then they accepted the
Anyway,
document.
after the date of surrender, this eviction notice receipt is there.
Yes. And as even now,
even if the address of your tenant has not changed from that,
yes,
they might not have changed. They might not have taken steps for changing that. That does not prove, I mean, automatically that they continue in possession. Their registered address might not have been changed.
So, Miller,
that's a violation. That may be a violation of company law.
That may be a violation that has not been done by negligence. Receipt of
might be. Receipt of notice is there.
Because I'll get that presumption as of today.
That is 2 years after the alleged surrender.
So, Miller, so Miller, these are the facts. Question is, Miller, at this stage, at an ad interim stage, whether what the learned judge has said that the property should be, whoever is in possession, property should be protected, and whether the status should remain the same. In my respectful submission, Miller, if it is not done so, and I ultimately prove that I have a better right, because that right is an established right. That
but Mr. Dotto, you also proceed all along on the premise that it's a transfer property act and lease. Because of these things, because see your suit, the frame of your suit, it's not a 97 Act suit. No ground has been disclosed, no prior notice under Section 6. So by filing this suit itself, the frame of the suit itself indicates that it's a transfer property act scenario.
Miller, even if your lordship takes
if that be so, then expiry of lease, reflux of time, parent lease goes.
Expiry of the lease, I become a tenant in sufferance or a tenant in holding over.
Holding over, there is no case made out by you.
No.
A holding over case
Holding
could
over is
have
not
been made
automatic.
out by you at that stage because of the reason
File a written objection to the injunction application.
in the injunction application, holding over is something which I was trying to develop from the nature of right which he has got.
Holding over is not automatic. There has to be a positive assertion, positive acceptance as a tenant after that. And whether you could hold over because your landlord has lost his lease has also expired. Where there could be a vis-a-vis you, inter se you may say that there could be a holding over.
Number one. Number two is so far as the mother lease is concerned, he has not proceeded to sue for eviction against me. So how does my learned friend try to get possession of a property over which he doesn't have a right?
But Mr. Dottu, if there is actually a surrender, physical surrender,
That is something will not be.
apart from that question, if there is a valid, if there is a surrender, physical surrender, you are not in, your tenant is not in possession, so you cannot, an eviction suit is a misnomer against your
Yes. Yes, because I had proceeded on the basis and I have been able to show at the first stage that my tenant was still in possession.
And you have the relief sought against the appellants here is that they cannot transfer, alienate, create third-party interest. So you are you in a sort of way admitting their title to the property?
Not
Aren't
exactly
you,
that.
rather?
Those prayers, Millard, those prayers probably would have been redundant. I would have filed only a suit, Millard.
Then there would be no cause of action against these defendants. Why are they included?
Because they were introduced because they were trying to interfere with my rights. They previous my rights, whatever it is, Millard. And Millard, so far as the other properties are concerned in the same premises, Millard, the other three suits which are pending, Millard. There, Millard, also I'm enjoying that injunction. But that is, of course, Millard, not a point I'm trying to impress upon the court with. Etc. And Millard, there is also another aspect which probably will not fall for consideration over here. Millard, I am not very sure whether this lease which was granted to my learned friend is a valid lease under the Trust Act or under, because no permission, the lease deed does not say of any permission being taken from the court to create an interest in the property, number one. Number two, maybe all the trustees have not signed the lease. But that is an issue which he has admitted in his own suit, which is at page 11, which is at page 11, Charu suit 117.
Of the stay application?
Of the stay application. Where Millard, he sues me for being in wrongful occupation in 2023.
That is in respect of the other property which you say.
Other properties.
But on the basis of the same lease deed. His lease deed remains the same.
Including that document.
From paragraph 16 onwards, Millard, that is of course in respect of this suit, but he admits that paragraph 18. At page 120.
You say that you are a monthly tenant. When did you become a monthly tenant? All along you have been acting in terms of transfer property act, lease deed, registered lease deeds. You cannot all on a sudden overnight become a monthly tenant after effects of time.
Millard, so far as this point is concerned, Millard, my understanding was this, Millard. I was under the impression, maybe wrong, that a registered deed executed after the commencement of the act will not be governed by the transfer of property, by the tenancy act, but by the transfer of property act. But Millard, I believe initially it was before and after.
Now it is not there.
Now it is not there.
So it's not a monthly tenancy.
No. So my understanding was, it was my understanding. My understanding was that if during the continuance of my possession and during the subsistence of my lease, when the Transfer of Property Act, when the Premises Tenancy Act came into force, and my rent was below the the limit, my lord, then I acquired the right to protection under the Premises Tenancy Act. Because when the Premises Tenancy Act came into force, my lease was subsisting. Now, whether that lease would be governed by the Premises Tenancy Act or the Transfer of Property Act, your lordship's view is that if you are a tenant to start with, then obviously it continues.
For a monthly tenant.
I was under the impression on and from the date.
No, 56 Act was there previously.
Yes, 56 Act
But
was,
parameters were different somehow.
yes, parameters were different. Now the parameters, whether can I fit into those parameters to argue that so far as my quantum of rent is concerned, this relationship is that of a landlord and tenant. And
Your
my lord-
quantum is less than
Yes.
the upper ceiling.
And the other part is, my lord, the other aspect of it is, for argument's sake, suppose I fail on this. Even, my lord, if I am a trespasser, my lord, I have to be evicted by my superior landlord before he can hand over possession to somebody. I cannot be evicted by a third party, because before a third party, as a trespasser, I can protect my interest against the whole world except my landlord. So today, if he shows a document to which he doesn't have possession, then I have a better right. I can say that it's only the headlesser who can come and evict me. And my lord, these two suits, my lord, which 962 is one of them, which he admits in 2023. There is a challenge to his lease also, because I am not stopped from challenging his title. So therefore, today the whole scenario is his title is under challenge by me. His possession is, my possession is admitted by in no uncertain terms. The fact that my tenant is in possession, I could prima facie show to the court. And ultimately, my lord, the clinching point is that on the basis of the right which he has got from the landlord or from the headlesser, he doesn't have a right to claim possession. It's only constructing and symbolic. So therefore, in those, my respectful submissions would be, my lord, that the suit can be expedited. But if this possession goes, my lord, then my suits become infructuous. Those would be my submissions.
Yes.
You're right.
He just said, I'll come back in 2 minutes. Then before I stood up to address, I found that his laptop, his tab was taken out. I'll just have a glass of water.
Please.
My lord, right to an interim order cannot be, my lord, confusion, either factually or, my lord, apropos law.
De jure, yes. De facto,
no. Can never be, my lord. Now, may I say this, my lord? What is the first point argued?
Yes.
Point wise, my lord. Who is in possession is uncertain. And, my lord, Mr. Dutt says, my lord, that he is prima facie able to show that his tenant is in possession. Answer, my lord, is please see the plaint. Plaint, my lord, is very clear as to who is in possession. The plaint, yes. The paragraph 24 of the plaint, yes. Which I have shown your lordship.
No, but there, they
Yes.
don't say that the possession has been given to you. They say upon perusal of a document annexed to the said objection being such and such, it transpired that the defendant number 1 claimed to have allegedly surrendered the suit property to defendant number 2. There being no privity, the property could not have been handed over. and is of no significance. They don't admit that it has been surrendered. They say it was your claim. Rather, it was the claim of their tenant.
Now, please see paragraph 25.
Yes.
Notwithstanding the said letter dated 13th April 2021, the defendant number 1 continued to occupy the suit property.
And that is his consistent case thereafter also. In the last few paragraphs of the plaint also. Para 32, 33, everything. 33 rather.
So I'm not in
34.
possession of the property.
So they don't admit that in the. So therefore, there is no bar in, as framed, there is no bar in filing of the suit for eviction of defendant number 1.
Defendant number 1.
They just deny that you are in possession, that the surrender ever
Excellent,
took effect.
Nothing better. But then I ask myself the question, would the plaintiff in such a position be entitled to an injunction against me? That if your case is that defendant number 1 is in possession, if your case is that defendant numbers 2 to 5 is not in possession, would I be entitled, I ask myself the question humbly, my lord, to an injunction?
Injunction is not in respect of anything else, but because you are claiming right by virtue of some, by virtue of your lease deed.
I am
and
claiming-
surrender letter.
Yes, but I'm lease deed. Not
Lease deed primarily.
Surrender, he says, is ineffective. It's not of no consequence. It has never happened.
Yes, but in the lease deed
Lease
itself,
deed,
there was no.
that's not in this suit.
No, in the in your lease deed,
yes,
there is no clause. Rather, the
let's-
clauses say that symbolic possession, no right of eviction is given to you, as pointed out by Mr. Jat.
Let's look at, my lord, the lease deed once, my lord.
Yes.
That would make it. My lord, please come to page 106.
Yes, we are there. Para 10, you rather admit.
8, 9, 10.
10, you say that still under possession of and occupation of unauthorized persons claiming to be sublessee.
Correct. Now, my lord, in then now this deed witnesses as follows. In pursuance of the agreement, the lessors hereby grant and demise all that land.
Where is that?
My lord,
page 106.
Clause 1, my lord, at page 106.
In pursuance of the said agreement and in consideration of the payment.
Consideration of the payment of interest-free refundable security deposit and rent hereby reserved, and on the reserved of the terms and conditions herein contained, and on the part of the lessee to be observed and performed, lessor hereby grant and demise such and such. Third line of the next page, on as is where is basis and as it is basis, without having any obligation to deliver vacant and peaceful possession of the property with the right of access to the premises, together with I'll read it out, my lord. On as is where is basis and without having any obligation to deliver vacant and peaceful possession of the said property, together with the right of access to the common passage leading from the municipal road to the premises, together with all normal and usual right for the beneficial use and enjoyment, possession, easement, and occupation of the demised premises.
But without having any obligation to deliver vacant and peaceful possession means that you don't have vacant and peaceful.
Right.
Even he doesn't have any vacant and peaceful possession.
He doesn't have. So, my lord, now, my lord, kindly, I was also completely, my lord,
But
taken
your case is that after this surrender took place. After this surrender took place. So therefore, admittedly, they did not have possession and they could not hand over possession.
They were not
you managed your own possession.
I manage my own possession. That's, my lord, I must have paid less for.
But
my lord,
apart
I'm
from
paying-
that surrender letter, isn't it even questionable, arguable at least, that whether you're in possession at all? Because in 2023, that eviction notice was received at the address.
I'll just come to that, Pilar. I'll deal with the issue of surrender. But before that, just one more statement, Pilar.
Yes, yes.
If your lordship kindly sees page 106.
106.
I, in fact, admit that or the lessor admits, and I also admit that there are unauthorized persons.
Yes.
My admission makes no difference. Lessor's admission, my lord, is
So
important.
you took possession from those unauthorized documents, subtenants and or unauthorized.
Unauthorized occupants. Occupation of, my lord, clause 10, my lord, at page 106.
The defendant numbers 1 or 6 have not come up. They have
No,
not
no,
filed it.
they've given me possession, a government
In
company.
the injunction application, they did not
No,
appear.
no.
also.
They have not entered
No, no.
appearance in this suit.
They won't bother. They've left the property and gone a government company. My lord, now, my lord, if I may just to answer this point, lease defined
Yes.
of leases of immovable
Government
property.
company, that makes it all the more credible that they might have handed over possession to you. But that cannot be taken judicial note of.
Yes, yes, yes. Absolutely correct. Section 105. You know, lease is defined. A lease of immovable property is a transfer of a right enjoy such property.
May be deferred.
Maybe deferred.
Vested right may be deferred.
Yes.
19.
Because lease includes, owner of a property has, title and has possessory right.
No, that Mr. Dutt does not deny, in a sense. I mean, he's not admitting or denying, but yes, a lease, so-called lease as per him has been given to you without possession admittedly.
Yes.
Now that possession, he says, could not have been surrendered by the tenant to you, to a third party. Under 108Q, it could be surrendered only to him, or at best to the superior landlord under the, even if you take account of the Rent Control Act. That
But he says there
surrender,
has
so-called surrender, is illegal. He says.
But he says there has been no surrender to me. Well, this is why I say, my lord.
That's why he says it's of no significance. He says, claim to have allegedly surrendered the property. They do not admit in the plaint at any point of time that it has been surrendered to you at the time of filing of the suit. So on the face of the frame of the suit, it is maintainable. Against defendant number 1, yes, you have a point without seeking a declaration of title against you, or whatever declaration against you not having this lease deed not conferring in title. They could not claim whether they could claim this injunction against you. But Mr. Dutt says that in other suits, your title has been, the lease deed has been challenged.
Now, my lord, I say this. My lord, it's a completely different scenario whether, my lord, I am in possession or not in possession. If I am not in possession, 2 points, my lord. Number 1, if I am not in possession, you can't get an order restraining me from giving possession to somebody else.
That is not the injunction sought. Dealing with disposing of, etc. Transferring,
encumbering.
alienating income.
That's what I'm saying.
You cannot execute a further lease deed, for example.
Yes, very simple, my lord, situation. You see, if you're saying I'm not in possession, you can't get an injunction restraining me from handing over possession. If you haven't challenged my title in this suit, you can't get an order restraining me from giving my title to somebody else. You have to challenge in the same proceeding. You can't, my lord, create a basket of, my lord, confusion and say that let it all be decided in suit. And till then I must get an injunction. He's made out a case in his, in the eviction notice, my lord, that for that handing over of possession document is a forgery. But he's never challenged really that document.
So you say the challenge had to be in this suit itself.
Yes.
But
or he can, my lord, if he's challenged my lease deed.
He has challenged in a different suit.
In a different suit. So you go and ask for an order of injunction in that suit saying that don't transfer to somebody else. My lord, what is he doing? My lord, if he says he's, my lord, the plaint proceeds on the basis that is.
With respect, my lord, in that suit, when I have challenged this title, I'm already enjoying an order of injunction.
So let us vacate this then.
Yes.
Superfluous injunction.
Yes. If that is the position, please do that.
That's in respect of another.
I remember another matter where, my lord, possession was in the process of being handed over by MSTC. There, my lord, pending consideration, there is, my lord, an order that you don't hand over the keys. That's, my lord, another matter. My lord, submission humbly is this. Now, to put things in the correct perspective, if he says, my lord, that the suit, my lord, is if he says, my lord, in his plain that he's not handed over possession, then he can't get any or injunction in possession, in respect of possession. Therefore, my lord, I request your lordship to, my lord, please have a look at the plaint one last time.
Yes, G says parting with possession also. Defendant.
Yes. My lord,
although that has not been granted probably.
no, status quo. Everything,
quo, okay.
everything. So, my lord, what he's doing is, my lord, I just want in my rejoinder submissions to put facts in the perspective. In paragraph, I now, my lord, enlightened by my learned friend's submissions, paragraph 25 at page 55, which I should have, my lord, shown your lordship in the morning. Notwithstanding the said letter written 13th April 2021, defendant number 1 continued to occupy the suit property without payment of rent or occupation charges. So if you say defendant number 1 is in possession, you can't get orders restraining me from handing over possession. A. B. If you don't challenge the lease in this suit, you can't get an order in aid of the challenge to my lease deed in this suit. So no title injunction, no possession injunction possible.
So insofar as you are concerned,
there
that's
can't be
different-
any relief.
That's a different compartment
Yes.
because they're very well.
If you're in your mind, if you're proceeding on the basis D1 is in possession, then you proceed. Why did you make me a party? You pursue an infructuous suit for the next 25 years. But don't make me a party. What is he doing, my lord? He's saying that you have not got possession. Defendant number 1 has possession. But I'll get an order against you. And he'll keep the property sub judice with an order of injunction. On a case which is totally incorrect. He knows that I am in possession.
No, the injunction, no status quo has not been granted. What has been granted is plaintiff allowed on contest without a plaintiff and defendants, both of you,
yes,
and your men and agents are restrained from dealing with and disposing of or creating any third party interest in respect to the suit property.
Yes, so
no possession, no injunction
third
regarding
party
possession.
interest.
No possession. Third party interest is different from possession.
Dealing with, if I today give it to somebody,
Yes,
I'll
dealing
have
with
to
is
give.
broader.
It's very broad.
Right.
They'll file a contempt, I'll be in trouble. Nobody wants trouble.
Yes,
Milord.
yes.
So this is, the situation.
Yes.
Now, Milord, let me quickly deal with his. So what he wants to do is on this, Milord, case, he wants to, Milord, keep the property and me hanging. Next, Milord, submission is that the contract, the lease in my favor is contrary to the statute because lease is on as is where is basis. I have shown your lordship clause 1, which says I have a right to enjoy possession under the lease. And definition of lease, Milord, under section 105, Milord, is right of enjoyment of property. And it's a transfer of, Milord, that right. So I'm entitled to.
He does not say without delivery of possession there cannot be a lease
No.
deed. He says that there has been a lease deed transfer, but without handing over possession to you.
Yes.
That's an admitted position as per the lease deed.
And he also goes, and that's correct, Milord, but he also goes on to say that you don't have a right, therefore, to get possession from anybody else or the property, and your document is really a right to collect rent. That's his argument. I'm meeting that argument by, Milord, showing your lordship the lease deed, Milord. At page
He says you don't have any right to evict as per that.
yes,
of that
Milord.
Possession.
The lease starts from, Milord, I want to show.
Application to deliver, vacate and but that does not necessarily mean that you don't have a right to it.
I don't have a right to get possession.
Says no right has been specifically conferred on you to.
So, Milord, his first submission is correct. He says it's an as is where is lease. And from there, Milord, Mr. Dutt leads on to two inferences. Inference 1, you don't have a right to get possession. And inference 2, you only have a right to collect rent. I am accepting, my lord, his argument that I've got as is where is lease without possession from the trespassers, no obligation, but I don't agree humbly with the two inferences. This is not a document for just collection of rent, and I have a right to enjoy possession, for which, my lord, I'm reading page 106, clause 1 of the lease.
Yes.
And I have pointed out on the second, my lord, the concluding part of the clause at page 107. So, my lord, the lease, creation of lease itself is enough because of the definition of lease. And this specifically says, together with normal, usual right of beneficial use, enjoyment, possession, and occupation. Easement and occupation
Yes,
of
enjoyment, possession, all that.
So, my lord, all because trespassers are in possession, he doesn't give me possession, but I get it for myself. So, my lord, this is the second submission, and this is obviously not a document for collection of rent. He says my remedy is to sue, my lord, the head lessor. I have not sued anybody. I have got possession. Simple. I've got possession. Now, question is, does he have a right, my lord, to get back possession from me? And I go back to my argument in the morning, my lord, that you're a trespasser, or not even a trespasser, having zero right, which is my answer to his third argument. So I don't have to sue anybody. I've got possession. Now, can you take it back from me? Answer is you can't, because you're no one in the property. And I reiterate my submissions made in the morning. Correct. Next, my lord, pages, my lord, 136 onwards to 142, 146.
The lessee shall be entitled to grant subtenancy, induct person or parties into possession the device.
Yes,
Will have to
yes, I'm grateful, my lord. Also, please see clause 7. We have a right to induct persons in possession. And no, that's at page 82. 109 of this. Lordship is looking at it from the state petition, my lord.
Yes, internal page 8.
Internal page 8. Clause 7. Entitled to grant sublease, subtenancies, induct person, parties into possession. The right given to me. So, my lord, what did I do first? I found some people in possession. I know some people are in possession. They're trespassers. I write to them saying, let me know how much rent you're collecting and how much you'll pay me. Enter into a lease with me. I'm the person who can give you lease now, because you're a trespasser. He doesn't do that. His subtenant delivers possession to me and goes away. There's no admission. There's no admission of his status. Nothing involved. Please see the documents which when learned friend showed your lordship. 142 of the compilation.
Whose compilation?
My learned friend's compilation, my lord. Page, he's shown your lordship, my lord, 142, 146. No, show me there. Oh, I'm sorry, my lord. 142 and 146 from the state petition. There are just 3 points I have to answer, my lord. Yes, my lord, the letter at 142.
Yes.
My lord, reference to your letter, we refer to our letter is in certain stated copy of registered lease in our favor attached to the letter. We are unaware of such reason for your denial to have receipt of the copy. We registered document, public document. You are aware that your contention of any alleged negotiation with the original lessors to us is ineffective futile, unconstructive, and ineffectual, since fresh lease deed has already been granted in our favor. It is denied that you are in lawful possession.
So you write to them to hand over possession.
Yes.
Admitting that they are in possession.
No, Milord, please see the next page.
Yes.
However, without prejudice to our rights and contentions, we are open for discussions on your offer in case you intend to obtain sublease from us. I have a right to give sublease under the.
So that is for the portion of the said premises occupied by you. So you distinguish between some portion being occupied by him.
No,
maybe that sixth floor northeastern.
No, this is also this also
We don't know.
occupied by you.
You are liable to hand over peaceful and vacant possession means that they are in possession.
Yes. Of other portions are also occupied. Milord, issue is, Milord, no one in occupation has title. I am entitled to get back possession from whoever is there. And different ports, some he is in occupation, some is, Milord, sublessees are in occupation, etc., etc. I am entitled to get back from whoever is there. And a trespasser or a person who's put in a trespasser is not entitled to get a decree for eviction against me. So on that basis, now after that this doesn't fructify, there is no hide and seek. And he shows, Milord, page 146.
What is that surrender letter of yours, Mr. Chaudhary?
Milord, surrender letter 148.
This is the only document which shows that you are in possession.
Oh, Milord, I am sorry, Milord. No.
Yes. 142 of the stay petition.
Milord, 145 is 140 is different.
148.
148 is the surrender letter. Milord, we, West Bengal Electronics Industry Development Corporation, have delivered peaceful and vacant possession confirmed by Charu Rizal.
This is the only document which shows your possession, that you are in possession. And Mr. Dutt says he handed over a document showing that the registered office is still the same.
But I'm aware, Milord, of the fact that he handed over documents to the learned court below, saying that the MCA record shows that Webel's registered office is over there. That was, and still is there. That was perhaps not taken on record, should have been taken on record.
Anyway, but
it's a public document. But I will, Milord, show your lordship that today's, Milord, printout from the MCA portal will show that Webel's registered office is in Salt Lake.
Is in
Salt Lake.
Webel has an office in Salt Lake that
Yes. Salt Lake, Bidhannagar, Kolkata.
The surrender letter, what is the date of the surrender letter?
Today, Kobin.
21.
Milord, today, Milord, 2nd of April 25, 1:42 in the afternoon.
Salt Lake, this Webel Bhavan is there from before 2021.
A registered office. Milord,
we have an office there also.
No, Milord, see, Milord, Mr. Konta.
This is Webel
Oh.
Electronics Industry Development Corporation. And we are Webel Information.
নাম চেঞ্জ হয়ে গেছে দেখো তুমি নাম চেঞ্জ এটাই তো কোনটা
এটা কর্পোরেট অফিসে আজকের ডেটে দেখাচ্ছে নাম চেঞ্জ হবে দেখাচ্ছে
Electronics Industry Development Corporation. Yes, that is the name of the defendant number 6.
West Bengal Electronics.
Is the name of the defendant number 6.
Yes.
But he's showing you the website which is saying something else.
Confused, Milord.
If both of you are confused, we accept that.
এটা কি করে হচ্ছে দেখো
We accept the confusion. Anyway, we cannot look into this.
Oh. This is Webel Informatics Limited.
This is electronic.
Yes.
That's so, Milord, according to me, yes.
Dust settled.
That's settled. Milord, according to me, it doesn't matter. It doesn't matter. Now, Milord,
Mr. Dutt, please take this back. You were the root of all this trouble. এটা ফেরত দিন তো না কেউ দিল
Had said that we are not going to consider this.
No.
This one, so far as this is concerned,
Milord, it
Here
does.
shows-
Milord,
It's a disputed. You are disputing that they're in possession. That surrender letter has not been given.
Very well.
The
To
learned
be
judge
happy
has not
without
been
an order of possession. Your plaint case is not in possession.
That point remains. If there is no possession, there is no question of restraining you from parting with possession, and the
Milord,
other
then
point.
the next
We'll consider that.
yes,
Yes.
Milord, next submission is no right of possession. I've dealt with that. Then my learned friend's argument is he has no obligation to me. Don't want him to have any obligation to me. Makes no difference. Then he's given an eviction notice to his tenant after, Milord, the date of delivery of possession which has been received.
No, he says that you cannot get direct possession from his tenant without taking possession from him. I mean, without having him evicted.
Milord, two answers to this. Number one, person who's a subtenant whose possession is in dispute, is, Milord, under threat, can always deliver possession to the head lessor. There are judgments also.
You are not the head lessor.
No, I'm not the head. I'm, Milord, the person who's got a lease from the head
You are
lessor.
on a parallel footing as the other sublessees.
No.
Yes, other lessees.
There's no one else. Head lease has expired.
Oh,
Owner has given me. I am, Milord, owner. I am the head lessor.
you are the lessee.
I am the main lessee. I am the representative of the owner. Correctly. Possession given to me. I've got a judgment also, 1987 Supreme Court, which says yes, it can be given to me.
Why didn't you cite it in the first instance?
I thought it wouldn't be necessary, but I
What
can't
is the
say.
proposition there?
Proposition is subtenant who's under threat of, Milord, eviction or dispossession can always deliver possession to head lessor, skipping the person in between.
head lessor is not him.
That his rights have been assigned to me.
No, that Mr. Dutt is also saying that it could have been given to the head lessor. That
So
other, he said that
accepting
it
the
could-
point, I don't want to cite
Anyway,
the judgment.
yes, right.
But head lessor has given me a lease. He's given me, Milord, with a right to sublet. I am the one who's entitled in possession. So if he's accepting the proposition, I don't want to go further. This is answer number one. Answer number two is, Milord, for a minute, done wrongly. Done wrongly. Who can get back? Who can remedy the wrong? Not a trespasser. If, Milord, his lease was subsisting, Milord, it's different matter. Lessee's, Milord, lease is subsisting. His sublessee hands back possession to the owner.
That you argued that he has no right. But the other, what about the other argument of Mr. Dutt, that he said that his impression is that after coming into force of the 97 Act,
yes,
if the parameters of the 97 Act are applicable and the rent is below that level,
Milord, I noted down
then
my...
he'll get the protection of that Act.
Yes, Milord, I noted, Milord, the argument. Registered lease is subsisting, at which point of time 97 Act comes into force,
yes,
and I become a monthly tenant. Milord, with respect to my learned friend, Milord, if registered lease is subsisting when the Act of 97 comes in, then at the 1 minute before the Act is notified, the lease is governed by the Transfer of Property Act.
Yes.
So now after the 97 Act comes in, that status, it can never change. And the Act contains nothing to change the status. Section 3 has no applicability to these leases. Please see section 3. Oh, we can hear. I'll read section 3, Milord. Not exemption, nothing contained in this act shall apply to any premises let out for non-residential purpose which carries more than 10,000 rupees.
Cited
monthly rent.
Prakashvati versus Shivaji.
So Shivaji blood is that confusing judgment blood in the morning. I have an arbitrate, I have
Yes,
an
yes.
arbitration at 4:30 before the learned judge. But I don't dare to ask him to explain the judgment to me.
Justice Gupta?
Yes, I won't dare to ask him. Otherwise, other learned retired honorable judges of this honorable court, we share good relation. We go and request, please explain this point of law. No problem. Justice Gupta, I don't want to take a chance. Though his lordship is very nice to us.
No.
But we are too scared of him. Because in this courtroom, my lord, on the second day of my practice,
Not this courtroom.
this courtroom, second day of my practice, company court,
Oh,
Justice Gupta, somebody asked me to mention and request for leave to have an order drawn up and completed. I didn't understand what to say, so I requested his lordship to draw up and complete the order. And his lordship, he said, I pray to your lordship to draw up and complete. Lordship looked at me and said, you want me to draw up and complete? I emphatically said, yes, I want your lordship to do. Next question, how long have you been practicing? I said, yesterday, my lord, I joined. And there was deathly silence in the courtroom. Then his lordship started laughing. And my lord, I was later explained that I shouldn't be very adventurous. Now, please see section 3, my lord. Any premises let out for
because
non-resident.
Prakashvati has been quoted in the book also. That's
Yes,
why
yes, yes.
we were curious. Pre-act registered lease. That is
Yes.
the. Anyway, we'll look into Prakashvati. We have to. Please.
Yes, yes.
Very well.
And
So these are all.
This is all.
Else remains. Now you're repeating.
Yes.
And we have that arbitration at 4:30 also.
Yes, yes. No, it happens, my lord. It's.
Oh.
What?
Clarification.
Yes.
That your lordship has the plaint, my lord?
Plaint, yes, it's annexed to the
Yes,
application.
my lord, your lordship takes the plaint, my lord. My lord, this confusion which your lordship blames me for creating, let me then clarify it.
Yes.
My lord, kindly see defendant number 6 is
Electronics Industry Development
Limited, a government of West Bengal, formerly known as Webel Informatics Limited, having its registered office at such and such, and 225 Acharya Jagadish Chandra Bose Road. And
না বলছিও না
okay,
1 and 6 are exactly the same.
no.
Name is exactly the same.
Will division. What is will
That
division?
actually it has same entity.
No, but
They
exactly
made a
the same. The name is
division of
exactly the
party.
same. How could you make him 1 and 6 in the same?
Well, there is a two divisions I am told. One is a will division. and
Division
one
will
is-
not make.
That's not a separate juristic entity.
Exactly.
Misjoinder of party.
But
It
the
can't be
thing is,
dismissed
what
from
I'm trying to show is that they are registered as Webel Informatics at this address even today.
No, but how can it be Webel Informatics?
Kindly see this.
One created one executed a lease deed, sublease deed in favor of 6.
One, just a minute.
এটা তো দেখেছি আমি Webel Informatics আলাদা
Millet,
The lease was
an old entry of Webel Informatics when its
No, no.
name was
there
Informatics.
was a lease deed by 1 to 6.
defendant
Millet,
number.
There's
One.
nothing, no document between 1 and 6.
No, nothing.
1 and 6 are the same entity. A division
Absolutely.
cannot be a juristic entity.
So there, no, they should not have been there. So therefore, Millet, 1 should have been good enough. 6
Yes,
did not have been there. But
Yes.
what I'm trying to
These
say
are
is
alter
that
egos, not even alter egos, the same
Same
company.
it
देखिए,
still
আমাকে
shows
competition
that
now.
it still shows that their office is at 20.
No, I'll tell
That's
your
it.
lordship.
They have office in both places.
No.
They still have it.
No.
Number 1. Number 2 is Millet. I should not reply to a reply. My learned friend is showing possession, but it is clarified
Registration number.
expressly in the
এই
lease.
এটা দাও
In the
তুমি
subsequent
যেটা
act,
এনেছো দাও
the possession which he will get is
ওটা
symbolic.
আসলেই দাও,
The
হাত
word
পা নাড়ো।
symbolic
Yeah, that is said. That you categorically.
Yes.
nothing more.
See, I can solve all problems.
What problem?
Milord,
You have been solving since the morning, Mr.
yes.
We have lost our confidence in you regarding
Yes.
solution of problems.
Milord, if please, Milord, look at
Company identification number.
the company identification number and the registration number of both companies are
Too
different.
long. If it's
No,
different, if you say it's different, we accept that.
So this was, Milord, I'll tell you, I've seen this problem before. This is an old company, name has changed, or Milord, maybe a amalgamation, merger, etc. SIN number has changed. This is the old entry which is showing.
Maybe, but insofar as the impediment of parties is concerned, we don't see any difference between 1 and 6.
No, Informatics Limited. WebL Informatics Limited.
As
Now
we-
my learned friend,
What is the cause of action against 6? That is what we are curious to know.
Oh.
6 has been impeded. There must be some cause of action.
কেন করেছে?
There is nothing disclosed in the plain. Everything against 1. 6 has not even been mentioned anywhere. Or is it? We have seen more or less all the paragraphs. 6 is not mentioned anywhere.
I don't know, Lord, why 6 is not.
But so no cause of action has even been disclosed against 6. Maybe in the first.
Nothing,
Yes,
Lord.
yes. Surprisingly, 21, para 21. Surprisingly, by later it is a subsidiary company. 6 road, the wheel division. That is 1 road basically.
That's yes. See.
Not what they are saying is, my lord, the
Wheel division
that
was
letter
offered.
was
Letter
issued
was-
by a
yes.
division. So that's a it's wrong, but doesn't matter.
So we'll close arguments on this.
Grateful.
Hearing is concluded. Judgment is the matter is reserved for judgment. Thank you.
Grateful.
Thank you. এই নোটস গুলো যাবে আর জানাবে এই জাজমেন্ট গুলো এই নোটস গুলো একসঙ্গে করে দেবে হ্যাঁ
ওটাতে আমি ব্রিফ নই ব্রিফটা ছিল
একদম সেম ভাবে বলে দিন।
সাবধানে পড়ে যাবে এগুলো ওনাকে দিয়ে দিন এটা নিয়ে নিন
ওই ফ্লোরে তো ইয়ে আছে অ্যাডিং অর্ডার থেকে একদম the next matter I believe they have preferred an appeal but it in respect of some another floor but Millard, since the facts Millard, can I come back tomorrow and say whether the facts are same or not because I have not been able to
let us call the next matter call করুন next matter
তাহলে ওটাকে
next matter call করুন yes what is the difference between the two different floors
different floors I am told
different suit also different suit also must be
Different suits.
the order is a copy paste or different orders
separate order by accepted judge
Order is copy. Order is copy paste. Do you know a copy paste? Possession was
ওই fourth floor-এ
It is
fourth floor-এ একটা কি ছিল
possession handing over date is
fourth floor-এ একটা কিছু ছিল
না ডেট অফ পজিশনটা কোথায় বলছে মানে ওই সাসপেক্ট ডকুমেন্টটা ডেটটা ডিফারেন্ট
fourth floor
maybe not detain your lordship and
no instead of detaining on the same facts again tomorrow better to resolve it
I was
11
yes
March 2023 handing over a possession.
again the same arguments will have to be advanced
so if it is same set of facts then I can come and satisfy myself and tell you
so we are just making it not today you can just it will be called on tomorrow then Very good.
Arbitration আছে
it's only for indicating to the court whether the facts are same or not
if the arguments are same virtually then we'll conclude that hearing of that also
I think there's only one difference which is the date of that's what I'm informed date of my lord the alleged possession alleged
surrender
yes that's surrender only that date is different
but are the other documents same I mean they are
I don't know
feel that so far as this floor is concerned it is this floor where they have filed a suit for my eviction I'm not sure
so then the arguments will be different
let me
so let us just make it not today Come back.
ওটাও তো করতে হবে।
26 এ কিছু দেখা লিখতে হবে না, just not to.
Lord, in that case, maybe request for next Tuesday.
Why only the facts you have to point out? If fresh
Tomorrow
arguments
I
are
am told
required.
is only hearing matter, and then Friday is.
Tomorrow is hearing matters only. So this is, oh, acha. So we'll keep this as a hearing matter under the
Yes,
hearing.
yes,
Keep it under hearing.
Yes, yes.
It is
We'll
hearing.
examine all facts and come tomorrow.
এটা একটা রেখে দিন। In view of hearing having commenced, comma, let the matter appear under the heading hearing tomorrow.
Grateful.
এটা hearing এ তাহলে না উপরে তো থাকবে না, তাহলে উইল মার্ক ইট এস পার্ট হার্ড, পার্ট হার্ড করে উপরে দিয়ে দেবো। জাস্ট লিখে রাখুন, ওটা অত লিখতে হবে না, হার্ড ইন পার্ট। This will appear on the top of the hearing list.
Great, and we'll come and
কালকে
indicate
পার্ট
it
হার্ড
one
হিসেবে
day.
দিয়ে দেবে। Yes.
Great.
Should we mark it as part heard,
Yes.
even without hearing it?
Yes,
Are you sure?
Same argument.
Are you sure? If tomorrow an order comes, a transfer order comes, then we are gone. That is the precise ground. That is the only ground.
Oh.
That's the only ground.
Yes, now I realize. Yes.
Why we could not hold court yesterday from 2 to 3:30.
Yes.
So
No, why?
we cannot have, I mean,
No,
assumptions.
but same legal arguments have been advanced, will be advanced in two cases. There
Yes,
cannot be, my lord.
if we find that it is not, something else is being done, we can cancel the
Then-
part tomorrow.
No, then we'll argue it out in 15 minutes. It will be the same.
Perfect. Thank you.
Then I was, my lord, also, my lord, told that you shouldn't appear before a particular tribunal. So I said, why shouldn't I? Tribunal is not covered. And he said, no, this is such a sensitive matter. I said, but if you are to actually on the ground of whatever ground we went on strike on, if you're to use it against in that tribunal, nobody would ever be able to appear in that tribunal.
Yes. Yes, Mr. Raut.
This matter, I am constrained to pray for at least 7 days adjournment in view of the fact. This is an appeal arising out of an order of injunction. An application of injunction is required to be filed in connection with instant appeal, annexing therewith all the relevant papers and documents. Otherwise, it will be difficult for me to go on with the hearing under Order 41. All the relevant papers and documents.
On the prayer of the appellant, let the matter stand adjourned till এই একটু সোজা করে দিন ক্যালেন্ডার, ক্যালেন্ডারটা বেঁকে গেছে, আমার দিকে করে দিন। Adjourned till when? Tell us.
Next week, subject to your lordship.
April 9, 2025. Next Wednesday.
My lord.
28, my lord, I am for the appellant, my lord.
Yes, please.
The matter was previously heard by the learned coordinate bench, my lord. There on 20th September 2024, my lord, direction was
You are
given-
appealing for all the respondents?
No, my lord. Respondent number 1.
One only. So
a direction.
how have you given the caption? Only plaintiff written here, no description of the parties in the stay application. What sort of a costed is this? You only write plaintiff in the High Court.
I apologize for that.
We hope the memorandum is better.
Plaintiff slash appellant will be there, my lord.
Yes, memorandum is all right.
It's okay, but
Memo
the
is
stay,
perfectly all right. No, appellant. What is this arising out of?
it is a rejection of an injunction order in a partition suit.
What is this applicant appellant? Plaintiff appellant it should be. You are the plaintiff.
Yes, my lord.
Rejection of injunction application, dismissal.
No, not dismissal.
Ad interim.
Yes, my lord, ad interim.
When is
No.
the next date in the trial court?
But I shall.
No.
It is a finally rejected.
No order of ad interim injunction can be passed, and since this court
Yes,
has
petition rejected, my lord.
there's no scope of hearing.
Order 39 rule 1 and 2 rejected application.
Oh, acha. That was the first order we were looking at.
19th April 2021 is the impugned order, my lord.
Rejected.
আরেকটা কপি করতে
After framing of issues was framed.
What is the matter? Move it.
This is related to the estate of the late Debendranath Manna, the father of the plaintiff and the defendant number 1. But now what has happened? I will kindly come at paragraph 5 of my stay application, my lord. What I've stated is that Debendranath Manna died
What is the suit filed for?
for partition of the estate, my lord.
Partition
For
suit.
partition. But in that, I have paid for an injunction because the defendant number 1 was raising construction therein, changing the nature and character of the suit property.
Why was it refused?
It was refused on the ground that misjoinder of parties. I have not included all the parties that are
Non-joiner, that is non-joiner, not misjoiner. Misjoiner, if you add extra parties. Non-joiner, if you omit necessary parties. Section 5 is there.
But section 5 was taken
Allowed.
up and disposed of. Allowed.
You asked for construction as well as transfer lien. Why was it misjoined? Let us see.
In your page 4 of the judgment. ma'am.
4.
Last paragraph.
Achha.
That's fine, ma'am, observation.
Improper way without bringing all the co-sharers on the basis of his self-assessed property description in the schedule of the plaintiff with sketch map.
Non-joiner of co-sharer.
Yes, ma'am. Now, my lord,
Who are the necessary parties who are not joined?
surprisingly, my lord, there is no non-joiner of parties, my lord. Why? I say that, but because the defendant number 1 has taken benefits of the deed. What I've stated is that there is an oral
Settlement.
settlement between the parties that the property of the Devendranath Manna is partitioned by them, and the land records is also showing the names. Land records is also showing the names. Now, what has happened? The Devendranath, the defendant number 1 has already taken benefit of it, taken gift deed from one of the brothers in his name by saying that the same has been represented by orally. It is already recorded in the gift deed. May I place the gift deed once?
I don't understand. Please repeat what you said.
May I place the case from the first? It would be better that. May I kindly come at paragraph 5 once of my stay application.
No, we have to look at your plaint case. In the plaint case, the same things must have been stated.
Yes, ma'am. Same thing as Mr.
Let us look at the plaint. Achha, very well. Paragraph 5.
Copied, that is
Very well. Paragraph 5.
Paragraph 5, it says that Devendranath Manna died on 27 January
Devendranath
1979.
Manna was the admitted
Father.
sole exclusive owner.
Yes, ma'am. Was the father and the owner of the estate that I am dealing with. Now, my lord,
Leaving these people, yes.
yes, Niranjan Manna, Indubhushan Manna, Lakshmi Manna,
Joint
Ananda
owners,
Manna
1/5.
Manna is the plaintiff and Saudananda Manna is the defendant number 1. Now, Indubhushan Manna died and leaving behind the defendant number 2 series. And my lord, Lokhi Manna died, defendant number 3 series.
According to the trial court, who is the omitted party?
And now they are saying that Devendranath Manna's father had more sons, seven. Devendranath Manna has 7 brothers.
They are not heirs of Devendranath.
No, but the trial court has held that they are also necessary.
Who was that finding? Why the property was, Devendranath was not the exclusive owner. He was also a co-sharer.
In the land records, it shows that it is in the name of the Devendranath.
Land records won't be sufficient. I mean, how did Devendranath derive title?
I have stated in paragraph 3, after the demise of late Kedarnath Manna, Arfusi, 8 sons mutually entered into an oral family arrangement. And
Unless there is a partition by meets and bounds, there cannot be.
I will kindly see that they have, the defendant number 1 has already taken benefits of this.
What benefit?
But they have, that is what I am trying to place. But page number 70, say page number 60 of the stay application.
So you want to say there was a mutual family arrangement?
Yes, ma'am.
Maybe there are several
50 to
judgments.
70 years, this has already been going on.
Several judgments, if
land
that is
records-
given effect to, then it has to be abided.
The land records is also showing the names that has been stated herein. I am not stating anything.
Saudananda Manna is the.
Saudananda Manna is the defendant number 1. He has taken the gift from Niranjan Manna. The
You are
name
for
that
defendant
I've-
number 1.
Yes, defendant number 1. Niranjan Manna, I have shown the name in paragraph 5.
So show us that relevant averment in this gift deed,
yes.
that there was this. He has taken a demarcated portion.
Firstly, at paragraph 62, page 62.
62, yes.
In the middle portion. আমার পিতা, থার্ড লাইন, আমার পিতা স্বর্গীয় দেবেন্দ্রনাথ মান্নার ওয়ারিশন সূত্রে 1 আনা অংশে 5 শতক সম্পত্তি মায়ের গৃহায়িত মালিক ও দখলিকার থাকা অবস্থায় তাহার 4টি পুত্র থেকে দিস নেমস আমাদের রাখিয়া পরলোক গ্রহণ করেন। তাহার পর আমরা পিতার ওয়ারিশন সূত্রপাতে হইয়া আমরা যে যাহার নামে রেকর্ডভুক্ত করিয়া সাবেক খতিয়ান হইতে this has been said that they are already enjoying the property and deciding. Now Niranjan Manna, what he has done, he has gifted his portion of the land to Sadananda Manna. That is at page number 65. The schedule of the gift deed.
So then you have also, I mean, entered into a mutual arrangement between yourselves.
Now what I am saying is that
If it's a family arrangement, then what is the question of a
now the estate
further
that-
partition?
Now the estate that has been left, they are in the estate, the defendant number 1 and the plaintiff stays. Now lot A and B has been allotted to them.
When did Devendranath Manna's father die?
Devendranath Manna's father died. That
Before 55?
That I have to take instruction because it is not rightly written, I think. It has been said at 27th January 1979.
Let us come to the trial court's order first.
9 January 1949.
9 January.
49, that then at that point of time, he is correct. There could have been a mutual arrangement,
That
yes.
is what I'm saying, my lord.
But
Now they have already taken fruits of it. Now defendant number 1 cannot approve it and reprove it at the same time. He has taken fruits and taken the portion of Niranjan Manna, that is one of the sons of late Devendranath Manna, taken his portion in his name. Now what
Taken fruit means only that he has, because taken fruits, they have not taken fruits of that original arrangement because that is also not even narrated there. They have only stated that your father, both of your father was the owner of the property.
Yes.
Only that.
Yes, now that is settled that his father is the owner of the property. Now he cannot take another stand.
In your plaint, you have stated about Kedarnath Manna's oral, that family arrangement.
Yes, paragraph number 3.
2 and 3.
2 and 3.
Page 19.
Let us see how the court proceeds. Mr. Bhattacharya, the learned trial judge records only partially what he has stated. Says that since he has admitted that Kedarnath, it originally belonged to Kedarnath Manna, and he had 7 legal heirs. Therefore, he had other 7 legal heirs along with
Excepting Devendranath Manna,
other.
there are 7.
Yes. So since he had those legal heirs, the proceeding on that premise, it is stated that it is observed that it's bad for non-joinder. But in the same breath, court did not take into consideration his averment that there was a mutual.
That's taken.
But that then, if that be so, the plaint has to be taken on its face. Then,
Yes.
why should it be said that it is bad for non-joinder? Because mutual arrangement was permissible before the Land Reforms Act, without meets and bounds. And there are several judgments also of the Supreme Court which say that mutual arrangement, family arrangement, if it is there, has to be honored inter se the parties at least.
But it's oral family arrangement.
Oral family arrangement also.
Family arrangement.
Yes, that also. If it is acted upon. And you have acted upon by taking this gift.
But I have
prior
purchased
fishing.
the share, only the share.
Not purchase, it is a gift deed.
Let us come to that gift deed.
Page
That
60.
gift deed as page 61. Page 62 you say, শতক মধ্যে আমার পিতা স্বর্গীয় দেবেন্দ্রনাথ মান্নার ওয়ারিশান সূত্রে প্রাপ্ত 1 আনা অংশে।
1 আনা অংশে 5 শতক।
আচ্ছা, so you say the share.
But even if it is unpartitioned, the parties can inter se transfer the shares.
Yes, yes.
Now my lord would kindly come at page
Whether that is
65.
acted upon, that is also an arguable question.
That point has been considered in the next page, page 5, second paragraph. My lord, the document relied on by the plaintiff that has been considered by the learned trial judge. My lord.
No, court only says on perusal of the information regarding arrest dag number such and such, it appears that there are a number of co-sharers in the suit dag and the nature of the suit property is Vastu, but plaintiff at his own perception separated the Vastu property of Devendranath Manna from other co-sharers. But if he has a plaint, let us see the plaint first. If he has made out a plaint case that there was a mutual arrangement, family arrangement, which was possible in 19.
The amendment made in the plaint, my lord.
They are entitled to prove it in the suit.
And my lord, the record of right is at page 30, which says that other co-sharer
Where is other co-sharer?
There is no other question.
But
each one has been. No, these are the names of the present parties.
yes, my lord, because Anando Manna, Pita Devendra, Bhuvan, Bhushan, Onadi, Profullo. Now,
only they are
the legal heirs
of Devendra.
The original owner, late Kedarnath Manna.
Not Devendra's heirs.
Not Devendra's heirs. Devendra's heirs are the Anando and Indu Bhushan.
Yes.
Then, my lord, Bhushan, if your lordship kindly compare,
Kartik Chandra, Kanailal, Jayanto,
kindly compare with page 19 and page 30. 19, paragraph 2, the legal heirs of Kedarnath Manna.
Krishna, Otul, Sridhar, Profullo, Nagendra, Kalipada, Bhushan.
Yes. Now, my lord, your lordship find Bhushan's son Kartik Chandra Manna, Bhushan's son Kanailal Manna, Onadi's son, and Profullo.
Now, apart from the underlined two, the rest are not parties to the present litigation.
No.
Then obviously they are not heirs of Devendra.
Not heirs of Devendra, and that is the reason, my lord, the suit is bad.
The Khutian number has to be seen.
Certainly not, my lord, the different Khatian number.
Khutian number should be.
One man, one Khatian.
No, if you see page this 15 also, 15, 16, it continues.
So,
dag number 38, these are the suit properties, 3481.
3481, my lord.
Yes, this is
Yes,
the Vastu.
yes, the names of all the heirs of the heirs of Kedarnath have been mentioned here. Not only the, otherwise, if your case was correct, the names of only Devendra's heirs would be appearing here. There are people beyond the array of parties in your suit. From your, this is your, you have produced this.
But I have only taken suit property, that is a 4 katas land.
You cannot call it out. Cannot.
Piecemeal partition.
And court is right in saying that you of your own has done this. The court precisely finds that plaintiff at his own perception separated the Vastu property of Devendra Manna from other co-sharers. Implead the other co-sharers. Implead the other, do that. As of today, it is, we will. Court is not inclined to run. Court has a point there. Prima facie, at least, I mean, we don't find anything to interfere. We'll dismiss the appeal, but Mr. Bhattacharya will say that nothing in this order shall prevent them from impleading the.
They are entitled.
And to pray for injunction afresh.
Let them, at their own wisdom, let them do it.
Their own wisdom has been already modified.
Tomorrow, let me take instructions on
This
the
observation, my lord.
Otherwise, that is the only ground on which otherwise this, you will argue, your counterpart will argue there that the injunction has been, this refusal has been affirmed up there.
They can file at any point of time.
My lord, only one thing may I suggest, my lord, very candidly, my lord, may I come back tomorrow and take instruction regarding this page 30?
Go back to the trial court tomorrow.
Lordship, they have the liberty to implement.
No.
But kindly, my lord, don't make this observation.
No.
Let that at their
No,
own.
if such an application is filed, it will be considered on its own. This has been rejected only on the ground of non-joiner. We'll make that clear. We'll dismiss it under order for 2011 itself and then make those observations. I could see. Present appeal is preferred against an order whereby the temporary injunction application filed by the plaintiff / appellant in connection with a partition suit has been dismissed on contest. Full stop, next para. Learned counsel for the appellant argues that the learned trial judge committed a legal error in refusing injunction on the ground that the suit is not maintainable for non-joinder of necessary parties on the premise that all the heirs of Kedarnath Manna, comma, the paternal grandfather of the parties, comma, have not been included in the suit. Full stop. It is submitted that although Kedarnath Manna was the original owner of the property, comma, as per the plain pleadings, comma, there was an oral mutual arrangement between the heirs of the said Kedarnath Manna and Kedarnath to the effect that the property of Kedarnath was separated and partitioned between the parties. Full stop. Next para, learned counsel for the appellant further argues that the said oral arrangement was given effect to by the defendant number 1 himself, comma, who is the primary contesting defendant, comma, by entering into a deed of gift whereby he accepted gift in respect of the share of one of the heirs of Debendranath Manna. Full stop. It is submitted that by doing so, comma, the defendant number 1 stroke respondent number 1 admitted the oral arrangement in effect. Full stop. Further, comma, it is argued that from the records of rights, comma, it is evident that the concerned suit properties have been recorded separately in the name of the different heirs of Kedarnath. Full stop. Next para, learned counsel. No, we cannot hear you. Okay. However, comma, we find from the impugned order that the learned trial judge was justified in observing that despite having admitted that Kedarnath Manna was the original owner of the property, comma, has of his own, comma, culled out, CULLED, a portion of the property, deeming the same to be demarcated without any basis for doing so. Full stop. In fact, comma, we find from the annexures to the stay applications, comma, which were also produced in the court below, comma, that the records of rights in respect of the suit property prima facie indicates the names of several heirs of the original owner Kedarnath Manna as owners of the said dags, comma, thereby raising a presumption that the property was never partitioned between the heirs of Kedarnath Manna. Full stop. The case of oral partition in the between the heirs of Kedarnath, comma, although pleaded in the plaint, is required to be proved on evidence. Full stop. However, comma, prima facie, we do not find any support of such case from the records of right. Full stop. Insofar as the deed of gift executed in favor of defendant number 1 stroke respondent number 1 is concerned, comma, we find there that by virtue of the said deed, comma, only a share of the of one of the shares of late Debendranath was transferred thereby. Full stop. Thus, comma, it cannot be said that by virtue of entering into the gift deed, comma, the defendant number 1 admitted the previous oral partition. Full stop. Next para. In such view of the matter, comma, since the learned trial judge has taken one of the plausible views in the facts of the case, comma, we are not inclined to interfere with the impugned order. Accordingly, FMAT 267 of 2022 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, comma, Can 1 of 2024 is also dismissed. Full stop. Next para, there will be no orders to cost. It is made clear that nothing in this order shall prevent the appellant from impleading the heirs, all the heirs of late Kedarnath Manna, and to renew his prayer for injunction thereafter. Full stop. If such a fresh prayer is made upon impleadment of the heirs of late Kedarnath Manna, comma, it will be open to the learned trial judge to adjudicate on the same afresh without being unnecessarily influenced by any of the observations made above, comma, keeping in view that the injunction application has been dismissed only on the ground of non-joinder of necessary parties. Thank you.
Presence be recorded, Malik.
Uh, it will be recorded. I mean, your name will be recorded. Order 14 rule 11, nothing. You retain the video clipping also for your client. Now it's easy. Yes.
Please, Your Lordship, I appear for the appellant. So in this matter,
Yes.
the appeal was basically against refusal for the ad interim order, ex parte ad interim order 3912. Actually, we came up before this appeal court. This appeal court initially directed that we serve the respondents. We attempted service, it came back. Thereafter, we were directed by the coordinate bench earlier to lodge the service.
Came back means
Lordship, it came back saying insufficient address. We alleged that they were trying to manage the postal receipts. The coordinate bench directed us to lodge the entire summons with the police officer. The officer in charge was given and the officer in charge delivered it to the respondents. And despite which the respondents didn't turn up. It's on that occasion when this division bench had granted us an interim order, saying that despite service, they were not.
Officer in charge filed a report.
Lordship. I'll take your lordship through the orders. So
Yes.
thereafter, the interim order was granted, recording that despite service through the police station, they were not appearing. Then it was extended for 6 months. Because Lordship, thereafter also we did not. We were directed to deposit the challan to the court so that the department would be giving it there through this proper service. That challan was also deposited. In September 2024, the interim order was again been extended for a period of 6 months, which has now expired on 26th March. Lordship, this is where we stand.
What is your case on merit?
Lordship, the case on merit is I have my plot of land. The photographs are on record, my lords. It's recorded that we have given photographs, videos were shown to the court that the respondents are my neighbors and they are doing construction in a
You have
manner.
produced title deeds.
Lordship,
In
I have
respect of the land?
produced my title deed. I've produced the photographs of the construction. I've also shown the videographs to the
Construction
previous
is being
coordinator.
made on your property.
Lordship, in a manner that it's not only obstructing the air and
No, they are
light of
constructing
my
on their property then.
No, Lordship. Their property, it has come on and it has in a
Encroached.
manner encroached my property.
So what is the injunction you sought?
That they should not do any further construction.
Why did it? Why was it refused by the court?
Lordships, only on the ground that there is no urgency involved. And that is the reason why this honorable court interfered.
The injunction application is still pending.
Lordship, it has not been formally admitted.
Appeal not formally admitted?
No, my lords. But the interim order has been there for over a year.
We find from the previous orders, passed by different coordinate benches that ad interim orders were passed upon consideration of the prima facie case of the appellant in connection with the injunction application bearing Can 1 of 2023. Full stop. Upon a perusal of the said orders, we deem that the appeal has been admitted to be heard on the questions formulated in the memorandum of appeal. Full stop. Next para. Can 1 of 2023 is now taken up for hearing. Full stop. It is rightly pointed out by learned counsel for the appellant that despite several endeavors, also to serve the respondents through the concerned police station, which was effectively served, the respondents chose not to appear at any stage of the appeal. Full stop. Next para. In such view of the matter, we have no other option but to take up the hearing of the injunction application ex parte. Full stop. Next para. We find from the records that sufficient prima facie case was made out by the appellant for injunction. The suit is for declaration and injunction. In his suit for declaration and injunction, full stop, the appellant has also produced title deeds in its favor as well as photographs to show that the respondents are prima facie attempting to encroach upon the property of the appellant and to make construction thereupon. Full stop. Accordingly, Can 1 of 2023 is allowed, thereby restraining the respondents and or their men and agents from changing the nature and character of the suit property in any manner and or making any further construction in respect of the suit property and/or in respect of the property situated in the southern side of the scheduled property in any manner whatsoever till disposal of the appeal. Full stop. The appellant shall put in requisites for service of notice of appeal on the respondents within a week from date. Full stop. The trial court. Have you got all the papers?
Lordship, because it's 3912 stage, Lordship will not call for the records, we'll make the informal paper.
Yeah, in view of the appeal arising out of an injunction order, comma, we dispense with calling for the trial court records at this stage. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records by incorporating all relevant documents within 6 weeks.
Lordship.
Within 6 weeks from date, and file the same in the department.
Lordship.
Liberty to mention the appeal for enlistment as and when the same is ready for hearing.
I'm so grateful.
Thanks. আগে যা অর্ডার ছিল সেটা কি অ্যাকচুয়ালি
Lordship, I appeal for the appellant defendant number 1.
Yes.
On the suit for declaration and injunction in respect of the suit property. Lord, there are 2 schedules of property.
It's a judgment of affirmance.
Lordship. First court I won, second court I lost.
So reversal.
Lordship.
Right. You're the plaintiff.
I am the defendant number 1. Suit for declaration that the co-scheduled property belongs to the plaintiff, and the co-scheduled property where I was gifted by my mother-in-law, I do not have any right, title, interest over that property.
Gift deed was challenged.
Gift deed was challenged.
You are brothers.
My lord, I am the daughter-in-law.
Acha.
Now, my lord, what?
Daughter-in-law of
The plaintiff.
Daughter-in-law of the plaintiff.
Plaintiff.
Mother means whose mother?
Shashuri.
Daughter-in-law of the plaintiff, or you are the sister-in-law of the plaintiff?
Daughter-in-law of the plaintiff. No, plaintiff. Thereafter, plaintiff expired. My lord, after her death, my lord, the legal heirs were substituted. My lord, bringing on record 3 daughters and 2 sons.
The gift deed was executed by the plaintiff
By
herself?
the plaintiff herself.
Acha,
And she challenged that the gift deed was executed by fraud, undue influence, and all those things, my lord. The trial court had held that, my lord, the deed was executed in accordance with law, whereas the second appellate court had held that she was a Pardashinin lady, so the deed could not be executed.
She signed in Bengali?
She LTI.
Read over and explained is there in the gift deed. The other formalities?
Everything was there. Everything, my lord, was tendered, my lord.
Reversed only on the ground of Pardashinin.
Pardashinin lady. Another aspect was also there, that since I did not have any cordial relation with the other members of the family, so that deed could not be executed.
That may be a consolation in will, but gift deed, I mean, it's a registered document.
Lordship.
Well, so show us the relevant portions of
Lordship. Kindly takes, my lord, the first trial court judgment first.
No, let us see the appeal court judgment.
Lordship. My lord, if your lordship takes page 7, internal page 7, my lord, your lordship takes page 6.
6.
Page 6 at the middle. Now, before I fall on the matters in controversy, it is pertinent to mention the following admitted facts. Suit property described co-schedule belongs to Panchanan Bhattacharya, the husband of the original plaintiff. He, by dint of a deed of gift such and such, he also executed a deed of sale in favor of the respondent number 2.
We'll continue tomorrow because there's only 1 minute left. This will take some time.
Lordship.
Although the matter is taken up for hearing, due to paucity of time, the matter is adjourned till April 7, 2025.
The difficulty is the second appeal was filed in the year 2016. Thereafter, my lord, it was filed through the State High Court Legal Service Authority.
Oh.
And my lord, learned advocate who had filed it, it was done perfectly. On the applications were filed, applications were moved, the second appeal could not be admitted. There were defect in the second appeal, so the defect I have cured. Thereafter, now it has come up for admission.
Unfortunately. Let us see. The luck favors us on the next one.